Section 18 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Florence Short. Debs versus United States, 249 U.S. 211. Decided March 10, 1919. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Holmes delivered the opinion of the court. This is an indictment under the Espionage Act of June 15, 1917. As amended by the Act of May 16, 1918. It has been cut down to 2 counts, originally the third and fourth. The former of these alleges that on or about June 16, 1918, at Canton, Ohio, the defendant caused and incited and attempted to cause and incite insubordination, disloyalty, mutiny, and refusal of duty in the military and naval forces of the United States, and with intent so to do, delivered to an assembly of people a public speech set forth. The fourth count alleges that he obstructed and attempted to obstruct the recruiting and enlistment service of the United States, and to that end and with that intent delivered the same speech again set forth. There was a demurrer to the indictment on the ground that the statute is unconstitutional as interfering with free speech, contrary to the First Amendment, and to the several counts as insufficiently stating the supposed offense. This was overruled, subject to exception. There were other exceptions to the admission of evidence with which we shall deal. The defendant was found guilty and was sentenced to 10 years' imprisonment. On each of the 2 counts, the punishment to run concurrently on both. The main theme of the speech was socialism, its growth, and a prophecy of its ultimate success. With that we have nothing to do, but if a part or the manifest intent of the more general utterances was to encourage those present to obstruct the recruiting service, and if in passages such encouragement was directly given, the immunity of the general theme may not be enough to protect the speech. The speaker began by saying that he had just returned from a visit to the workhouse in the neighborhood where 3 of their most loyal comrades were paying the penalty for their devotion to the working class, these being Wagenknecht, Berger, and Rothenberg, who had been convicted of aiding and abetting another in failing to register for the draft. Rothenberg versus United States, 245 U.S. 480. He said that he had to be prudent and might not be able to say all that he thought, thus intimating to his hearers that they might infer that he meant more. But he did say that those persons were paying the penalty for standing erect and for seeking to pave the way to better conditions for all mankind. Later he added further eulogies and said that he was proud of them. He then expressed opposition to Prussian militarism in a way that naturally might have been thought to be intended to include the mode of proceeding in the United States. After considerable discourse that it is unnecessary to follow, he took up the case of Kate Richards O'Hare, convicted of obstructing the enlistment service, praised her for her loyalty to socialism and otherwise, and said that she was convicted on false testimony under a ruling that would seem incredible to him if he had not had some experience with a federal court. We mention this passage simply for its connection with evidence put in at the trial. The defendant spoke of other cases and then, after dealing with Russia, said that the master class has always declared the war and the subject class has always fought the battles, that the subject class has had nothing to gain and all to lose, including their lives, that the working class, who furnish the corpses, have never yet had a voice in declaring war and never yet had a voice in declaring peace. Quote, "You have your lives to lose. You certainly ought to have the right to declare war if you consider a war necessary." End of quote. The defendant next mentioned Rose Pastor Stokes, convicted of attempting to cause insubordination and refusal of duty in the military forces of the United States and obstructing the recruiting service. He said that she went out to render her service to the cause in this day of crises, and they sent her to the penitentiary for 10 years, that she had said no more than the speaker had said that afternoon, that if she was guilty, so was he, and that he would not be cowardly enough to plead his innocence, but that her message that opened the eyes of the people must be suppressed, and so after a mock trial before a packed jury and a corporation tool on the bench, she was sent to the penitentiary for 10 years. There followed personal experiences and illustrations of the growth of socialism, a glorification of minorities, and a prophecy of the success of the international socialist crusade, with the interjection that, quote, "You need to know that you are fit for something better than slavery and cannon fodder." End of quote. The rest of the discourse had only the indirect, though not necessarily ineffective, bearing on the offenses alleged that is to be found in the usual contrasts between capitalists and laboring men. Sneers at the advice to cultivate war gardens, attribution to plutocrats of the high price of coal, etc., with the implication running through it all that the working men are not concerned in the war, and a final exhortation, quote, "Don't worry about the charge of treason to your masters, but be concerned about the treason that involves yourselves." End of quote. The defendant addressed the jury himself, and while contending that his speech did not warrant the charges, said, quote, "I have been accused of obstructing war. I admit it. Gentlemen, I abhor war. I would oppose the war if I stood alone." End of quote. The statement was not necessary to warrant the jury in finding that one purpose of the speech, whether incidental or not does not matter, was to oppose not only war in general, but this war, and that the opposition was so expressed that its natural and intended effect would be to obstruct recruiting. If that was intended, and if, in all circumstances, that would be its probable effect, it would not be protected by reason of its being part of a general program and expressions of a general and conscientious belief. The chief defenses upon which the defendant seemed willing to rely were the denial that we have dealt with, and that based upon the First Amendment to the Constitution, disposed of in Schenck v. United States, 249 U.S. 47. His counsel questioned the sufficiency of the indictment. It is sufficient in form. Frawerk v. United States, 249 U.S. 204. The most important question that remains is raised by the admission in evidence of the record of the conviction of Ruthenberg, Wagenknecht and Berger, Rose Pastor Stokes, and Kate Richards O'Hare. The defendant purported to understand the grounds on which these persons were imprisoned, and it was proper to show what those grounds were in order to show what he was talking about, to explain the true import of his expression of sympathy, and to throw light on the intent of the address, so far as the present matter is concerned. There was introduced also an anti-war proclamation and program adopted at St. Louis in April 1917, coupled with testimony that about an hour before his speech the defendant had stated that he approved of that platform in spirit and in substance. The defendant referred to it in his address to the jury, seemingly with satisfaction and willingness that it should be considered in evidence, but his counsel objected and has argued against its admissibility at some length. This document contained the usual suggestion that capitalism was the cause of the war, and that our entrance into it, quote, was instigated by the predatory capitalists in the United States. End of quote. It alleged that the war of the United States against Germany could not, quote, be justified even on the plea that it is a war in defense of American rights or American honor, end of quote. It said, quote, we brand the declaration of war by our governments as a crime against the people of the United States and against the nations of the world. In all modern history, there has been no war more unjustifiable than the war in which we are about to engage. End of quote. Its first recommendation was, quote, continuous, active, and public opposition to the war through demonstrations, mass petitions, and all other means within our power. End of quote. Evidence that the defendant accepted this view and this declaration of his duties at the time that he made his speech is evidence that if in that speech he used the words tending to obstruct the recruiting service, he meant that they should have that effect. The principle is too well established and too manifestly good sense to need citation of the books. We should add that the jury were most carefully instructed that they could not find the defendant guilty for advocacy of any of his opinions unless the words used had as their natural tendency and reasonably probable effect to obstruct the recruiting service, etc., and unless the defendant had the specific intent to do so in his mind. Without going into further particulars, we are of the opinion that the verdict on the fourth count for obstructing and attempting to obstruct the recruiting service of the United States must be sustained. Therefore, it is less important to consider whether that upon the third count, for causing and attempting to cause insubordination, etc., in the military and naval forces, is equally impregnable. The jury were instructed that for the purposes of the statute, the persons designated by the Act of May 18, 1917, C. 1540, Stat. 76, registered and enrolled under it, and thus subject to be called into the active service, were a part of the military forces of the United States. The government presents a strong argument from the history of the statutes that the instruction was correct and in accordance with established legislative usage. We see no sufficient reason for differing from the conclusion, but think it unnecessary to discuss the question in detail. Judgment affirmed. End of section 18.
Section 19 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. West Virginia State Board of Education vs. Barnette, 319 U.S. 624, decided June 14, 1943. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Jackson delivered the opinion of the court. Following the decision of this court on June 3, 1940, in Minersville School District v. Gobatis, 310 U.S. 586, the West Virginia legislature amended its statutes to require all schools therein to conduct courses of instruction in history, civics, and in the constitutions of the United States and of the state, quote, for the purpose of teaching, fostering, and perpetuating the ideals, principles, and spirit of Americanism, and increasing the knowledge of the organization and machinery of the government. End quote. Appellant, Board of Education was directed, with advice of the State Superintendent of Schools, to, quote, prescribe the courses of study covering these subjects, end quote, for public schools. The act made it a duty of private, parochial, and denominational schools to prescribe courses of study, quote, similar to those required for the public schools, end quote. Footnote. Section 134, West Virginia Code, 1941, Supplement. Quote, in all public, private, parochial, and denominational schools located within this state there shall be given regular courses of instruction in history of the United States, in civics, and in the constitutions of the United States and of the state of West Virginia, for the purpose of teaching, fostering, and perpetuating the ideals, principles, and spirit of Americanism, and increasing the knowledge of the organization and machinery of the government of the United States and of the state of West Virginia. The State Board of Education shall, with the advice of the State Superintendent of Schools, prescribe the courses of study covering these subjects for the public elementary and grammar schools, public high schools, and state normal schools. It shall be the duty of the officials or boards having authority over the respective private, parochial, and denominational schools to prescribe courses of study for the schools under their control and supervision similar to those required for the public schools. End quote. End footnote. The Board of Education on January 9, 1942, adopted a resolution containing recitals taken largely from the court's Gobatisk opinion, and ordering that the salute to the flag become, quote, a regular part of the program of activities in the public schools, end quote, that all teachers and pupils, quote, shall be required to participate in the salute honoring the nation represented by the flag, provided, however, that refusal to salute the flag be regarded as an act of insubordination and shall be dealt with accordingly. End quote. The resolution originally required the commonly accepted salute to the flag, which it defined. Objections to the salute as being too much like Hitler's were raised by the Parent and Teachers Association, the Boy and Girl Scouts, the Red Cross, and the Federation of Women's Clubs. Footnote. The national headquarters of the United States Flag Association takes the position that the extension of the right arm in this salute to the flag is not the Nazi fascist salute. Quote, although quite similar to it, in the pledge to the flag the right arm is extended and raised palm upward, whereas the Nazis extend the arm practically straight to the front, the finger-tips being about even with the eyes, palm downward, and the fascists do the same, except they raise the arm slightly higher. End of quote. James A. Moss, The Flag of the United States, Its History and Symbolism, 1914, page 108. End of footnote. Some modifications appears to have been made in deference to these objections, but no concession was made to Jehovah's Witnesses. Footnote. They have offered, in lieu of participating in the flag salute ceremony, quote, periodically and publicly, end quote, to give the following pledge, quote, I have pledged my unqualified allegiance and devotion to Jehovah, the Almighty God, and to his kingdom, for which Jesus commands all Christians to pray. I respect the flag of the United States and acknowledge it as a symbol of freedom and justice to all. I pledge allegiance and obedience to all the laws of the United States that are consistent with God's law, as set forth in the Bible. End quote. End of footnote. What is now required is the stiff arm salute, the saluter to keep the right hand raised with palm turned up, while the following is repeated. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. Failure to conform is insubordination, dealt with by expulsion. Readmission is denied by statute until compliance. Meanwhile, the expelled child is unlawfully absent, and may be proceeded against as a delinquent. His parents or guardians are liable to prosecution, and, if convicted, are subject to fine not exceeding $50 and jail term not exceeding 30 days. Appellees, citizens of the United States and of West Virginia, brought suit in the United States District Court for themselves and others similarly situated, asking its injunction to restrain enforcement of these laws and regulations against Jehovah's Witnesses. The witnesses are an unincorporated body teaching that the obligation imposed by law of God is superior to that of laws enacted by temporal governments. Their religious beliefs include a literal version of Exodus chapter 20, verses 4 and 5, which says, Thou shalt not make unto thee any graven image, nor any likeness of anything that is in heaven above, or that is in the earth beneath, or that is in the water under the earth. Thou shalt not bow down thyself to them, nor serve them. They consider that the flag is an image within this command. For this reason, they refuse to salute it. Children of this faith have been expelled from school and are threatened with exclusion for no other cause. Officials threaten to send them to reformatories maintained for criminally inclined juveniles. Parents of such children have been prosecuted and are threatened with prosecutions for causing delinquency. The Board of Education moved to dismiss the complaint, setting forth these facts and alleging that the law and regulations are an unconstitutional denial of religious freedom and of freedom of speech, and are invalid under the due process and equal protection clauses of the 14th Amendment of the Federal Constitution. The cause was submitted to the pleadings of a district court of 3 judges. It restrained enforcement as to the plaintiffs and those of that class. The Board of Education brought the case here by direct appeal. This case calls upon us to consider a precedent decision, as the court throughout its history often has been required to do. Before returning to the Gobatis case, however, it is desirable to notice certain characteristics by which this controversy is distinguished. The freedom asserted by these appellees does not bring them into collision with rights asserted by any other individual. It is such conflicts which most frequently require intervention of the state to determine where the rights of one end and those of another begin. But the refusal of these persons to participate in the ceremony does not interfere with or deny rights of others to do so. Nor is there any question in this case that their behavior is peaceable and orderly. The sole conflict is between authority and rights of the individual. The state asserts power to condition access to public education on making a prescribed sign and profession, and at the same time to coerce attendance by punishing both parent and child. The latter stand on a right of self-determination in matters that touch individual opinion and personal attitude. As the Chief Justice said in dissent in the Gobatis case, the state may, require teaching by instruction and study of all in our history and in the structure and organization of our government, including the guarantees of civil liberty which tend to inspire patriotism and love of country. Here, however, we are dealing with a compulsion of students to declare a belief. They are not merely made acquainted with the flag salute, so that they may be informed as to what it is or even what it means. The issue here is whether this slow and easily neglected route to arouse loyalties constitutionally may be short-cut by substituting a compulsory salute and slogan. This issue is not prejudiced by the court's previous holding, that where a state without compelling attendance extends college facilities to pupils who voluntarily enroll, it may prescribe military training as part of the course without offense to the Constitution. It was held that those who take advantage of its opportunity may not, on ground of conscience, refuse compliance with such conditions. Hamilton v. Regents. In the present case, attendance is not optional. That case is also to be distinguished from the present one, because independently of college privileges or requirements, the state has power to raise militia and impose the duties of service therein upon its citizens. There is no doubt that, in connection with the pledges, the flag salute is a form of utterance. Symbolism is a primitive but effective way of communicating ideas. The use of an emblem or flag to symbolize some system, idea, institution, or personality is a shortcut from mind to mind. Causes and nations, political parties, lodges, and ecclesiastical groups seek to knit the loyalty of their followers to a flag or banner, a color or design. The state announces rank, function, and authority through crowns and maces, uniforms, and black robes. The church speaks through the cross, the crucifix, the altar and shrine, and clerical raiment. Symbols of state often convey political ideas, just as religious symbols come to convey theological ones. Associated with many of these symbols are appropriate gestures of acceptance or respect. A salute, a bowed or bared head, a bended knee. A person gets from a symbol the meaning he puts into it, and what is one man's comfort and inspiration is another's jest and scorn. Over a decade ago, Chief Justice Hughes led this court in holding that the display of a red flag as a symbol of opposition by peaceful and legal means to organized government was protected by the free speech guarantees of the Constitution. Stromberg v. California. Here it is the state that employs a flag as a symbol of adherence to government, as presently organized. It requires the individual to communicate by word and sign his acceptance of the political ideas it thus bespeaks. Objection to this form of communication, when coerced, is an old one, well known to the framers of the Bill of Rights. Footnote: Early Christians were frequently persecuted for their refusal to participate in ceremonies before the statue of the emperor or other symbol of imperial authority. The story of William Tell's sentence to shoot an apple off his son's head for refusal to salute a bailiff's hat is an ancient one. The Quakers, William Penn included, suffered punishment rather than uncover their heads in deference to any civil authority. End footnote. It is also to be noted that the compulsory flag salute and pledge requires affirmation of a belief and an attitude of mind. It is not clear whether the regulation contemplates that pupils forego any contrary convictions of their own and become unwilling converts to the prescribed ceremony, or whether it will be acceptable if they simulate assent by words without belief, or by a gesture barren of meaning. It is now commonplace that censorship or suppression of expression of opinion is tolerated by our Constitution only when the expression presents a clear and present danger of action of a kind the state is empowered to prevent and punish. It would seem that involuntary affirmation could be commanded only on even more immediate and urgent grounds than silence. But here the power of compulsion is invoked without any allegation that remaining passive during a flag salute ritual creates a clear and present danger that would justify an effort even to muffle expression. To sustain the compulsory flag salute, we are required to say that a Bill of Rights which guards the individual's right to speak his own mind, left it open to public authorities to compel him to utter what is not in his mind. Whether the First Amendment to the Constitution will permit officials to order observance of ritual of this nature does not depend upon whether as a voluntary exercise we would think it to be good, bad, or merely innocuous. Any credo of nationalism is likely to include what some disapprove of or omit what others think essential, and to give off different overtones as it takes on different accents or interpretations. If official power exists to coerce acceptance of any patriotic creed, what it shall contain cannot be decided by courts, but must be largely discretionary with the ordaining authority, whose power to prescribe would no doubt include power to amend. Hence, validity of the asserted power to force an American citizen publicly to profess any statement of belief or engage in any ceremony of assent to one presents questions of power that must be considered independently of any idea we may have as to the utility of the ceremony in question. Nor does the issue, as we see it, turn on one's possession of particular religious views, or the sincerity with which they are held. While religion supplies appellee's motive for enduring the discomforts of making the issue in this case, many citizens who do not share these religious views hold such a compulsory right to infringe constitutional liberty of the individual. Footnote: Cushman Constitutional Law in 1939, 1940, 35 American Political Science Review, pages 250 and 271 observes, quote, all of the eloquence by which the majority extol the ceremony of flag saluting as a free expression of patriotism turned sour, when used to describe the brutal compulsion which requires a sensitive and conscientious child to stultify himself in public. End quote. End footnote. It is not necessary to inquire whether nonconformist beliefs will exempt from the duty to salute, unless we first find power to make the salute a legal duty. The Gobetist decision, however, assumed, as did the argument in that case and in this, that power exists in the state to impose the flag salute discipline upon school children in general. The court only examined and rejected a claim based on religious beliefs of immunity from an unquestioned general rule. The question which underlies the flag salute controversy is whether such a ceremony so touching matters of opinion and political attitude may be imposed upon the individual by official authority under powers committed to any political organization under our Constitution. We examine rather than assume existence of this power, and against this broader definition of issues in this case, re-examine specific grounds assigned for the Gobetist decision. 1. It was said that the flag salute controversy confronted the court with, quote, the problem which Lincoln cast in memorable dilemma. Quote, must a government of necessity be too strong for the liberties of its people or too weak to maintain its own existence? End quote. And that the answer must be in favor of strength. Minersville School District v. Gobetist, Supra at 596. End quote. We think these issues may be examined free of pressure or restraint growing out of such considerations. It may be doubted whether Mr. Lincoln would have thought that the strength of government to maintain itself would be impressively vindicated by our confirming power of the state to expel a handful of children from school, Such oversimplification, so handy in political debate, often lacks the precision necessary to postulates of judicial reasoning. If validly applied to this problem, the utterance cited would resolve every issue of power in favor of those in authority, and would require us to override every liberty thought to weaken or delay execution of their policies. Government of limited power need not be anemic government. Assurance that rights are secure tends to diminish fear and jealousy of strong government, and by making us feel safe to live under it, makes for its better support. Without promise of a limiting Bill of Rights, it is doubtful if our Constitution could have mustered enough strength to enable its ratification. To enforce those rights today is not to choose weak government over strong government. It is only to adhere as a means of strength to individual freedom of mind in preference to officially disciplined uniformity, for which history indicates a disappointing and disastrous end. The subject now before us exemplifies this principle. Free public education, if faithful to the ideal of secular instruction and political neutrality, will not be partisan or enemy of any class, creed, party, or faction. If it is to impose any ideological discipline, however, each party or denomination must seek to control, or, failing that, to weaken the influence of the educational system. Observance of the limitations of the Constitution will not weaken government in the field appropriate for its exercise. 2. It was also considered in the Gobatis case that functions of educational officers in states, counties, and school districts were such that to interfere with their authority would in effect make us the school board for the country. The 14th Amendment, as now applied to the states, protects the citizens against the state itself and all of its creatures, boards of education not excepted. These have, of course, important, delicate, and highly discretionary functions, but none that they may not perform within the limits of the Bill of Rights. That they are educating the young for citizenship is reason for scrupulous protection of constitutional freedoms of the individual, if we are not to strangle the free mind at its source and teach youth to discount important principles of our government as mere platitudes. Such boards are numerous, and their territorial jurisdiction often small. But small and local authority may feel less sense of responsibility to the Constitution, and agencies of publicity may be less vigilant in calling it to account. The action of Congress in making flag observance voluntary and respecting the conscience of the objector in a matter so vital as raising the army contrasts sharply with these local regulations in matters relatively trivial to the welfare of the nation. There are village tyrants as well as village Hampdens, but none who acts under color of law is beyond reach of the Constitution. 3. The Gobatis opinion reasoned that this is a field where courts possess no marked and certainly no controlling competence, that it is committed to the legislatures as well as the courts to guard cherished liberties, and that it is constitutionally appropriate to, quote, fight out the wise use of legislative authority in the forum of public opinion and before legislative assemblies, rather than to transfer such a contest to the judicial arena, end quote. Since all the effective means of inducing political changes are left free, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, A free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. In weighing arguments of the parties, it is important to distinguish between the due process clause of the 14th Amendment as an instrument for transmitting the principles of the First Amendment and those cases in which it is applied for its own sake. The test of legislation which collides with the 14th Amendment because it also collides with the principles of the first is much more definite than the test when only the 14th is involved. Much of the vagueness of the due process clause disappears when the specific prohibitions of the first become its standard. The right of a state to regulate, for example, a public utility may well include, so far as the due process test is concerned, power to impose all the restrictions which a legislature may have a rational basis for adopting. But freedoms of speech and of press, of assembly and of worship may not be infringed on such slender grounds. They are susceptible of restriction only to prevent grave and immediate danger to interests which the state may lawfully protect. It is important to note that, while it is the 14th Amendment which bears directly upon the state, it is the more specific limiting principles of the First Amendment that finally govern this case. Nor does our duty to apply the Bill of Rights to assertions of official authority depend upon our possession of marked competence in the field where the invasion of rights occurs. True, the task of translating the majestic generalities of the Bill of Rights, conceived as part of the pattern of liberal government in the 18th century, into concrete restraints on officials dealing with the problems of the 20th century, is one to disturb self-confidence. These principles grew in soil which also produced a philosophy that the individual was the center of society, that his liberty was attainable through mere absence of governmental restraints, and that government should be entrusted with few controls and only the mildest supervision over men's affairs. We must transplant these rights to the soil in which the laissez-faire concept or principle of non-interference has withered, at least as to economic affairs, and social advancements are increasingly sought through closer integration of society and through expanded and strengthened governmental controls. These changed conditions often deprive precedents of reliability and cast us more than we would choose upon our own judgment. But we act in these matters not by authority of our competence, but by force of our commissions. We cannot, because of modest estimates of our competence in such specialties as public education, withhold the judgment that history authenticates as the function of this court when liberty is infringed. 4. Lastly, this is the very heart of the Gobatis opinion. It reasons that, quote, national unity is the basis of national security, end quote, that the authorities have, quote, the right to select appropriate means for its attainment, end quote, and hence reaches the conclusion that such compulsory measures toward national unity are constitutional. Upon the verity of this assumption depends our answer in this case. National unity as an end which officials may foster by persuasion and example is not in question. The problem is whether, under our Constitution, compulsion as here employed is a permissible means for its achievement. Struggles to coerce uniformity of sentiment in support of some end thought essential to their time and country have been waged by many good as well as by evil men. Nationalism is a relatively recent phenomenon, but at other times and places The ends have been racial or territorial security, support of a dynasty or regime, and particular plans for saving souls. As first and moderate methods to attain unity have failed, those bent on its accomplishment must resort to an ever-increasing severity. As governmental pressure toward unity becomes greater, so strife becomes more bitter as to whose unity it shall be. Probably no deeper division of our people could proceed from any provocation than from finding it necessary to choose what doctrine and whose program public educational officials should compel youth to unite in embracing. Ultimate futility of such attempts to compel coherence is the lesson of every such effort, from the Roman drive to stamp out Christianity as a disturber of its pagan unity, the Inquisition as a means to religious and dynastic unity, the Siberian exiles as a means to Russian unity, down to the fast failing efforts of our present totalitarian enemies. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. It seems trite but necessary to say that the First Amendment of our Constitution was designed to avoid these ends by avoiding these beginnings. There is no mysticism in the American concept of the state or of its nature or origin of its authority. We have set up government by consent of the governed, and the Bill of Rights denies those in power any legal opportunity to coerce that consent. Authority here is to be controlled by public opinion, not public opinion by authority. The case is made difficult not because the principles of its decision are obscure, but because the flag involved is our own. Nevertheless, we apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. To believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. We can have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. When they are so harmless to others or to the state as those we deal with here, the price is not too great. But freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or any other matter of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. We think the action of the local authorities in compelling the flag salute and pledge transcends constitutional limitations on their power, and invades the sphere of intellect and spirit, which it is the purpose of the First Amendment of our Constitution to reserve from all official control. The decision of this court in Minersville School District v. Gobatis and the holdings of those few per curiam decisions which preceded and foreshadowed it are overruled, and the judgment enjoining enforcement of the West Virginia regulation is affirmed. End of section 19.
Section 20 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Gray v. Sanders, 372 U.S. 368. Decided March 18, 1963. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Douglas delivered the opinion of the court. The suit was instituted by appellee who was qualified to vote in primary and general elections in Fulton County, Georgia, to restrain appellants from using Georgia's county unit system as a basis for counting votes in a Democratic primary for the nomination of a United States Senator and statewide officers, and for declaratory relief. Appellants are the chairman and secretary of the Georgia State Democratic Executive Committee and the Secretary of State of Georgia. Appellee alleges that the use of the county unit system in counting, tabulating, consolidating, and certifying votes cast in primary elections for statewide offices violates the Equal Protection Clause and the Due Process Clause of the 14th Amendment and the 17th Amendment. As the constitutionality of a state statute was involved and the question was a substantial one, a three-judge court was properly convened. Appellants moved to dismiss, and they also filed an answer denying that the county unit system was unconstitutional and alleging that it was designed, quote, to achieve a reasonable balance as between urban and rural electoral power, end quote. Under Georgia law, each county is given a specified number of representatives in the lower house of the General Assembly. This county unit system at the time this suit was filed was employed as follows in statewide primaries. 1. Candidates for nominations who received the highest number of popular votes in a county were considered to have carried the county and to be entitled to 2 votes for each representative to which the county is entitled in the lower house of the General Assembly. 2. The majority of the county unit vote nominated a United States Senator and Governor. The plurality of the county vote nominated the others. Appellee asserted that the total population of Georgia in 1960 was 3,943,116, that the population of Fulton County, where he resides, was 556,326, that the residents of Fulton County comprised 14.11% of Georgia's total population, but that under the county unit system, the 6-unit votes of Fulton County constituted 1.46% of the total of 410 unit votes, or 1/10 of Fulton County's percentage of statewide population. The complaint further alleged that Eccles County, the least populous county in Georgia, had a population in 1960 of 1,876, or 0.05% of the state's population, but the unit vote of Eccles County was 0.48% of the total unit vote of all counties in Georgia, or 10 times Eccles County's statewide percentage of population. 1 unit vote in Eccles County represented 938 residents, whereas 1 unit vote in Fulton County represented 92,721 residents. Thus, 1 resident in Eccles County had an influence in the nomination of candidates equivalent to 99 residents of Fulton County. On the same day as the hearing in the district court, Georgia amended the statutes challenged in the complaint. This amendment modified the county unit system by allocating units to counties in accordance with a, quote, bracket system, end quote, instead of doubling the number of representatives of each county in the lower house of the Georgia Assembly. Counties with from 0 to 15,000 people were allotted 2 units. An additional 1 unit was allotted for the next 5,000 persons, an additional unit for the next 10,000 persons, another unit for each of the next two brackets of 15,000 persons, and thereafter 2 more units for each increase of 30,000 persons. Under the amended Act, all candidates for statewide office, not merely for senator and governor as under the earlier Act, are required to receive a majority of the county unit votes to be entitled to nomination in the first primary. In addition, in order to be nominated in the first primary, a candidate has to receive a majority of the popular votes unless there are only 2 candidates for the nomination, and each receives an equal number of unit votes, in which event the candidate with the popular majority wins. If no candidate receives both a majority of the unit votes and a majority of the popular votes, a second runoff primary is required between the candidate receiving the highest number of unit votes and the candidate receiving the highest number of popular votes. In the second primary, the candidate receiving the highest number of unit votes is to prevail. But again, if there is a tie in unit votes, the candidate with a popular majority wins. Paty was allowed to amend his complaint so as to challenge the amended Act. The district court held that the amended Act had some of the vices of the prior Act. It stated that under the amended Act, quote, "the vote of each citizen counts for less and less as the population of the county of his residence increases." End of quote. It went on to say, quote, "there are 97 2-unit counties totaling 194 unit votes, and 22 counties totaling 66 unit votes. Altogether 260 unit votes, within 14 of a majority, but no county in the above has as much as 20,000 population. The remaining 40 counties range in population from 20,481 to 556,326, but they control altogether only 287 county unit votes. Combination of the units from the counties having the smallest population gives counties having population of 1/3 of the total in the state a clear majority of county units." End of quote. The district court held that as a result of Berger versus Carr, it had jurisdiction, that a justiciable case was stated, that appellee had standing, and that the Democratic primary in Georgia is, quote, "state," end of quote, action within the meaning of the 14th Amendment. It held that the county unit system as applied violates the Equal Protection Clause, and it issued an injunction not against conducting any party primary election under the county unit system, but against conducting such an election under a county unit system that does not meet the requirements specified by the court. In other words, the district court did not proceed on the basis that in a statewide election every qualified person was entitled to 1 vote and that all weighted voting was outlawed. Rather, it allowed a county unit system to be used in weighting the votes if the system showed no greater disparity against a county than exists against any state in the conduct of national elections. Thereafter, the Democratic Committee voted to hold the 1962 primary election for the statewide offices mentioned on a popular vote basis. We noted probable jurisdiction. We agree with the district court that the action of this party in the conduct of its primary constitutes state action within the meaning of the 14th Amendment. Judge Sibley, writing for the court in Chapman versus King, showed with meticulous detail the manner in which Georgia regulates the conduct of party primaries, and he concluded, quote, "We think these provisions show that the state, through the managers it requires, collaborates in the conduct of the primary and puts its power behind the rules of the party. It adopts the primary as a part of the public election machinery. The exclusions of voters made by the party by the primary rules become exclusions enforced by the state." End of quote. We agreed with that result and conclude that state regulation of this preliminary phase of the election process makes it state action. We also agree that appellee, like any person whose right to vote is impaired, has standing to sue. Moreover, we think the case is not moot by reason of the fact that the Democratic Committee voted to hold the 1962 primary on a popular vote basis. But for the injunction issued below, the 1962 Act remains in force, and if the complaint were dismissed, it would govern future elections. In addition, the voluntary abandonment of a practice does not relieve a court of adjudicating its legality, particularly where the practice is deeply rooted and long-standing. For if the case were dismissed as moot, appellants would be, quote, free to return to their old ways, end quote. On the merits, we take a different view of the nature of the problem than did the district court. The case, unlike Barger versus Carr, supra, does not involve a question of the degree to which the Equal Protection Clause of the 14th Amendment limits the authority of a state legislature in designing the geographical districts from which representatives are chosen, either for the state legislature or for the federal House of Representatives. Nor does it include the related problems of Gomillion versus Lightfoot, where, quote, gerrymandering, end quote, was used to exclude a minority group from participation in municipal affairs. Nor does it present the question, inherent in the bicameral form of our federal government, whether a state may have one house chosen without regard to population. The district court, however, analogized Georgia's use of the county unit system in determining the results of a statewide election to phases of our federal system. It pointed out that under the Electoral College, required by Article 2, Section 1 of the Constitution, and the 12th Amendment in the election of the President, voting strength, quote, is not in exact proportion to population. Recognizing that the Electoral College was set up as a compromise to enable the formation of the Union among the several sovereign states, it still could hardly be said that such a system used in a state among its counties, assuming rationality and absence of arbitrariness in end result, could be termed invidious. End quote. Accordingly, the district court, as already noted, held that use of the county unit system in counting the votes in a statewide election was permissible if, quote, the disparity against any county is not in excess of the disparity that exists against any state in the most recent electoral college allocation, end quote. Moreover, the district court held that use of the county unit system in counting the votes in a statewide election was permissible, quote, if the disparity against any county is not in excess of the disparity that exists under the equal proportions formula for representation of the several states in the Congress, end quote. The assumption implicit in these conclusions is that since equality is not inherent in the Electoral College, and since precise equality among blocks of votes in one state or in the several states when it comes to the election of members of the House of Representatives is never possible, precise equality is not necessary in statewide elections. We think the analogies to the Electoral College, to districting and redistricting, and to other phases of the problems of representation in state or federal legislatures or conventions are inopposite. The inclusion of the Electoral College in the Constitution as the result of specific historical concerns validated the collegiate principle despite its inherent numerical inequality, but implied nothing about the use of an analogous system by a state in a statewide election. No such specific accommodation of the latter was ever undertaken, and therefore no validation of its numerical inequality ensued. Nor does the question here have anything to do with the composition of the state or federal legislature, and we intimate no opinion on the constitutional phases of that problem beyond what we say in Barger versus Carr, supra. The present case is only a voting case. Georgia gives every qualified voter one vote in a statewide election, but in counting those votes, she employs the county unit system, which in end result weights the rural vote more heavily than the urban vote, and weights some small rural counties heavier than other larger rural counties. States can, within limits, specify the qualifications of voters in both state and federal elections. The Constitution, indeed, makes voters' qualifications rest on state law even in federal elections. As we held in Lassiter versus Northampton County Election Board, a state may, if it chooses, require voters to pass literacy tests, provided, of course, that literacy is not used as a cloak to discriminate against one class or group. But we need not determine all the limitations that are placed on this power of a state to determine the qualifications of voters, for appellee is a qualified voter. The 15th Amendment prohibits a state from denying or abridging a Negro's right to vote. The 19th Amendment does the same for women. If a state in a statewide election weighted the male vote more heavily than the female vote, or the white vote more heavily than the Negro vote, none could successfully contend that that discrimination was allowable. How then can one person be given twice or 10 times the voting power of another person in a statewide election merely because he lives in a rural area or because he lives in the smallest rural county? Once the geographical unit for which a representative is to be chosen is designated, all who participate in the election are to have an equal vote, whatever their race, whatever their sex, whatever their occupation, whatever their income, and wherever their home may be in that geographical unit. This is required by the Equal Protection Clause of the 14th Amendment. The concept of "we the people" under the Constitution visualizes no preferred class of voters, but equality among those who meet the basic qualifications. The idea that every voter is equal to every other voter in his state when he casts his ballot in favor of one of several competing candidates underlies many of our decisions. The Court has consistently recognized that all qualified voters have a constitutionally protected right, quote, to cast their ballots and have them counted at congressional elections, end of quote. Every voter's vote is entitled to be counted once. It must be correctly counted and reported. As stated in United States versus Mosley, quote, the right to have one's vote counted, end of quote, has the same dignity as, quote, the right to put a ballot in a box, end of quote. It can be protected from the diluting effect of illegal ballots. And these rights must be recognized in any preliminary election that in fact determines the true weight a vote will have. The concept of political equality in the voting booth contained in the 14th Amendment extends to all phases of state elections. And as previously noted, there is no indication in the Constitution that home site or occupation affords a permissible basis for distinguishing between qualified voters within the state. The only weighting of votes sanctioned by the Constitution concerns matters of representation, such as the allocation of senators irrespective of population and the use of the Electoral College in the choice of a president. Yet when senators are chosen, the 17th Amendment states that choice must be made, quote, by the people, end of quote. Minors, felons, and other classes may be excluded. But once the class of voters is chosen and their qualifications specified, we see no constitutional way by which equality of voting power may be evaded. As we stated in Goldmillion versus Lightfoot, quote, when a state exercises power wholly within the domain of state interest, it is insulated from federal judicial review. But such insulation is not carried over when state power is used as an instrument for circumventing a federally protected right, end of quote. The conception of political equality from the Declaration of Independence to Lincoln's Gettysburg Address to the 15th, 17th, and 19th Amendments can mean only one thing: one person, one vote. While we agree with the district court on most phases of the case and think it was right in enjoining the use of the county unit system in tabulating the votes, we vacate its judgment and remand the case so that a decree in conformity with our opinion may be entered. It is so ordered. Judgment vacated and case remanded. End of section 20.
Section 21 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. New York Times Company v. Sullivan, 376, U.S. 254. Decided March 9, 1964. Part 1. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Brennan delivered the opinion of the court. We are required in this case to determine for the first time the extent to which the constitutional protections for speech and press limit a state's power to award damages in a libel action brought by a public official against critics of his official conduct. Respondent L.B. Sullivan is one of the 3 elected commissioners of the city of Montgomery, Alabama. He testified that he was Commissioner of Public Affairs, and the duties are supervision of the Police Department, Fire Department, Department of Cemetery, and Department of Scales. He brought this civil libel action against the 4 individual petitioners who are Negroes and Alabama clergymen, and against petitioner the New York Times Company, a New York corporation which publishes the New York Times, a daily newspaper. A judge in the Circuit Court of Montgomery County awarded him damages of $500,000. The full amount claimed against all the petitioners, and the Supreme Court of Alabama affirmed. Respondent's complaint alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960, entitled, quote, "Heed Their Rising Voices," end quote. The advertisement began by stating that, quote, "As the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations in positive affirmation of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights," end quote. It went on to charge that, quote, "In their efforts to uphold these guarantees, they are being met by an unprecedented wave of terror by those who would deny and negate that document which the whole world looks upon as setting the pattern for modern freedom," end quote. Succeeding paragraphs purported to illustrate the wave of terror by describing certain alleged events. The text concluded with an appeal for funds for 3 purposes: support of the student movement, quote, "the struggle for the right to vote," end quote, and the legal defense of Dr. Martin Luther King, Jr., leader of the movement against a perjury indictment then pending in Montgomery. The text appeared over the names of 64 persons, many widely known for their activities in public affairs, religion, trade unions, and the performing arts. Below these names, and under a line reading, "We in the South who are struggling daily for dignity and freedom warmly endorse this appeal," appeared the names of the 4 individual petitioners and of 16 other persons, all but 2 of whom were identified as clergymen in various Southern cities. The advertisement was signed at the bottom of the page by the Committee to Defend Martin Luther King and the Struggle for Freedom in the South, and the officers of the committee were listed. Of the 10 paragraphs of text in the advertisement, the 3rd and a portion of the 6th were the basis of respondents' claim of libel. They read as follows. 3rd paragraph. "In Montgomery, Alabama, after students sang 'My Country 'Tis of Thee' on the state capitol steps, their leaders were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. When the entire student body protested to state authorities by refusing to re-register, their dining hall was padlocked in an attempt to starve them into submission." 6th paragraph. "Again and again the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killed his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses, and now they have charged him with perjury, a felony under which they could imprison him for 10 years. Although neither of these statements mentioned respondent by name, he contended that the word "police" in the 3rd paragraph referred to him as the Montgomery commissioner who supervised the police department, so that he was being accused of "ringing" the campus with police. He further claimed that the paragraph would be read as imputing to the police, and hence to him, the padlocking of the dining hall in order to starve the students into submission. Footnote: Respondent did not consider the charge of expelling the students to be applicable to him, since "that responsibility rests with the State Department of Education." End footnote. As to the 6th paragraph, he contended that, since arrests are ordinarily made by the police, the statement, "They have arrested Dr. King 7 times," would be read as referring to him. He further contended that the "they" who did the arresting would be equated with the "they" who committed the other described acts, and with the Southern violators. Thus, he argued, the paragraph would be read as accusing the Montgomery police, and hence him, of answering Dr. King's protests with "intimidation and violence," bombing his home, assaulting his person, and charging him with perjury. Respondent and 6 other Montgomery residents testified that they read some or all of the statements as referring to him in his capacity as commissioner. It is uncontroverted that some of the statements contained in the 2 paragraphs were not accurate descriptions of events which occurred in Montgomery. Although Negro students staged a demonstration on the state capitol steps, they sang the national anthem, and not "My Country 'Tis of Thee." Although 9 students were expelled by the State Board of Education, this was not for leading the demonstration at the Capitol, but for demanding service at a lunch counter in the Montgomery County Courthouse on another day. Not the entire student body, but most of it had protested the expulsion, not by refusing to register, but by boycotting classes on a single day. Virtually all the students did register for the ensuing semester. The campus dining hall was not padlocked on any occasion, and the only students who may have been barred from eating there were the few who had neither signed a pre-registration application nor requested temporary meal tickets. Although the police were deployed near the campus in large numbers on 3 occasions, they did not at any time "ring" the campus, and they were not called to the campus in connection with the demonstration on the state capitol steps, as the 3rd paragraph implied. Dr. King had not been arrested 7 times, but only 4, and although he claimed to have been assaulted some years earlier in connection with his arrest for loitering outside a courtroom, one of the officers who made the arrest denied that there was such an assault. On the premise that the charges in the 6th paragraph could be read as referring to him, respondent was allowed to prove that he had not participated in the events described. Although Dr. King's home had, in fact, been bombed twice when his wife and child were there, both of these occasions antedated respondent's tenure as commissioner. And the police were not only not implicated in the bombings, but they had made every effort to apprehend those who were. 3 of Dr. King's 4 arrests took place before respondent became commissioner. Although Dr. King had, in fact, been indicted, he was subsequently acquitted on 2 counts of perjury, each of which carried a possible 5-year sentence. Respondent had nothing to do with procuring the indictment. Respondent made no effort to prove that he suffered actual pecuniary loss as a result of the alleged libel. Footnote: approximately 394 copies of the edition of the Times containing the advertisement were circulated in Alabama. Of these, about 35 copies were distributed in Montgomery County. The total circulation of the Times for that day was approximately 650,000 copies. End footnote. One of his witnesses, a former employer, testified that, if he had believed the statements, he doubted whether he "would want to be associated with anybody who would be a party to such things that are stated in that ad," and that he would not re-employ respondent if he believed "that he allowed the police department to do the things that the paper said he did." But neither this witness nor any of the others testified that he had actually believed the statements in their supposed reference to respondent. The cost of the advertisement was approximately $4,800, and it was published by the Times upon an order from a New York advertising agency acting for the signatory committee. The agency submitted the advertisement with a letter from A. Philip Randolph, chairman of the committee, certifying that the persons whose names appeared on the advertisement had given their permission. Mr. Randolph was known to the Times's advertising acceptability department as a responsible person, and in accepting the letter as sufficient proof of authorization, it followed its established practice. There was testimony that the copy of the advertisement which accompanied the letter listed only the 64 names appearing under the text, and that the statement, "We in the South warmly endorse this appeal," and the list of names thereunder, which included those of the individual petitioners, were subsequently added when the first proof of the advertisement was received. Each of the individual petitioners testified that he had not authorized the use of his name, and that he had been unaware of its use until receipt of respondent's demand for retraction. The manager of the Advertising Acceptability Department testified that he had approved the advertisement for publication because he knew nothing to cause him to believe that anything in it was false, and because it bore the endorsement of "a number of people who are well known and whose reputation" he "had no reason to question." Neither he nor anyone else at the Times made an effort to confirm the accuracy of the advertisement, either by checking it against recent Times news stories relating to some of the described events, or by any other means. Alabama law denies a public officer recovery of punitive damages in a libel action brought on account of a publication concerning his official conduct unless he first makes a written demand for a public retraction, and the defendant fails or refuses to comply. Respondent served such a demand upon each of the petitioners. None of the individual petitioners responded to the demand, primarily because each took the position that he had not authorized the use of his name on the advertisement, and therefore had not published the statements that respondent alleged had libeled him. The Times did not publish a retraction in response to the demand, but wrote respondent a letter stating, among other things, that "we are somewhat puzzled as to how you think the statements in any way reflect on you," and "you might, if you desire, let us know in what respect you claim that the statements in the advertisement reflect on you." Respondent filed this suit a few days later without answering the letter. The Times did, however, subsequently publish a retraction of the advertisement upon the demand of Governor John Patterson of Alabama, who asserted that the publication charged him with "grave misconduct and improper actions and omissions as Governor of Alabama and ex officio Chairman of the State Board of Education of Alabama." When asked to explain why there had been a retraction for the governor, but not for respondent, the secretary of the Times testified, "We did that because we didn't want anything that was published by the Times to be a reflection on the state of Alabama, and the governor was, as far as we could see, the embodiment of the state of Alabama and the proper representative of the state. And furthermore, we had by that time learned more of the actual facts which the and purported to recite, and, finally, the ad did refer to the action of the state authorities and the Board of Education, presumably of which the governor is an ex officio chairman." On the other hand, he testified that he did not think that "any of the language in there referred to Mr. Sullivan." The trial judge submitted the case to the jury under instructions that the statements in the advertisement were "libelous per se," and were not privileged, so that petitioners might be held liable if the jury found that they had published the advertisement and that the statements were made "of and concerning" respondent. The jury was instructed that, because the statements were libelous per se, "the law implies legal injury from the bare fact of publication itself," "falsity and malice are presumed," "general damages need not be alleged or proved, but are presumed," and "punitive damages may be awarded by the jury even though the amount of actual damages is neither found nor shown." An award of punitive damages, as distinguished from "general" damages, which are compensatory in nature, apparently requires proof of actual malice under Alabama law, and the judge charged that, quote, mere negligence or carelessness is not evidence of actual malice or malice in fact, and does not justify an award of exemplary or punitive damages, end quote. He refused to charge, however, that the jury must be, quote, convinced, end quote, of malice, in the sense of, quote, actual intent, end quote, to harm or, quote, gross negligence and recklessness, end quote, to make such an award. And he also refused to require that a verdict for respondent differentiate between compensatory and punitive damages. The judge rejected petitioner's contention that his rulings abridged the freedom of speech and of the press that are guaranteed by the First and 14th Amendments. In affirming the judgment, the Supreme Court of Alabama sustained the trial judge's rulings and instructions in all respects. It held that, quote, where the words published tend to injure a person libeled by them in his reputation, profession, trade, or business, or charge him with an indictable offense, or tend to bring the individual into public contempt, they are libelous per se, end quote. That, quote, the matter complained of is, under the above doctrine, libelous per se, if it was published of and concerning the plaintiff, end quote, and that it was actionable without, quote, proof of pecuniary injury, such injury being implied, end quote. It approved the trial court's ruling that the jury could find the statements to have been made, quote, of and concerning, end quote, respondent stating, quote, we think it common knowledge that the average person knows that municipal agents, such as police and firemen and others, are under the control and direction of the city governing body and more particularly under the direction and control of a single commissioner. In measuring the performance or deficiencies of such groups, praise or criticism is usually attached to the official in complete control of the body, end quote. In sustaining the trial court's determination that the verdict was not excessive, the court said that malice could be inferred from the Times, quote, irresponsibility, end quote, in printing the advertisement while, quote, the Times in its own files had articles already published which would have demonstrated the falsity of the allegations in the advertisement, end quote. From the Times's failure to retract for respondent while retracting for the governor, whereas the falsity of some of the allegations was then known to the Times and, quote, the matter contained in the advertisement was equally false as to both parties, end quote, and from the testimony of the Times's secretary that, apart from the statement that the dining hall was padlocked, he thought the two paragraphs were, quote, substantially correct, end quote. The court reaffirmed a statement in an earlier opinion that, quote, there is no legal measure of damages in cases of this character, end quote. It rejected petitioner's constitutional contentions with the brief statements that, quote, the First Amendment of the U.S. Constitution does not protect libelous publications, end quote, and, quote, the 14th Amendment is directed against state action and not private action, end quote. Because of the importance of the constitutional issues involved, we granted the separate petitions for certiorari of the individual petitioners and of the Times, 371 U.S. 946. We reversed the judgment. We hold that the rule of law applied by the Alabama courts is constitutionally deficient for failure to provide the safeguards for freedom of speech and of the press that are required by the First and 14th Amendments in a libel action brought by a state official against the critics of his official conduct. Footnote: Since we sustain the contentions of all the petitioners under the First Amendment's guarantees of freedom of speech and of the press as applied to the states by the 14th Amendment, we do not decide the questions presented by the other claims of violation of the 14th Amendment. The individual petitioners contend that the judgment against them offends the Due Process Clause, because there was no evidence to show that they had published or authorized the publication of the alleged libel, and that the due process and equal protection clauses were violated by racial segregation and racial bias in the courtroom. The Times contends that the assumption of jurisdiction over its corporate person by the Alabama courts overreaches the territorial limits of the Due Process Clause. The latter claim is foreclosed from our review by the ruling of the Alabama courts that the Times entered a general appearance in the action, and thus waived its jurisdictional objection. We cannot say that this ruling lacks "fair or substantial support" in prior Alabama decisions. We further hold that under the proper safeguards, the evidence presented in this case is constitutionally insufficient to support the judgment for respondent. 1. We may dispose at the outset of two grounds asserted to insulate the judgment of the Alabama courts from constitutional scrutiny. The first is a proposition relied on by the State Supreme Court, that the 14th Amendment is directed against state action and not private action. That proposition has no application to this case. Although this is a civil lawsuit between private parties, the Alabama courts have applied a state rule of law which petitioners claim to impose invalid restrictions on their constitutional freedoms of speech and press. It matters not that that law has been applied in a civil action, and that it is common law only, though supplemented by statute. The test is not the form in which state power has been applied, but, whatever the form, whether such power has, in fact, been exercised. The second contention is that the constitutional guarantees of freedom of speech and of the press are inapplicable here, at least so far as the Times is concerned, because the allegedly libelous statements were published as part of a paid "commercial" advertisement. The argument relies on Valentine v. Chesterton, 316 U.S. 52, where the court held that a city ordinance forbidding street distribution of commercial and business advertising matter did not abridge the First Amendment freedoms, even as applied to a handbill having a commercial message on one side, but a protest against certain official action on the other. The reliance is wholly misplaced. The court in Chesterton reaffirmed the constitutional protection for the freedom of communicating information and disseminating opinion. Its holding was based on the factual conclusions that the handbill was purely commercial advertising, and that the protest against official action had been added only to evade the ordinance. The publication was not a commercial advertisement in the sense in which the word was used in Chesterton. It communicated information, expressed opinion, recited grievances, protested claimed abuses, and sought financial support on behalf of a movement whose existence and objectives are matters of the highest public interest and concern. That the Times was paid for publishing the advertisement is as immaterial in this connection as is the fact that the newspapers and books are sold. Any other conclusion would discourage newspapers from carrying "editorial advertisements" of this type, and so might shut off an important outlet for the promulgation of information and ideas by persons who do not themselves have access to publishing facilities, who wish to exercise their freedom of speech even though they are not members of the press. The effect would be to shackle the First Amendment in an attempt to secure "the widest possible dissemination of information from diverse and antagonistic sources." To avoid placing such a handicap upon the freedoms of expression, we hold that, if the allegedly libelous statements would otherwise be constitutionally protected from the present judgment, they do not forfeit that protection because they were published in the form of a paid advertisement. 2. Under Alabama law, as applied in this case, a publication is "libelous per se" if the words "tend to injure a person in his reputation" or to "bring him into public contempt." The trial court stated that the standard was met if the words are such as to "injure him in his public office, or impute misconduct to him in his office, or want of official integrity, or want of fidelity to a public trust." The jury must find that the words were published "of and concerning" the plaintiff. But where the plaintiff is a public official, his place in the governmental hierarchy is sufficient evidence to support a finding that his reputation has been affected by statements that reflect upon the agency of which he is in charge. Once libel per se has been established, the defendant has no defense as to stated facts unless he can persuade the jury that they were true in all their particulars. His privilege of "fair comment" for expressions of opinion depends on the truth of the facts upon which the comment is based. Unless he can discharge the burden of proving truth, general damages are presumed, and may be awarded without proof of pecuniary injury. A showing of actual malice is apparently a prerequisite to recovery of punitive damages, and the defendant may in any event forestall a punitive award by a retraction meeting the statutory requirements. Good motives and belief in truth do not negate an inference of malice, but are relevant only in mitigation of punitive damages, if the jury chooses to accord them weight. The question before us is whether this rule of liability, as applied to an action brought by a public official against critics of his official conduct, abridges the freedom of speech and of the press that is guaranteed by the First and 14th Amendments. Respondent relies heavily, as did the Alabama courts, on statements of this court to the effect that the Constitution does not protect libelous publications. Those statements do not foreclose our inquiry here. None of the cases sustained the use of libel laws to impose sanctions upon expression critical of the official conduct of public officials. The dictum in Pennicamp v. Florida, that "when the statements amount to defamation, a judge has such remedy in damages for libel as do other public servants," implied no view as to what remedy might constitutionally be afforded to public officials. In Beauharnais v. Illinois, the court sustained an Illinois criminal libel statute as applied to a publication held to be both defamatory of a racial group and, quote, liable to cause violence and disorder, end quote. But the court was careful to note that it, quote, retains and exercises authority to nullify action which encroaches on freedom of utterance under the guise of punishing libel, end quote. For, quote, public men are, as it were, public property, end quote. And, quote, discussion cannot be denied, and the right as well as the duty of criticism must not be stifled, end quote. In the only previous case that did present the question of constitutional limitations upon the power to award damages for libel of a public official, the court was equally divided, and the question was not decided. In deciding the question now, we are compelled by neither precedent nor policy to give any more weight to the epithet, quote, libel, end quote, than we have to other, quote, mere labels, end quote, of state law, like insurrection, contempt, advocacy of unlawful acts, breach of the peace, obscenity, solicitation of legal business, and the various other formula for the repression of expression that has been challenged in the court. Libel can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. The general proposition that freedom of expression upon public questions is secured by the First Amendment has long been settled by our decisions. The constitutional safeguard, we have said, quote, was fashioned to assure unfettered interchange of ideas for the bringing about of political and social changes desired by the people, end quote. Roth v. United States 354, U.S. 476, 484. Quote, the maintenance of the opportunity for free political discussion to the end that government may be responsive to the will of the people, and that changes may be obtained by lawful means, an opportunity essential to the security of the Republic, is a fundamental principle of our constitutional system, end quote. Quote, it is a prized American privilege to speak one's mind, although not always with perfect good taste, on all public institutions, end quote. And this opportunity is to be afforded for, quote, vigorous advocacy, end quote, no less than, quote, abstract discussion, end quote. The First Amendment, said Judge Learned Hand, presupposes that right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. To many this is and always will be folly, but we have staked upon it our all. End of section 21. Section 22 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. New York Times Company v. Sullivan, 376 U.S. 254. Decided March 9, 1964, Part 2. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Brandeis, in his concurring opinion in Whitney v. California, 274 U.S. 357, gave the principle its classic formulation. Quote, "Those who won our independence believed that public discussion is a political duty, and that this should be a fundamental principle of the American government. They recognized the risks to which all human institutions are subject, but they knew that order cannot be secured merely through fear of punishment for its infraction, that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones. Believing in the power of reason as applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed." End quote. Thus we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. The present advertisement, as an expression of grievance and protest on one of the major public issues of our time, would seem clearly to qualify for the constitutional protection. The question is whether it forfeits that protection by the falsity of some of its factual statements and by its alleged defamation of respondent. Authoritative interpretations of the First Amendment guarantees have consistently refused to recognize an exception for any test of truth, whether administered by judges, juries, or administrative officials, and especially one that puts the burden of proving truth on the speaker. The constitutional protection does not turn upon "the truth, popularity, or social utility of the ideas and beliefs which are offered." As Madison said, "Some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than in that of the press." In Cantwell v. Connecticut 310, U.S. 296 310, the court declared, "In the realm of religious faith and in that of political belief, sharp differences arise. In both fields the tenets of one man may seem the rankest error to his neighbor. To persuade others to his own point of view, the pleader, as we know, at times resorts to exaggeration, to vilification of men who have been or are prominent in church or state, and even to false statement. But the people of this nation have ordained in the light of history that, in spite of the probability of excesses and abuses, these liberties are, in the long view, essential to enlightened opinion and right conduct on the part of the citizens of a democracy." That erroneous statement is inevitable in free debate, and that it must be protected if the freedom of expression are to have the "breathing space" that they "need to survive," was also recognized by the Court of Appeals for the District of Columbia Circuit in Sweeney v. Patterson, 76 U.S. Judge Edgerton spoke for a unanimous court which affirmed the dismissal of a congressman's libel suit based upon a newspaper article charging him with anti-Semitism in opposing a judicial appointment. He said, "Cases which impose liability for erroneous reports of the political conduct of officials reflect the obsolete doctrine that the governed must not criticize their governors. The interest of the public here outweighs the interest of appellant or any other individual. The protection of the public requires not merely discussion, but information. Political conduct and views which some respectable people approve and others condemn are constantly imputed to congressmen. Errors of fact, particularly in regard to the man's mental states and processes, are inevitable. Whatever is added to the field of libel is taken from the field of free debate." Footnote: see also Mill on Liberty, Oxford, Blackwell, 1947, at 47. "To argue sophistically, to suppress facts or arguments, to misstate the elements of the case or misrepresent the opposite opinion, all this, even to the most aggravated degree, is so continually done in perfect good faith by persons who are not considered, and in many other respects may not deserve to be considered, ignorant or incompetent, that it is rarely possible on adequate grounds conscientiously to stamp the misrepresentation as morally culpable, and still less could law presume to interfere with this kind of controversial misconduct." End of footnote. Injury to official reputation affords no more warrant for repressing speech that would otherwise be free than does factual error. Where judicial officials are involved, this court has held that concern for dignity and reputation of the courts does not justify the punishment as criminal contempt of criticism of the judge or his decision. This is true even though the utterance contains "half-truths" and "misinformation." Such repression can be justified, if at all, only by a clear and present danger of the obstruction of justice. If judges are to be treated as "men of fortitude, able to thrive in a hardy climate," surely the same must be true of other government officials, such as elected city commissioners. Footnote: the climate in which public officials operate, especially during a political campaign, has been described by one commentator in the following terms: "Charges of gross incompetence, disregard of the public interest, communist sympathies, and the like usually have filled the air, and hints of bribery, embezzlement, and other criminal conduct are not infrequent." Criticism of their official conduct does not lose its constitutional protection merely because it is effective criticism, and hence diminishes their official reputations. If neither factual error nor defamatory content suffices to remove the constitutional shield from criticisms of official conduct, the combination of the two elements is no less inadequate. This is the lesson to be drawn from the great controversy over the Sedition Act of 1798, 1 Stat. 596, which first crystallized a national awareness of the central meaning of the First Amendment. That statute made it a crime punishable by a $5,000 fine and 5 years in prison, "if any person shall write, print, utter, or publish any false, scandalous, and malicious writing or writings against the government of the United States, or either house of the Congress, or the President, with intent to defame, or to bring them or either of them into contempt or disrepute, or to excite against them or either of any of them the hatred of the good people of the United States." The act allowed the defendant the defense of truth, and provided that the jury were to be judges both of the law and the facts. Despite these qualifications, the act was vigorously condemned as unconstitutional in an attack joined in by Jefferson and Madison. In the famous Virginia resolutions of 1798, the General Assembly of Virginia resolved that it, doth particularly protest against the palpable and alarming infractions of the Constitution in the two late cases of the Alien and Sedition Acts passed at the last session of Congress. The Sedition Act exercises a power not delegated by the Constitution, but on the contrary, expressly and positively forbidden by one of the amendments thereto. A power which, more than any other, ought to produce universal alarm, because it is levelled against the right of freely examining public characters and measures, and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every other right. Madison prepared the report in support of the protest. His premise was that the Constitution created a form of government under which "the people, not the government, possessed the absolute sovereignty." The structure of the government dispersed power in reflection of the people's distrust of concentrated power, and of power itself at all levels. This form of government was "altogether different" from the British form, under which the crown was sovereign and the people were subjects. "Is it not natural and necessary under such different circumstances," he asked, "that a different degree of freedom in the use of the press should be contemplated?" Earlier, in a debate in the House of Representatives, Madison had said, "If we advert to the nature of republican government, we shall find that the censorial power is in the people over the government, and not in the government over the people." Of the exercise of that power by the press, his report said, "In every State, probably in the Union, the press has exerted a freedom in canvassing the merits and measures of public men of every description, which has not been confined to the strict limits of the common law. On this footing the freedom of the press has stood; on this foundation it yet stands." The right of free public discussion of the stewardship of public officials was thus, in Madison's view, a fundamental principle of the American form of government. The report on the Virginia resolutions further stated, "It is manifestly impossible to punish the intent to bring those who administer the government into disrepute or contempt, without striking at the right of freely discussing public characters and measures, which again is equivalent to a protection of those who administer the government, if they should at any time deserve the contempt or hatred of the people, against being exposed to it by free animadversions on their characters and conduct. Nor can it be a doubt that a government thus entrenched in penal statutes against the just and natural effects of a culpable administration will easily evade the responsibility which is essential to a faithful discharge of its duty. Let it be recollected, lastly, that the right of electing the members of the government constitutes more particularly the essence of a free and responsible government. The value and efficiency of this right depends on the knowledge of the comparative merits and demerits of the candidates for public trust, and on the equal freedom, consequently, of examining and discussing these merits and demerits of the candidates respectively." Although the Sedition Act was never tested in this court, The act expired by its terms in 1801. End footnote. The attack upon its validity has carried the day in the court of history. Fines levied in its prosecution were repaid by act of Congress on the ground that it was unconstitutional. Calhoun, reporting to the Senate on February 4, 1836, assumed that its invalidity was a matter, "which no one now doubts." Jefferson, as President, pardoned those who had been convicted and sentenced under the act and remitted their fines, stating, "I discharged every person under punishment or prosecution under the sedition law because I considered, and now consider, that law to be a nullity, as absolute and as palpable as if Congress had ordered us to fall down and worship a golden image." The invalidity of the act has also been assumed by justices of this court. These views reflect a broad consensus that the act, because of the restraint it imposed upon criticism of government and public officials, was inconsistent with the First Amendment. There is no force in respondents' argument that the constitutional limitations implicit in the history of the Sedition Act applied only to Congress, and not to the State. It is true that the First Amendment was originally addressed only to action by the federal government, and that Jefferson, for one, while denying the power of Congress "to control the freedom of the press," recognized such a power in the States. But this distinction was eliminated with the adoption of the 14th Amendment and the application to the States of the First Amendment's restrictions. What a State may not constitutionally bring about by means of a criminal statute is likewise beyond the reach of its civil law of libel. The fear of damage awards under a rule such as that invoked by the Alabama courts here may be markedly more inhibiting than the fear of prosecution under a criminal statute. Alabama, for example, has a criminal libel law which subjects to prosecution "any person who speaks, writes, or prints of, and concerning another, any accusation falsely and maliciously importing the commission by such person of a felony, or any other indictable offence involving moral turpitude," and which allows as punishment, upon conviction, a fine not exceeding $500 and a prison sentence of 6 months. Presumably, a person charged with violation of this statute enjoys ordinary criminal law safeguards, such as the requirements of an indictment and of proof beyond a reasonable doubt. These safeguards are not available to the defendant in a civil action. The judgment awarded in this case, without the need of any proof of actual pecuniary loss, was 1,000 times greater than the maximum fine provided by the Alabama criminal statute, and 100 times greater than that provided by the Sedition Act. And since there is no double jeopardy limitation applicable to civil lawsuits, this is not the only judgment that may be awarded against petitioners for the same publication. Footnote: The Times states that 4 other libel suits based on the advertisement have been filed against it by others who have served as Montgomery City Commissioners, and by the Governor of Alabama; that another $500,000 verdict has been awarded in the only one of those cases that has yet gone to trial, and that the damages sought in the other 3 total $2 million. End footnote. Whether or not a newspaper can survive a succession of such judgments, the pall of fear and timidity imposed upon those who would give voice to public criticism is an atmosphere in which the First Amendment freedoms cannot survive. Plainly, the Alabama law of civil libel is a form of regulation that creates hazards to protected freedoms markedly greater than those that attend reliance upon the criminal law." The state rule of law is not saved by its allowance of the defense of truth. A defense for erroneous statements honestly made is no less essential here than was the requirement of proof of guilty knowledge which, in Smith v. California, we held indispensable to a valid conviction of a bookseller for possessing obscene writings for sale. We said, "For if the bookseller is criminally liable without knowledge of the contents, he will tend to restrict the books he sells to those he has inspected, and thus the state will have imposed a restriction upon the distribution of constitutionally protected as well as obscene literature, and the bookseller's burden would become the public's burden, for by restricting him, the public's access to reading matter would be restricted. His timidity in the face of his absolute criminal liability thus would tend to restrict the public's access to forms of the printed word which the state could not constitutionally suppress directly. The bookseller's self-censorship compelled by the state would be a censorship affecting the whole public, hardly less virulent for being privately administered. Through it the distribution of all books, both obscene and not obscene, would be impeded." A rule compelling the critic of official conduct to guarantee the truth of all his factual assertions, and to do so on pain of liable judgments virtually unlimited in amount, leads to a comparable "self-censorship" allowance of the defense of truth, with the burden of proving it on the defendant, does not mean that only false speech will be deterred. Even a false statement may be deemed to make a valuable contribution to public debate, since it brings about "the clearer perception and livelier impression of truth produced by its collision with air." Even courts accepting this defense as an adequate safeguard have recognized the difficulties of adducing legal proofs that the alleged libel was true in all its factual particulars. Under such a rule, would-be critics of official conduct may be deterred from voicing their criticism, even though it is believed to be true, and even though it is, in fact, true, because of doubt whether it can be proved in court, or fear of the expense of having to do so. They tend to make only statements which "steer far wider of the unlawful zone." The rule thus dampens the vigor and limits the variety of public debate. It is inconsistent with the First and 14th Amendments. The constitutional guarantees require, we think, a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with "actual malice," that is, with knowledge that it was false, or with reckless disregard of whether it was false or not. An oft-cited statement of a like rule, which has been adopted by a number of state courts, is found in the Kansas case of Coleman v. McClellan, 78 Kansas 711, 98, page 281, 1908. The State Attorney General, a candidate for re-election and a member of the commission charged with the management and control of the state school fund, sued a newspaper publisher for alleged libel in an article purporting to state facts relating to his official conduct in connection with a school fund transaction. The defendant pleaded privilege, and the trial judge, over the plaintiff's objection, instructed the jury that, "where an article is published and circulated among voters for the sole purpose of giving what the defendant believes to be truthful information concerning a candidate for public office, and for the purpose of enabling such voters to cast their ballot more intelligently, and the whole thing is done in good faith and without malice, the article is privileged, although the principal matters contained in the article may be untrue in fact and derogatory to the character of the plaintiff, and in such a case the burden is on the plaintiff to show actual malice in the publication of the article." In answer to a special question, the jury found that the plaintiff had not proved actual malice, and a general verdict was returned for the defendant. On appeal, the Supreme Court of Kansas, in an opinion of Justice Berger, reasoned as follows: "It is of the utmost consequence that the people should discuss the character and qualifications of candidates for their suffrages. The importance to the state and to society of such discussions is so vast, and the advantages derived are so great, that they more than counterbalance the inconvenience of private persons whose conduct may be involved, and occasional injury to the reputations of individuals must yield to the public welfare, although at times such injury may be great. The public benefit from publicity is so great, and the chance of injury to private character so small, that such discussion must be privileged." The court thus sustained the trial court's instruction as a correct statement of the law, saying, "In such a case the occasion gives rise to a privilege qualified to this extent: any one claiming to be defamed by the communication must show actual malice or go remedialess. This privilege extends to a great variety of subjects, and includes matters of public concern, public men, and candidates for office." Such a privilege of criticism of official conduct is appropriately analogous to the protection afforded a public official when he is sued for libel by a private citizen. The privilege immunizing honest misstatements of fact is often referred to as a "conditional" privilege, to distinguish it from the "absolute" privilege recognized in judicial, legislative, administrative, and executive proceedings. In Barr v. Matteo, this court held the utterance of a federal official to be absolutely privileged if made "within the outer perimeter" of his duties. The states accord the same immunity to statements of their highest officers, although some differentiate their lesser officials and qualify the privilege they enjoy. But all hold that all officials are protected unless actual malice can be proved. The reason for the official privilege is said to be that the threat of damage suits would otherwise "inhibit the fearless, vigorous, and effective administration of policies of government," and "dampen the ardor of all but the most resolute or the most irresponsible in the unflinching discharge of their duties." Analogous considerations support the privilege for the citizen critic of government. It is as much his duty to criticize as it is the official's duty to administer. As Madison said, "The censorial power is in the people over the government, and not in the government over the people." It would give public servants an unjustified preference over the public they serve if critics of official conduct did not have a fair equivalent of the immunity granted to the officials themselves. We conclude that such a privilege is required by the First and 14th Amendments. 3. We hold today that the Constitution delimits a state's power to award damages for libel in actions brought by public officials against critics of their official conduct. Since this is such an action, the rule requiring proof of actual malice is applicable. While Alabama law apparently requires proof of actual malice for an award of punitive damages, where general damages are concerned, malice is "presumed." Such a presumption is inconsistent with the federal rule. The power to create presumptions is not a means of escape from constitutional restrictions. The showing of malice required for the forfeiture of the privilege is not presumed, but is a matter for proof by the plaintiff. Footnote: we have no occasion here to determine how far down into the lower ranks of government employees the "public official" designation would extend for the purpose of this rule, or otherwise to specify categories of persons who would or would not be included. Nor need we here determine the boundaries of the "official conduct" concept. It is enough for the present case that respondent's position as an elected city commissioner clearly made him a public official, and that the allegations in the advertisement concerned what was allegedly his official conduct as commissioner in charge of the police department. As to the statements alleging the assaulting of Dr. King and the bombing of his home, it is immaterial that they might not be considered to involve respondent's official conduct if he himself had been accused of perpetrating the assaulting and the bombing. Respondent does not claim that the statements charged him personally with these acts. His contention is that the advertisement connects him with them only in his official capacity as the commissioner supervising the police, on the theory that the police might be equated with the "they" who did the bombing and the assault. Thus, if these allegations can be read as referring to respondent at all, they must be read as describing his performance of his official duties. Footnote. Thus the trial judge here instructed the jury that mere negligence or carelessness is not evidence of actual malice or malice. In fact, it does not justify an award of exemplary or punitive damages in an action for libel. The court refused, however, to give the following instruction, which had been requested by the Times. I charge you that punitive damages, as the name indicates, are designed to punish the defendant, the New York Times Company, a corporation, and the other defendants in this case. And I further charge you that such punitive damages may be awarded only in the event that you, the jury, are convinced by a fair preponderance of the evidence that the defendant was motivated by personal ill will, that is, actual intent to do the plaintiff harm, or that the defendant was guilty of gross negligence and recklessness, and not of just ordinary negligence, or carelessness in publishing the matter complained of, so as to indicate a wanton disregard to plaintiff's rights. The trial court's error in failing to require any finding of actual malice for an award of general damages makes it unnecessary for us to consider the sufficiency under the federal standard of the instructions regarding actual malice that were given as to punitive damages. Since the trial judge did not instruct the jury to differentiate between general and punitive damages, it may be that the verdict was wholly in award of one or the other, but it is impossible to know, in view of the general verdict returned. Because of this uncertainty, the judgment must be reversed and the case remanded. Since respondent may seek a new trial, we deem that considerations of effective judicial administration require us to review the evidence in the present record to determine whether it could constitutionally support a judgment for respondent. This court's duty is not limited to the elaboration of constitutional principles. We must also, in proper cases, review the evidence to make certain that those principles have been constitutionally applied. This is such a case, particularly since the question is one of alleged trespass across "the line between speech unconditionally guaranteed and speech which may legitimately be regulated." In cases where the line must be drawn, the rule is that we "examine for ourselves the statements in issue and the circumstances under which they were made to see whether they are of a character which the principles of the First Amendment, as adopted by the Due Process Clause of the 14th Amendment, protect." We must "make an independent examination of the whole record," so as to assure ourselves that the judgment does not constitute a forbidden intrusion on the field of free expression. Footnote: The Seventh Amendment does not, as respondent contends, preclude such an examination by this court. That amendment providing that "no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law," is applicable to state cases coming here. But its ban on re-examination of facts does not preclude us from determining whether governing rules of federal law have been properly applied to the facts. "This court will review the finding of facts by a state court, where a conclusion of law as to a federal right and a finding of fact are so intermingled as to make it necessary, in order to pass upon the federal question, to analyze the facts." Applying these standards, we consider that the proof presented to show actual malice lacks the convincing clarity which the constitutional standard demands, and hence that it would not constitutionally sustain the judgment for respondent under the proper rule of law. The case of the individual petitioners requires little discussion. Even assuming that they could constitutionally be found to have authorized the use of their names on the advertisement, there is no evidence whatever that they were aware of any erroneous statements or were in any way reckless in that regard. The judgment against them is thus without constitutional support. As to the Times, we similarly conclude that the facts do not support a finding of actual malice. The statement by the Times secretary that, apart from the padlocking allegation, he thought the advertisement was "substantially correct," affords no constitutional warrant for the Alabama Supreme Court's conclusion that it was a "cavalier ignoring of the falsity of the advertisement, from which the jury could not have but been impressed with the bad faith of the Times, and its maliciousness inferable therefrom." The statement does not indicate malice at the time of the publication, even if the advertisement was not "substantially correct," although the respondent's own proofs tend to show that it was. That opinion was at least a reasonable one, and there was no evidence to impeach the witness's good faith in holding it. the Times's failure to retract upon respondent's demand, although it later retracted upon the demand of Governor Patterson, is likewise not adequate evidence of malice for constitutional purposes. Whether or not a failure to retract may ever constitute such evidence, there are two reasons why it does not here. First, the letter written by the Times reflected a reasonable doubt on its part as to whether the advertisement could reasonably be taken to refer to respondent at all. Second, it was not a final refusal, since it asked for an explanation on this point, a request that respondent chose to ignore. Nor does the retraction upon the demand of the governor supply the necessary proof. It may be doubted that a failure to retract, which is not itself evidence of malice, can retroactively become such by virtue of a retraction subsequently made to another party. But in any event, that did not happen here, since the explanation given by the Times' secretary for the distinction drawn between respondent and the governor was a reasonable one, the good faith of which was not impeached. Finally, there is evidence that the Times published the advertisement without checking its accuracy against the news stories of the Times' own files. The mere presence of the stories in the files does not, of course, establish that the Times, "knew," the advertisement was false, since the state of mind required for actual malice would have to be brought home to the persons in the Times' organization having responsibility for the publication of the advertisement. With respect to the failure of those persons who make the check, the record shows that they relied upon their knowledge of the good reputation of many of those whose names were listed as sponsors of the advertisement, and upon the letter from A. Philip Randolph, known to them as a responsible individual, certifying that the use of the names was authorized. There was testimony that the persons handling the advertisement saw nothing in it that would render it unacceptable under the Times' policy of rejecting advertisements containing "attacks of a personal character." Their failure to reject it on this ground was not unreasonable. We think that the evidence against the Times supports at most a finding of negligence in failing to discover the misstatements, and is constitutionally insufficient to show the recklessness that is required for a finding of actual malice. We also think the evidence was constitutionally defective in another respect. It was incapable of supporting the jury's finding that the alleged libelous statements were made "of and concerning" respondent. Respondent relies on the words of the advertisement and the testimony of 6 witnesses to establish a connection between it and himself. Thus, in his brief to this court, he states, "The reference to respondent as police commissioner is clear from the ad. In addition, the jury heard the testimony of a newspaper editor, a real estate and insurance man, the sales manager of a men's clothing store, a food equipment man, a service station operator, and the operator of a truck line for whom respondent had formerly worked. Each of these witnesses stated that he associated the statements with respondent." There was no reference to respondent in the advertisement, either by name or official position. A number of the allegedly libelous statements, the charges that the dining hall was padlocked and that Dr. King's home was bombed, his person assaulted, and a perjury prosecution instituted against him, did not even concern the police, despite the ingenuity of the arguments which would attach his significance to the word "they." It is plain that these statements could not reasonably be read as accusing respondent of personal involvement in the acts in question. The statement upon which respondent principally relies as referring to him are the two allegations that did concern the police or police functions. That, "truckloads of police ringed the Alabama State College campus," after the demonstration on the state capitol steps, and that Dr. King had been "arrested 7 times." These statements were false only in that the police had been "deployed near" the campus, but had not actually "ringed" it, and had not gone there in connection with the state capitol demonstration, and in that Dr. King had been arrested only 4 times. The ruling that these discrepancies between what was true and what was asserted were sufficient to injure respondent's reputation may itself raise constitutional problems, but we need not consider them here. Although the statements may be taken as referring to the police, they did not, on their face, make even an oblique reference to respondent as an individual. Support for asserted reference must, therefore, be sought in the testimony of respondent's witnesses. But none of them suggested any basis for the belief that respondent himself was attacked in the advertisement, beyond the bare fact that he was in overall charge of the police department, and thus bore official responsibility for police conduct. To the extent that some of the witnesses thought respondent to have been charged with ordering or approving the conduct or otherwise being personally involved in it, they based this notion not on any statements in the advertisement, and not on any evidence that he had in fact been so involved, but solely on the unsupported assumption that, because of his official position, he must have been. This reliance on the bare fact of respondent's official position was made explicit by the Supreme Court of Alabama. That court, in holding that the trial court "did not err in overruling the demurrer of the Times in the aspect of the libelous matter was not of and concerning the plaintiff," based its ruling on the proposition that "we think it common knowledge that the average person knows that municipal agents, such as police and firemen and others, are under the control and direction of the city governing body, and more particularly under the direction and control of a single commissioner. In measuring the performance or deficiencies of such groups, praise or criticism is usually attached to the official in complete control of the body." This proposition has disquieting implications for criticism of governmental conduct. For good reason, "no court of last resort in this country has ever held, or even suggested, that prosecutions for libel on government have any place in the American system of jurisprudence." The present proposition would sidestep this obstacle by transmuting criticism of government, however impersonal it may seem on its face, into personal criticism, and hence potential libel, of the officials of whom the government is composed. There is no legal alchemy by which a state may thus create the cause of action that would otherwise be denied for a publication which, as respondent himself said of the advertisement, "reflects not only on me, but on the other commissioners and the community," raising as it does the possibility that a good faith critic of government will be penalized for his criticism. The proposition relied on by the Alabama court strikes at the very center of the constitutionally protected area of free expression. Footnote: insofar as the proposition means only that the statements about police conduct libeled respondent by implicitly criticizing his ability to run the police department, recovery is also precluded in this case by the doctrine of fair comment. Since the 14th Amendment requires recognition of the conditional privilege for honest misstatements of fact, it follows that a defense of fair comment must be afforded for honest expression of opinion based upon privileged as well as true statements of fact. Both defenses are, of course, defeasible if the public official proves actual malice, as was not done here. End footnote. We hold that such a proposition may not constitutionally be utilized to establish that an otherwise impersonal attack on government operations was a libel of any official responsible for those operations. Since it was relied on exclusively here, and there was no other evidence to connect the statements with respondent, the evidence was constitutionally insufficient to support a finding that the statements referred to respondent. The judgment of the Supreme Court of Alabama is reversed, and the case is remanded to that court for further proceedings not inconsistent with this opinion. Reversed and remanded. End of section 22.
Section 23 of A Collection of Supreme Court Opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Miles McCain. Berger v. New York, 388 U.S. 41. Decided June 12, 1967. This is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Clark delivered the opinion of the court. This writ tests the validity of New York's permissive eavesdrop statute, New York Code of Criminal Procedure, Section 813A, under the 4th, 5th, 9th, and 14th Amendments. The claim is that the statute sets up a system of surveillance which involves trespassory intrusions into private, constitutionally protected premises, authorizes general searches for mere evidence, and is an invasion of the privilege against self-incrimination. The trial court upheld this statute, the appellate division affirmed without opinion, and the Court of Appeals did likewise by a divided vote. We granted certiorari. We have concluded that the language of New York statute is too broad in its sweep, resulting in a trespassory intrusion into a constitutionally protected area, and is, therefore, violative of the 4th and 14th Amendments. This disposition obviates the necessity for any discussion of the other points raised. Berger, the petitioner, was convicted on 2 counts of conspiracy to bribe the chairman of the New York State Liquor Authority. The case arose out of the complaint of one Ralph Pancini to the district attorney's office that agents of the State Liquor Authority had entered his bar and grill and without cause seized his books and records. Pancini asserted that the raid was in reprisal for his failure to pay a bribe for a liquor license. Numerous complaints had been filed with the district attorney's office charging the payment of bribes by applicants for liquor licenses. On the direction of that office, Pancini, while equipped with a mini-phone recording device, interviewed an employee of the authority. The employee advised Pancini that the price for a license was $10,000 and suggested that he contact attorney Harry Nair. Nair subsequently told Pancini that he worked with the authority employee before and that the latter was aware of the going rate on liquor licenses downtown. On the basis of this evidence, an eavesdrop order was obtained from a justice of the State Supreme Court as provided by Section 813A. The order permitted the installation, for a period of 60 days, of a recording device in Nair's office. On the basis of leads obtained from this eavesdrop, a second order permitting the installation, for a like period, of a recording device in the office of one Harry Steinman was obtained. After some 2 weeks of eavesdropping, a conspiracy was uncovered involving the issuance of liquor licenses for the Playboy and tenement clubs, both of New York City. Petitioner was indicted as a go-between for the principal conspirators who, though not named in the indictment, were disclosed in a bill of particulars. Relevant portions of the recordings were received in evidence at the trial and were played to the jury, all over the objection of the petitioner. The parties have stipulated that the district attorney had no information upon which to proceed to present a case to the grand jury or on the basis of which to prosecute the petitioner except by use of the eavesdrop evidence. Eavesdropping is an ancient practice which at common law was condemned as a nuisance. At one time, the eavesdropper listened by naked ear under the eaves of houses or their windows or beyond their walls, seeking out private discourse. The awkwardness and undignified manner of this method, as well as its susceptibility to abuse, was immediately recognized. Electricity, however, provided a better vehicle, and, with the advent of the telegraph, surreptitious interception of messages began. As early as 1862, California found it necessary to prohibit the practice by statute. During the Civil War, General J.E.B. Stuart is reputed to have had his own eavesdropper along with him in the field, whose job it was to intercept military communications of the opposing forces. Subsequently, newspapers reportedly raided one another's news-gathering lines to save energy, time, and money. Racing news was likewise intercepted and flashed to bettors before the official result arrived. The telephone brought on a new and more modern eavesdropper known as the wiretapper. Interception was made by a connection with a telephone line. This activity has been with us for 3/4 of a century. Like its cousins, wiretapping proved to be a commercial as well as a police technique. Illinois outlawed it in 1895, and, in 1905, California extended its telegraph interception prohibition to the telephone. Some 50 years ago, a New York legislative committee found that police, in cooperation with the telephone company, had been tapping telephone lines in New York despite an act passed in 1895 prohibiting it. During Prohibition days, wiretaps were the principal source of information relied upon by the police as the basis for prosecutions. In 1934, the Congress outlawed the interception without authorization and the divulging or publishing of the contents of wiretaps by passing Section 605 of the Communications Act of 1934. New York, in 1938, declared by constitutional amendment that the right of the people to be secure against unreasonable interception of telephone and telegraph communications shall not be violated, but it permitted by ex parte order of the Supreme Court of the state the interception of communications on a showing of reasonable ground to believe that evidence of a crime might be obtained. Sophisticated electronic devices have now been developed, commonly known as bugs, which are capable of eavesdropping on anyone in almost any given situation. They are to be distinguished from wiretaps, which are confined to the interception of telegraphic and telephonic communications. Miniature in size, no larger than a postage stamp, these gadgets pick up whispers within a room and broadcast them half a block away to a receiver. It is said that certain types of electronic rays beamed at walls or glass windows are capable of catching voice vibrations as they are bounced off the surfaces. Since 1940, eavesdropping has become a big business. Manufacturing concerns offer complete detection systems which automatically record voices under almost any conditions by remote control. A microphone concealed in a book, a lamp, or other unsuspected place in a room, or made into a fountain pen, tie clasp, lapel button, or cufflink increases the range of these powerful wireless transmitters to a half-mile. Receivers pick up the transmission with interference-free reception on a special wave frequency. And, of late, a combination mirror transmitter has been developed which permits not only sight, but voice transmission up to 300 feet. Likewise, parabolic microphones, which can overhear conversations without being placed within the premises monitored, have been developed. As science developed these detection techniques, lawmakers, sensing the resulting invasion of individual privacy, have provided some statutory protection for the public. 7 states, California, Illinois, Maryland, Massachusetts, Nevada, New York, and Oregon, prohibits surreptitious eavesdropping by mechanical or electronic device. However, All save Illinois permit official court-ordered eavesdropping. Some 36 states prohibit wiretapping. But of these, 27 permit authorized interception of some type. Federal law, as we have seen, prohibits interception and divulging or publishing of the content of wiretaps without exception. In sum, it is fair to say that wiretapping, on the whole, is outlawed, except for permissive use by law enforcement officials in some states, while electronic eavesdropping is, save for 7 states, permitted both officially and privately. And, in 6 of the 7 states, electronic eavesdropping, bugging, is permissible on court order. The law, though jealous of individual privacy, has not kept pace with these advances in scientific knowledge. This is not to say that individual privacy has been relegated to a second-class position, for it has been held since Lord Camden's day that intrusions into it are subversive of all the comforts of society. And the founders so decided a quarter of a century later when they declared in the Fourth Amendment that the people had a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Indeed, that right, they wrote, quote, shall not be violated and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. End of quote. Almost a century thereafter, this court took specific and lengthy notice of Educ v. Carrington, supra, finding that its holding was undoubtedly familiar to, and in the minds of, those who framed the Fourth Amendment, Boyd v. United States. And after quoting from Lord Camden's opinion at some length, Mr. Justice Bradley characterized it thus, quote, the principles laid down in this opinion affect the very essence of constitutional liberty and security. They reach farther than the concrete form of the case. They apply to all invasions on the part of the government and its employees of the sanctity of a man's home and the privacies of life. End of quote. Boyd held unconstitutional an act of the Congress authorizing a court of the United States to require a defendant in a revenue case to produce in court his private books, invoices, and papers, or else the allegations of the government were to be taken as confessed. The court found that the essence of the offense was the invasion of this sacred right which underlies and constitutes the essence of Lord Camden's judgment. The act, the court found, violated the Fourth Amendment in that it authorized a general search contrary to the amendment's guarantee. The amendment, however, carried no criminal sanction, and the federal statutes not affording one, the court in 1914 formulated and pronounced the federal exclusionary rule in Weeks v. United States, prohibiting the use in federal courts of any evidence seized in violation of the amendment. The court held, quote, the effect of the Fourth Amendment is to put the courts of the United States under limitations and restraints as to the exercise of such power, and to forever secure the people against all unreasonable searches and seizures under the guise of law. This protection reaches all alike, whether accused of crime or not, and the duty of giving to it force and effect is obligatory upon all. The tendency of those who execute the criminal laws of the country to obtain conviction by means of unlawful seizures should find no sanction in the judgments of the courts which are charged at all times with the support of the Constitution and to which people of all conditions have a right to appeal for the maintenance of such fundamental rights. End of quote. The court was faced with its first wiretap case in 1928, Olmsted v. United States. There, the interception of Olmsted's telephone line was accomplished without entry upon his premises, and was, therefore, found not to be prescribed by the Fourth Amendment. The basis of the decision was that the Constitution did not forbid the obtaining of evidence by wiretapping unless it involved actual unlawful entry into the house. Statements in the opinion that a conversation passing over a telephone wire cannot be said to come within the Fourth Amendment's enumeration of persons, houses, papers, and effects have been negated by our subsequent cases, as hereinafter noted. They found conversation was within the Fourth Amendment's protections, and that the use of electronic devices to capture it was a search within the meaning of the amendment, and we so hold. In any event, Congress soon thereafter, and some say in answer to Olmsted, specifically prohibited the interception without authorization and the divulging or publishing of the contents of telephonic communications. And the Nardone cases extended the exclusionary rule to wiretap evidence offered in federal prosecutions. The first bugging case reached the court in 1942 in Goldman v. United States. There, the court found that the use of a detectaphone placed against an office wall in order to hear private conversations in the office next door did not violate the Fourth Amendment because there was no physical trespass in connection with the relevant interception. And in Onley v. United States, we found that, since no trespass was committed, a conversation between Lee and a federal agent occurring in the former's laundry and electronically recorded was not condemned by the Fourth Amendment. Thereafter, in Silverman v. United States, the court found that the eavesdropping was accomplished by means of an unauthorized physical penetration into the premises occupied by the petitioners. A spike a foot long with a microphone attached to it was inserted under a baseboard into a party wall until it made contact with the heating duct that ran through the entire house occupied by Silverman, making a perfect sounding board through which the conversations in question were overheard. Significantly, the court held that its decision did, quote, not turn upon the technicality of a trespass upon a party wall as a matter of local law. It is based upon the reality of an actual intrusion into a constitutionally protected area. End of quote. In Wong Sun v. United States, the court for the first time specifically held that verbal evidence may be the fruit of an official illegality under the Fourth Amendment along with the more common tangible fruits of unwarranted intrusion. It used these words, quote, the exclusionary rule has traditionally barred from trial physical, tangible materials obtained either during or as a direct result of an unlawful invasion. It follows from our holding in Silverman v. United States that the Fourth Amendment may protect against the overhearing of verbal statements, as well as against the more traditional seizure of papers and effects. End of quote. And in Lopez v. United States, the court confirmed that it had, quote, in the past sustained instances of electronic eavesdropping against constitutional challenge when devices have been used to enable government agents to overhear conversations which would have been beyond the reach of the human ear. It has been insisted only that the electronic device not be planted by an unlawful physical invasion of a constitutionally protected area. End of quote. In this case, a recording of a conversation between a federal agent and the petitioner in which the latter offered the agent a bribe was admitted in evidence. Rather than constituting eavesdropping, the court found that the recording, quote, was used only to obtain the most reliable evidence possible of a conversation in which the government's own agent was a participant, and which that agent was fully entitled to disclose. End of quote. It is now well settled that the Fourth Amendment's right of privacy has been declared enforceable against the states through the Due Process Clause of the 14th Amendment. Quote, the security of one's privacy against arbitrary intrusion by the police, which is at the core of the Fourth Amendment, is basic to a free society. End of quote. And its fundamental protections are guaranteed against invasion by the states. This right has most recently received enunciation in Camara v. Municipal Court. Quote, the basic purpose of this amendment, as recognized in countless discussions of this court, is to safeguard the privacy and security of individuals against arbitrary invasions by government officials. End of quote. Likewise, the court has decided that, while the standards of reasonableness required under the Fourth Amendment are the same under the 14th, they are not susceptible of Procrustean application. We said there, Kerr v. California, that, quote, the reasonableness of a search is to be determined by the trial court from the facts and circumstances of the case, and in the light of the fundamental criteria laid down by the Fourth Amendment and in the opinions of this court applying that amendment. End of quote. We, therefore, turn to New York statute to determine the basis of the search and seizure authorized by it upon the order of a state Supreme Court justice, a county judge, or general sessions judge of New York County. Section 813A authorizes the issuance of an ex parte order for eavesdropping upon, quote, oath or affirmation of a district attorney or of the attorney general or of an officer above the rank of sergeant of any police department of the state or of any political subdivision thereof." End of quote. The oath must state, quote, "that there is reasonable ground to believe that evidence of a crime may be thus obtained, and particularly describing the person or persons whose communications, conversations, or discussions are to be overheard or recorded, and the purpose thereof, and identifying the particular telephone number or telegraph line involved." End of quote. The judge, quote, "may examine on oath the applicant and any other witness he may produce, and shall testify himself of the existence of reasonable grounds for the granting of such application." End of quote. The order must specify the duration of the eavesdrop, not exceeding 2 months unless extended, and, quote, "any such order together with the papers upon which the application was based shall be delivered to and retained by the applicant as authority for the eavesdropping authorized therein." End of quote. While New York statute satisfies the Fourth Amendment's requirement that a neutral and detached authority be interposed between the police and the public, the broad sweep of the statute is immediately observable. It permits the issuance of the order or warrant for eavesdropping upon the oath of the Attorney General, the District Attorney, or any police officer above the rank of sergeant, stating that there is reasonable ground to believe that evidence of a crime may be thus obtained. Such a requirement raises a serious probable cause question under the Fourth Amendment. Under it, warrants may only issue but, quote, "upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized." End of quote. Probable cause under the Fourth Amendment exists where the facts and circumstances within the affiant's knowledge, and of which he has reasonably trustworthy information, are sufficient unto themselves to warrant a man of reasonable caution to believe that an offense has been or is being committed. It is said, however, by the petitioner, and the state agrees, that the reasonable ground requirement of Section 813A is undisputedly equivalent to the probable cause requirement of the Fourth Amendment. This is indicated by People v. Grossman, reversed on other grounds. Also see People v. Beshany. While we have found no case on the point by New York's highest court, we need not pursue the question further, because we have concluded that the statute is deficient on its face in other respects. Since petitioner clearly has standing to challenge the statute, being indisputably affected by it, we need not consider either the sufficiency of the affidavits upon which the eavesdrop orders were based or the standing of petitioner to attack the search and seizure made thereunder. The Fourth Amendment commands that a warrant issue not only upon probable cause supported by oath or affirmation, but also particularly describing the place to be searched and the persons or things to be seized. New York statute lacks this particularization. It merely says that a warrant may issue on reasonable ground to believe that evidence of a crime may be obtained by the eavesdrop. It lays down no requirement for the particularity in the warrant as to what specific crime has been or is being committed, nor the place to be searched, or the persons or things to be seized, as specifically required by the Fourth Amendment. The need for particularity and evidence of reliability in the showing required when judicial authorization of a search is sought is especially great in the case of eavesdropping. By its very nature, eavesdropping involves an intrusion on privacy that is broad in scope. As was said in Osborne v. United States, the indiscriminate use of such devices in law enforcement raises grave constitutional questions under the Fourth and Fifth Amendments, and imposes a heavier responsibility on this court in its supervision of the fairness of procedures. There, two judges acting jointly authorized the installation of a device on the person of a prospective witness to record conversations between him and an attorney for a defendant then on trial in the United States District Court. The judicial authorization was based on an affidavit of the witness setting out in detail previous conversations between the witness and the attorney concerning the bribery of jurors in the case. The recording device was, as the court said, authorized under the most precise and discriminate circumstances which fully met the requirement of particularity of the Fourth Amendment. The court was asked to exclude the evidence of the recording of the conversations seized pursuant to the order on constitutional grounds, Weeks v. United States, or in the exercise of supervisory power, McNabb v. United States. The court refused to do so, finding that the recording, although an invasion of the privacy protected by the Fourth Amendment, was admissible because of the authorization of the judges, based upon, quote, a detailed factual affidavit alleging the commission of a specific criminal offense directly and immediately affecting the administration of justice, for the narrow and particularized purpose of ascertaining the truth of the affidavit's allegations. End of quote. The invasion was lawful because there was sufficient proof to obtain a search warrant to make the search for the limited purpose outlined in the order of the judges. Through these precise and discriminate procedures, the order authorizing the use of the electronic device afforded similar protections to those that are present in the use of conventional warrants, authorizing the seizure of tangible evidence. Among other safeguards, the order described the type of conversation sought with particularity, thus indicating the specific objective of the government in entering the constitutionally protected area and the limitations placed upon the officer executing the warrant. Under it, the officer could not search unauthorized areas. Likewise, once the property sought and for which the order was issued was found, the officer could not use the order as a passkey to further search. In addition, the order authorized one limited intrusion rather than a series or a continuous surveillance. And we note that a new order was issued when the officer sought to resume the search, and probable cause was shown for the succeeding one. Moreover, the order was executed by the officer with dispatch, not over a prolonged and extended period. In this manner, no greater invasion of privacy was permitted than was necessary under the circumstances. Finally, the officer was required to, and did, make a return on the order showing how it was executed and what was seized. Through these strict precautions, the danger of an unlawful search and seizure was minimized. By contrast, New York statute lays down no such precise and discriminate requirements. Indeed, it authorizes the indiscriminate use of electronic devices as specifically condemned in Osborne. The proceeding by search warrant is a drastic one, and must be carefully circumscribed so as to prevent unauthorized invasions of the sanctity of a man's home and the privacies of life. New York's broadside authorization, rather than being carefully circumscribed so as to prevent unauthorized invasions of privacy, actually permits general searches by electronic devices, the truly offensive character of which was first condemned in Educ v. Carrington, and which were then known as general warrants. The use of the latter was a motivating factor behind the Declaration of Independence. In view of the many cases commenting on the practice, it is sufficient here to point out that, under these general warrants, customs officials were given blanket authority to conduct general searches for goods imported to the colonies in violation of the tax laws of the Crown. The Fourth Amendment's requirement that a warrant particularly describe the place to be searched and the persons or things to be seized repudiated these general warrants and, quote, makes general searches impossible and prevents the seizure of one thing under a warrant describing another. As to what is to be taken, nothing is left to the discretion of the officer executing the warrant. End of quote. We believe the statute here is equally offensive. First, as we have mentioned, eavesdropping is authorized without requiring belief that any particular offense has been or is being committed, nor that the property sought, the conversations, be particularly described. The purpose of the probable cause requirement of the Fourth Amendment, to keep the state out of constitutionally protected areas until it has reason to believe that a specific crime has been or is being committed, is thereby wholly aborted. Likewise, the statute's failure to describe with particularity the conversations sought gives the officer a roving commission to seize any and all conversations. It is true that the statute requires the naming of the person or persons whose communications, conversations, or discussions are to be overheard or recorded, but this does no more than identify the person whose constitutionally protected area is to be invaded, rather than particularly describing the communications, conversations, or discussions to be seized. As with general warrants, this leaves too much to the discretion of the officer executing the order. Secondly, authorization of eavesdropping for a 2-month period is the equivalent of a series of intrusions, searches, and seizures pursuant to a single showing of probable cause. Prompt execution is also avoided. During such a long and continuous, 24 hours a day, period, The conversations of any and all persons coming into the area covered by the device will be seized indiscriminately and without regard to their connection with the crime under investigation. Moreover, the statute permits, and there were authorized here, extensions of the original 2-month period, presumably for 2 months each, on a mere showing that such extension is in the public interest. Apparently, the original grounds on which the eavesdrop order was initially issued also forms the basis of the renewal. This, we believe, is insufficient without a showing of present probable cause for the continuance of the eavesdrop. Third, the statute places no termination date on the eavesdrop once the conversation sought is seized. This is left entirely in the discretion of the officer. Finally, the statute's procedure, necessarily because its success depends on secrecy, has no requirement for notice as do conventional warrants, nor does it overcome this defect by requiring some showing of special facts. On the contrary, it permits unconsented entry without any showing of exigent circumstances. Such a showing of exigency, in order to avoid notice, would appear more important in eavesdropping, with its inherent dangers, than that required when conventional procedures of search and seizure are utilized. Nor does the statute provide for a return on the warrant, thereby leaving full discretion in the officer as to the use of seized conversations of innocent as well as guilty parties. In short, the statute's blanket grant of permission to eavesdrop is without adequate judicial supervision or protective procedures. It is said with fervor that electronic eavesdropping is a most important technique of law enforcement, and that outlawing it will severely cripple crime detection. The monumental report of the President's Commission on Law Enforcement and Administration of Justice, entitled The Challenge of Crime in a Free Society, informs us that the majority of law enforcement officials say that this is especially true in the detection of organized crime. As the Commission reports, there can be no question about the serious proportions of professional criminal activity in this country. However, we have found no empirical statistics on the use of electronic devices, bugging, in the fight against organized crime. Indeed, there are even figures available in the wiretap category which indicate to the contrary. As the Commission points out, quote, wiretapping was the mainstay of the New York attack against organized crime until federal court decisions intervened. Recently, chief reliance in some offices has been placed on bugging, where the information is to be used in court. Law enforcement officials believe that the successes achieved in some parts of the state are attributable primarily to a combination of dedicated and competent personnel and adequate legal tools, and that the failure to do more in New York has resulted primarily from the failure to commit additional resources of time and men, end of quote, rather than electronic devices. Moreover, Brooklyn's District Attorney Silver's poll of the state of New York indicates that, during the 12-year period, 1942 to 1954, duly authorized wiretaps in bribery and corruption cases constituted only a small percentage of the whole. It indicates that this category involved only 10% of the total wiretaps. The overwhelming majority were in the categories of larceny, extortion, coercion, and blackmail, accounting for almost 50%. Organized gambling was about 11%. Statistics are not available on subsequent years. An often repeated statement of District Attorney Hogan of New York County was made at a hearing before the Senate Judiciary Committee, at which he advocated the amendment of the Communications Act of 1934 so as to permit telephonic interception of conversations. As he testified, quote, federal statutory law, the 1934 Act, has been interpreted in such a way as to bar us from divulging wiretap evidence, even in the courtroom in the course of criminal prosecution. End of quote. Mr. Hogan then said that without it, wiretaps, my own office could not have convicted top figures in the underworld. He then named 9 persons his office had convicted and one on whom he had furnished leads secured from wiretaps to the authorities of New Jersey. Evidence secured from wiretaps, as Mr. Hogan said, was not admissible in criminal prosecutions. He was advocating that the Congress adopt a measure that would make it admissible. The President's Commission also emphasizes in its report the need for wiretapping in the investigation of organized crime because of the telephone's relatively free use by those engaged in the business, and the difficulty of infiltrating their organizations. The Congress, though long importuned, has not amended the 1934 Act to permit it. We are also advised by the Solicitor General of the United States that the federal government has abandoned the use of electronic eavesdropping for prosecutorial purposes. Despite these actions of the federal government, there has been no failure of law enforcement in that field. As the Chief Justice said in concurring in the result Lopez v. United States, quote, "The fantastic advances in the field of electronic communication constitute a great danger to the privacy of the individual. Indiscriminate use of such devices in law enforcement raises grave constitutional questions under the Fourth and Fifth Amendments." End of quote. In any event, we cannot forgive the requirements of the Fourth Amendment in the name of law enforcement. This is no formality that we require today, but a fundamental rule that has long been recognized as basic to the privacy of every home in America. While the requirements of the Fourth Amendment are not inflexible or obtusely unyielding to the legitimate needs of law enforcement, it is not asking too much that officers be required to comply with the basic command of the Fourth Amendment, before the innermost secrets of one's home or office are invaded. Few threats to liberty exist which are greater than that posed by the use of eavesdropping devices. Some may claim that, without the use of such devices, crime detection in certain areas may suffer some delays, since eavesdropping is quicker, easier, and more certain. However, techniques and practices may well be developed that will operate just as speedily and certainly, and, what is more important, without attending illegality. It is said that neither a warrant nor a statute authorizing eavesdropping can be drawn so as to meet the Fourth Amendment's requirements. If that be true, then the fruits of eavesdropping devices are barred under the amendment. On the other hand, this court has in the past, under specific conditions and circumstances, sustained the use of eavesdropping devices. In the latter case, the eavesdropping device was permitted where the commission of a specific offense was charged, its use was under the most precise and discriminate circumstances, and the effective administration of justice in a federal court was at stake. The states are under no greater restrictions. The Fourth Amendment does not make the precincts of the home or the office sanctuaries where the law can never reach. But it does prescribe a constitutional standard that must be met before official invasion is permissible. Our concern with the statute here is whether its language permits a trespassory invasion of the home or office by general warrant, contrary to the command of the Fourth Amendment. As it is written, we believe that it does. Reversed. End of section 23.
Section 24 of A Collection of Supreme Court Opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Colleen McMahon. Walz v. Tax Commission of City of New York, 397 U.S. 664. Decided May 4, 1970. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Chief Justice Berger delivered the opinion of the court. Appellant, owner of real estate in Richmond County, New York, sought an injunction in the New York courts to prevent the New York City Tax Commission from granting property tax exemptions to religious organizations for religious properties used solely for religious worship. The exemption from state taxes is authorized by Article 16, Section 1 of the New York Constitution, which provides in relevant part, quote, "Exemptions from taxation may be granted only by general laws. Exemptions may be altered or repealed, except those exempting real or personal property used exclusively for religious, educational, or charitable purposes, as defined by law and owned by any corporation or association organized or conducted exclusively for one or more of such purposes, and not operating for profit." End of quote. Footnote: Article 16, Section 1 of the New York State Constitution is implemented by Section 420, Subdivision 1 of the New York Real Property Tax Law, which states in pertinent part, quote, "Real property owned by a corporation or association organized exclusively for the moral or mental improvement of men and women, or for religious, Bible, tract, charitable, benevolent, missionary, hospital, infirmary, educational, public playground, scientific, literary, bar association, medical society, library, patriotic, historical, or cemetery purposes, and used exclusively for carrying out thereupon one or more of such purposes, shall be exempt from taxation as provided in this section. End of quote. End of footnote. The essence of appellant's contention was that the New York City Tax Commission's grant of an exemption to church property indirectly requires the appellant to make a contribution to religious bodies, and thereby violates provisions prohibiting establishment of religion under the First Amendment, which under the 14th Amendment is binding on the states. Footnote. The First Amendment to the United States Constitution provides in part that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. End of quote. End of footnote. Appellee's motion for summary judgment was granted, and appellate division of the New York Supreme Court and the New York Court of Appeals affirmed. We noted probable jurisdiction and affirm. 1. Prior opinions of this court have discussed the development and historical background of the First Amendment in detail. See Everson v. Board of Education, Engel v. Vitale. It would therefore serve no useful purpose to review in detail the background of the establishment and free exercise clauses of the First Amendment, or to restate what the court's opinions have reflected over the years. It is sufficient to note that for the men who wrote the religion clauses of the First Amendment, the, quote, establishment, end of quote, of a religion connoted sponsorship, financial support, and active involvement of the sovereign in religious activity. In England, and in some colonies at the time of the separation in 1776, the Church of England was sponsored and supported by the Crown as a state or established church. In other countries, quote, establishment, end of quote, meant sponsorship by the sovereign of the Lutheran or Catholic Church. The exclusivity of established churches in the 17th and 18th centuries, of course, was often carried to prohibition of other forms of worship. The establishment and free exercise clauses of the First Amendment are not the most precisely drawn portions of the Constitution. The sweep of the absolute prohibitions in the religion clauses may have been calculated, but the purpose was to state an objective, not to write a statute. In attempting to articulate the scope of the two religion clauses, the court's opinions reflect the limitations inherent in formulating general principles on a case-by-case basis. The considerable internal inconsistency in the opinions of the court derives from what in retrospect may have been too sweeping utterances on aspects of these clauses that seemed clear in relation to the particular cases, but have limited meaning as general principles. The court has struggled to find a neutral course between the two religion clauses, both of which are cast in absolute terms, and either of which, if expanded to a logical extreme, would tend to clash with the other. For example, in Zorach v. Clausen, Mr. Justice Douglas, writing for the court, noted, quote, the First Amendment, however, does not say that in every and all respects there shall be a separation of church and state. End of quote. Quote, we sponsor an attitude on the part of the government that shows no partiality to any one group, and that lets each flourish according to the zeal of its adherents and the appeal of its dogma. End of quote. Mr. Justice Harlan expressed something of this in his dissent in Sherbert v. Werner, saying that the constitutional neutrality imposed on us, quote, is not so narrow a channel that the slightest deviation from an absolutely straight course leads to condemnation. End of quote. The course of constitutional neutrality in this area cannot be an absolutely straight line. Rigidity could well defeat the basic purpose of these provisions, which is to ensure that no religion be sponsored or favored, none commanded, and none inhibited. The general principle deducible from the First Amendment and all that has been said by the court is this, that we will not tolerate either governmentally established religion or governmental interference with religion. Short of these expressly proscribed governmental acts, there is room for play in the joints, productive of a benevolent neutrality which will permit religious exercise to exist without sponsorship and without interference. Each value judgment under the religion clauses must therefore turn on whether particular acts in question are intended to establish or interfere with religious beliefs and practices, or have the effect of doing so. Adherence to the policy of neutrality that derives from an accommodation of the establishment and free exercise clauses has prevented the kind of involvement that would tip the balance toward government control of churches, or governmental restraint on religious practice. Adherents of particular faiths and individual churches frequently take strong positions on public issues, including, as this case reveals in the several briefs amici, vigorous advocacy of legal or constitutional positions. Of course, churches, as much as secular bodies and private citizens, have that right. No perfect or absolute separation is really possible. The very existence of the religion clauses is an involvement of sorts, one that seeks to mark boundaries to avoid excessive entanglement. The hazards of placing too much weight on a few words or phrases of the court is abundantly illustrated within the pages of the court's opinion in Everson. Mr. Justice Black, writing for the court's majority, said the First Amendment, quote, means at least this: neither a state nor the federal government can pass laws which aid one religion, aid all religions, or prefer one religion over another. End of quote. Yet he had no difficulty in holding that, quote, measured by these standards, we cannot say that the First Amendment prohibits New Jersey from spending tax-raised funds to pay the bus fares of parochial school pupils as a part of a general program under which it pays the fares of pupils attending public and other schools. It is undoubtedly true that children are helped to get to church schools. There's even a possibility that some of the children might not be sent to the church schools if the parents were compelled to pay their children's bus fares out of their own pockets. End of quote. The court did not regard such, quote, aid, end of quote, to schools teaching a particular religious faith as any more a violation of the Establishment Clause than providing, quote, state-paid policemen detailed to protect children at the schools from the very real hazards of traffic, end of quote. Mr. Justice Jackson, in perplexed dissent in Everson, noted that, quote, the undertones of the opinion, advocating complete and uncompromising separation, seem utterly discordant with its conclusion, end of quote. Perhaps so. One can sympathize with Mr. Justice Jackson's logical analysis, but agree with the court's eminently sensible and realistic application of the language of the Establishment Clause. In Everson, the court declined to construe the religion clauses with a literalness that would undermine the ultimate constitutional objective as illuminated by history. Surely, bus transportation and police protection to pupils who receive religious instruction, quote, aid, end of quote, that particular religion to maintain schools that plainly tend to assure future adherence to a particular faith by having control of their total education at an early age. No religious body that maintains schools would deny this as an affirmative, if not dominant, policy of church schools. But if, as in Everson, buses can be provided to carry and policemen to protect church school pupils, we fail to see how a broader range of police and fire protection given equally to all churches, along with nonprofit hospitals, art galleries, and libraries receiving the same tax exemption, is different for purposes of the religion clauses. Similarly, making textbooks available to pupils in parochial schools in common with public schools was surely an, quote, aid, end of quote, to the sponsoring churches, because it relieved those churches of an enormous aggregate cost for those books. Supplying of costly teaching materials was not seen either as manifesting a legislative purpose to aid or as having a primary effect of aid contravening the First Amendment. In so holding, the court was heeding both its own prior decisions and our religious tradition. Mr. Justice Douglas, in Zorak v. Clausen, supra, after recalling that we, quote, are a religious people whose institutions presuppose a supreme being, end of quote, went on to say, quote, we make room for as wide a variety of beliefs and creeds as the spiritual needs of man deem necessary. When the state encourages religious instruction, it follows the best of our traditions. for it then respects the religious nature of our people and accommodates the public service to their spiritual needs." End of quote. With all the risks inherent in programs that bring about administrative relationships between public education bodies and church-sponsored schools, we have been able to chart a course that preserved the autonomy and freedom of religious bodies while avoiding any semblance of established religion. This is a, quote, tightrope, end of quote, and one we have successfully traversed. 2. The legislative purpose of the property tax exemption is neither the advancement nor the inhibition of religion. It is neither sponsorship nor hostility. New York, in common with the other states, has determined that certain entities that exist in a harmonious relationship to the community at large, and that foster its, quote, moral or mental improvement, end of quote, should not be inhibited in their activities by property taxation or the hazard of loss of those properties for non-payment of taxes. It has not singled out one particular church or religious group, or even churches as such. Rather, it has granted exemption to all houses of religious worship within a broad class of property owned by non-profit, quasi-public corporations, which include hospitals, libraries, playgrounds, scientific, professional, historical, and patriotic groups. The state has an affirmative policy that considers these groups as beneficial and stabilizing influences in community life and finds this classification useful, desirable, and in the public interest. Qualification for tax exemption is not perpetual or immutable. Some tax-exempt groups lose that status when their activities take them outside the classification, and new entities can come into being and qualify for exemption. Governments have not always been tolerant of religious activity, and hostility toward religion has taken many shapes and forms, economic, political, and sometimes harshly oppressive. Grants of exemption historically reflect the concern of authors of constitutions and statutes as to the latent dangers inherent in the imposition of property taxes. Exemption constitutes a reasonable and balanced attempt to guard against those dangers. The limits of permissible state accommodations to religion are by no means coextensive with the non-interference mandated by the Free Exercise Clause. To equate the two would be to deny a national heritage with roots in the Revolution itself. We cannot read New York statute as attempting to establish religion. It is simply sparing the exercise of religion from the burden of property taxation levied on private profit institutions. We find it unnecessary to justify the tax exemption on the social welfare services or, quote, good works, end of quote, that some churches perform for parishioners and others, family counseling, aid to the elderly and the infirm, and to children. Churches vary substantially in the scope of such services. Programs expand or contract according to resources and need. As public-sponsored programs enlarge, private aid from the church sector may diminish. The extent of social services may vary, depending on whether the church serves an urban or rural, a rich or poor constituency. To give emphasis to so variable an aspect of the work of religious bodies would introduce an element of governmental evaluation and standards as to the worth of particular social welfare programs, thus producing a kind of continuing day-to-day relationship which the policy of neutrality seeks to minimize. Hence, the use of a social welfare yardstick as a significant element to qualify for tax exemption could conceivably give rise to confrontations that could escalate to constitutional dimensions. Determining that the legislative purpose of tax exemption is not aimed at establishing, sponsoring, or supporting religion does not end the inquiry, however. We must also be sure that the end result, the effect, is not an excessive government entanglement with religion. The test is inescapably one of degree. Either course, taxation of churches or exemption, occasions some degree of involvement with religion. Elimination of exemption would tend to expand the involvement of government by giving rise to tax valuation of church property, tax liens, tax foreclosures, and the direct confrontations and conflicts that follow in the train of those legal processes. Granting tax exemptions to churches necessarily operates to afford an indirect economic benefit, and also gives rise to some, but yet a lesser, involvement than taxing them. In analyzing either alternative, the questions are whether the involvement is excessive, and whether it is a continuing one calling for official and continuing surveillance, leading to an impermissible degree of entanglement. Obviously, a direct money subsidy would be a relationship pregnant with involvement, and, as with most governmental grant programs, could encompass sustained and detailed administrative relationships for enforcement of statutory or administrative standards, but that is not this case. The hazards of churches supporting government are hardly less in their potential than the hazards of government supporting churches. Footnote: the support of religion with direct allocation of public revenue was a common colonial practice. A general assessment proposed in the Virginia legislature in 1784 prompted the writing of James Madison's Remonstrance. Governmental support of religion is common in many countries. End of footnote. Each relationship carries some involvement rather than the desired insulation and separation. We cannot ignore the instances in history when church support of government led to the kind of involvement we seek to avoid. The grant of a tax exemption is not sponsorship, since the government does not transfer part of its revenue to churches, but simply abstains from demanding that the church support the state. No one has ever suggested that tax exemption has converted libraries, art galleries, or hospitals into arms of the state, or put employees, quote, on the public payroll, end of quote. There is no genuine nexus between tax exemption and establishment of religion. As Mr. Justice Holmes commented in a related context, quote, a page of history is worth a volume of logic, end of quote. The exemption creates only a minimal and remote involvement between church and state, and far less than taxation of churches. It restricts the fiscal relationship between church and state and tends to complement and reinforce the desired separation, insulating each from the other. Separation in this context cannot mean absence of all contact. The complexities of modern life inevitably produce some contact, and the fire and police protection received by houses of religious worship are no more than incidental benefits accorded all persons or institutions within a state's boundaries, along with many other exempt organizations. The appellant has not established even an arguable quantitative correlation between the payment of an ad valorem property tax and the receipt of these municipal benefits. All of the 50 states provide for tax exemption of places of worship, most of them doing so by constitutional guarantees. For so long as federal income taxes have had any potential impact on churches, over 75 years, religious organizations have been expressly exempt from the tax. Footnote: following passage of the 16th Amendment, federal income tax acts have consistently exempted corporations and associations organized and operated exclusively for religious purposes, along with eleemosynary groups, from payment of the tax. End of footnote. Such treatment is a, quote, aid, end of quote, to churches no more and no less in principle than the real estate tax exemption granted by states. Few concepts are more deeply embedded in the fabric of our national life, beginning with pre-revolutionary colonial times, than for the government to exercise, at the very least, this kind of benevolent neutrality toward churches and religious exercise generally, so long as none was favored over others and none suffered interference. It is significant that Congress, from its earliest days, has viewed the religion clauses of the Constitution as authorizing statutory real estate tax exemption to religious bodies. In 1802, the 7th Congress enacted a taxing statute for the county of Alexandria, adopting the 1800 Virginia statutory pattern which provided tax exemptions for churches. Footnote: in 1798, Congress passed an act to provide for the valuation of lands and dwelling houses. All existing state exemptions were expressly excluded from the aforesaid valuation and enumeration. Subsequent levies of direct taxes expressly or impliedly incorporated existing state exemptions. End of footnote. As early as 1813, the 12th Congress refunded import duties paid by religious societies on the importation of religious articles. Footnote: See 6 Statute 116, 1813, relating to plates for printing Bibles. See also 6 Statute 346, 1826, relating to church vestments, furniture, and paintings. 6 Statute 162, 1816, Bible plates. 6 Statute 600, 1834, and 6 Statute 675, 1836, church bells. End of footnote. During this period, the City Council of Washington, D.C., acting under congressional authority, enacted a series of real and personal property assessments that uniformly exempted church property. In 1870, the Congress specifically exempted all churches in the District of Columbia and appurtenant grounds and property, quote, from any and all taxes or assessments, national, municipal, or county, end of quote. Footnote. Subsequent acts of Congress carried over the substance of the exemption. End of footnote. It is obviously correct that no one acquires a vested or protected right in violation of the Constitution by long use, even when that span of time covers our entire national existence and indeed predates it. Yet an unbroken practice of according the exemption to churches, openly and by affirmative state action, not covertly or by state inaction, is not something to be lightly cast aside. Nearly 50 years ago, Mr. Justice Holmes stated, quote, if a thing has been practiced for 200 years by common consent, it will need a strong case for the 14th Amendment to affect it. End of quote. Nothing in this national attitude toward religious tolerance and 2 centuries of uninterrupted freedom from taxation has given the remotest sign of leading to an established church or religion, and, on the contrary, it has operated affirmatively to help guarantee the free exercise of all forms of religious belief. Thus, it is hardly useful to suggest that tax exemption is but the, quote, foot in the door, end of quote, or the, quote, nose of the camel in the tent, end of quote, leading to an established church. If tax exemption can be seen as this first step toward, quote, establishment, end of quote, of religion, as Mr. Justice Douglas fears, the second step has been long in coming. Any move that realistically, quote, establishes, end of quote, a church, or tends to do so can be dealt with, quote, while this court sits, end of quote. Mr. Justice Cardozo commented in The Nature of the Judicial Process on the, quote, tendency of a principle to expand itself to the limit of its logic, end of quote. Such expansion must always be contained by the historical frame of reference of the principle's purpose, and there is no lack of vigilance on this score by those who fear religious entanglement in government. The argument that making, quote, fine distinctions, end of quote, between what is and what is not absolute under the Constitution is to render us a government of men, not laws, gives too little weight to the fact that it is an essential part of adjudication to draw distinctions, including fine ones, in the process of interpreting the Constitution. We must frequently decide, for example, what are, quote, reasonable, end of quote, searches and seizures under the Fourth Amendment. Determining what acts of government tend to establish or interfere with religion falls well within what courts have long been called upon to do in sensitive areas. It is interesting to note that while the precise question we now decide has not been directly before the court previously, the broad question was discussed by the court in relation to real estate taxes assessed nearly a century ago on land owned by and adjacent to a church in Washington, D.C. At that time, Congress granted real estate tax exemptions to buildings devoted to art, to institutions of public charity, libraries, cemeteries, and, quote, church buildings and grounds actually occupied by such buildings, end of quote. In denying tax exemption as to land owned by but not used for the church, but rather to produce income, the church concluded, quote, in the exercise of this taxing power, Congress, like any state legislature unrestricted by constitutional provisions, may, at its discretion, wholly exempt certain classes of property from taxation, or may tax them at a lower rate than other property. End of quote. It appears that at least up to 1885, this court, reflecting more than a century of our history and uninterrupted practice, accepted without discussion the proposition that federal or state grants of tax exemption to churches were not a violation of the religion clauses of the First Amendment. As to the New York statute, we now confirm that view. Affirmed. End of Section 24. Recording by Colleen McMahon. Section 25 of A Collection of Supreme Court Opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Colleen McMahon. Roe v. Wade, 410 U.S. 113, decided January 2, 1973. Part 1. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Blackmun delivered the opinion of the court. This Texas federal appeal and its Georgia companion, Doe v. Bolton, post, present constitutional challenges to state criminal abortion legislation. The Texas statutes under attack here are typical of those that have been in effect in many states for approximately a century. The Georgia statutes, in contrast, have a modern cast and are a legislative product that, to an extent at least, obviously reflects the influences of recent attitudinal change, of advancing medical knowledge and techniques, and of new thinking about an old issue. We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes toward life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions about abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. Our task, of course, is to resolve the issue by constitutional measurement, free of emotion and of predilection. We seek earnestly to do this, and because we do, we have inquired into, and in this opinion place some emphasis upon, medical and medical legal history, and what that history reveals about man's attitudes toward the abortion procedure over the centuries. We bear in mind, too, Mr. Justice Holmes' admonition in his now vindicated dissent in Lochner v. New York. Quote, "The Constitution is made for people of fundamentally differing views, and the accident of our finding certain opinions natural and familiar or novel and even shocking ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States." End of quote. The Texas statutes that concern us here are Articles 1191 through 1194 and 1196 of the state's Penal Code. Footnote: Article 1191, Abortion. If any person shall designedly administer to a pregnant woman, or knowingly procure to be administered with her consent any drug or medicine, or shall use towards her any violence or means whatever externally or internally applied, and thereby procure an abortion, he shall be confined in the penitentiary not less than 2, nor more than 5 years. If it be done without her consent, the punishment shall be doubled. By abortion is meant that the life of the fetus or embryo shall be destroyed in the woman's womb, or that a premature birth thereof be caused. Article 1192, Furnishing the means. Whoever furnishes the means for procuring an abortion, knowing the purpose intended, is guilty as an accomplice. Article 1193, Attempt at abortion. If the means used shall fail to produce an abortion, the offender is nevertheless guilty of an attempt to produce abortion, provided it be shown that such means were calculated to produce that result, and shall be fined not less than $100 nor more than $1,000. Article 1194, Murder in producing abortion. If the death of the mother is occasioned by an abortion so produced, or by an attempt to effect the same, it is murder. Article 1196. Nothing in this chapter applies to an abortion procured or attempted by medical advice for the purpose of saving the life of the mother. The foregoing articles, together with Article 1195, compose Chapter 9 of Title 15 of the Penal Code. Article 1195, not attacked here, reads, Article 1195, Destroying Unborn Child. Whoever shall, during parturition of the mother, destroy the vitality or life in a child in a state of being born and before actual birth, which child would otherwise have been born alive, shall be confined in the penitentiary for life or for not less than 5 years. End of footnote. These make it a crime to, quote, procure an abortion, end of quote, as therein defined, or to attempt one, except with respect to, quote, an abortion procured or attempted by medical advice for the purpose of saving the life of the mother, end of quote. Similar statutes are in existence in a majority of the states. Texas first enacted a criminal abortion statute in 1854. This was soon modified into language that has remained substantially unchanged to the present time. The final article in each of these compilations provided the same exception, as does the present Article 1196, for an abortion by, quote, medical advice for the purpose of saving the life of the mother, end of quote. Footnote. Long ago, a suggestion was made that the Texas statutes were unconstitutionally vague because of definitional deficiencies. The Texas Court of Criminal Appeals disposed of that suggestion peremptorily, saying only, quote, it is also insisted in the motion in arrest of judgment that the statute is unconstitutional and void, in that it does not sufficiently define or describe the offense of abortion. We do not concur in respect to this question. End of quote. The same court recently has held again that the state's abortion statutes are not unconstitutionally vague or overbroad. The court held that, quote, the state of Texas has a compelling interest to protect fetal life, end of quote. That Article 1191, quote, is designed to protect fetal life, end of quote. That the Texas homicide statutes, particularly Article 1205 of the Penal Code, are intended to protect a person, quote, in existence by actual birth, end of quote, and thereby implicitly recognize other human life that is not, quote, in existence by actual birth, end of quote. That the definition of human life is for the legislature and not the courts. That Article 1196, quote, is more definite than the District of Columbia statute upheld in United States versus Village, end of quote, and that the Texas statute, quote, is not vague and indefinite or overbroad, end of quote. A physician's abortion conviction was affirmed. In Thompson, the court observed that any issue as to the burden of proof under the exemption of Article 1196, quote, is not before us, end of quote. End of footnote. 2. Jane Roe. Footnote. The name is a pseudonym. End of footnote. A single woman who was residing in Dallas County, Texas, instituted this federal action in March 1970 against the district attorney of the county. She sought a declaratory judgment that the Texas criminal abortion statutes were unconstitutional on their face and an injunction restraining the defendant from enforcing the statutes. Roe alleged that she was unmarried and pregnant, that she wished to terminate her pregnancy by an abortion, quote, performed by a competent licensed physician under safe clinical conditions, end of quote, that she was unable to get a legal abortion in Texas because her life did not appear to be threatened by the continuation of her pregnancy, and that she could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions. She claimed that the Texas statutes were unconstitutionally vague and that they abridged her right of personal privacy, protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. By an amendment to her complaint, Roe purported to sue, quote, on behalf of herself and all other women, end of quote, similarly situated. James Hubert Halford, a licensed physician, sought and was granted leave to intervene in Roe's action. In his complaint, he alleged that he had been arrested previously for violations of the Texas abortion statutes, and that 2 such prosecutions were pending against him. He described conditions of patients who came to him seeking abortions, and he claimed that for many cases he, as a physician, was unable to determine whether they fell within or outside the exception recognized by Article 1196. He alleged that, as a consequence, the statutes were vague and uncertain, in violation of the 14th Amendment, and that they violated his own and his patient's rights to privacy in the doctor-patient relationship, and his own right to practice medicine, rights he claimed were guaranteed by the 1st, 4th, 5th, 9th, and 14th Amendments. John and Mary Doe, footnote, these names are pseudonyms, end of footnote, a married couple, filed a companion complaint to that of Roe. They also named the district attorney as defendant, claimed like constitutional deprivations, and sought declaratory and injunctive relief. The Does alleged that they were a childless couple, that Mrs. Doe was suffering from a, quote, neurochemical, end of quote, disorder, that her physician had, quote, advised her to avoid pregnancy until such time as her condition was materially improved, end of quote, although a pregnancy at the present time would not present, quote, a serious risk, end of quote, to her life, that, pursuant to medical advice, she had discontinued use of birth control pills, and that, if she should become pregnant, she would want to terminate the pregnancy by an abortion performed by a competent licensed physician under safe clinical conditions. By an amendment to their complaint, the Does purported to sue, quote, on behalf of themselves and all couples similarly situated, end of quote. The two actions were consolidated and heard together by a duly convened 3-judge district court. The suits thus presented the situations of the pregnant single woman, the childless couple, with the wife not pregnant, and the licensed practicing physician, all joining in the attack on the Texas criminal abortion statutes. Upon the filing of affidavits, motions were made for dismissal and for summary judgment. The court held that Roe and members of her class and Dr. Halford had standing to sue and presented justiciable controversies, but that the Does had failed to allege facts sufficient to state a present controversy and did not have standing. It concluded that, with respect to the request for a declaratory judgment, abstention was not warranted. On the merits, the district court held that the, quote, fundamental right of single women and married persons to choose whether to have children is protected by the 9th Amendment through the 14th Amendment, end of quote, and that the Texas criminal abortion statutes were void on their face because they were both unconstitutionally vague and constituted an overbroad infringement of the plaintiff's 9th Amendment rights. The court then held that abstention was warranted with respect to the request for an injunction. It therefore dismissed the Doe's complaint, declared the abortion statutes void, and dismissed the application for injunctive relief. The plaintiffs Roe and Doe and the intervener Halford, pursuant to 28 U.S.C. section 1253, have appealed to this court from that part of the district court's judgment denying the injunction. The defendant district attorney has purported to cross-appeal, pursuant to the same statute, from the court's grant of declaratory relief to Roe and Halford. Both sides also have taken protective appeals to the United States Court of Appeals for the Fifth Circuit. That court ordered the appeals held in abeyance pending decision here. We postponed decision on jurisdiction to the hearing on the merits. It might have been preferable if the defendant, pursuant to our Rule 20, had presented to us a petition for certiorari before judgment in the Court of Appeals with respect to the granting of the plaintiff's prayer for declaratory relief. Our decisions in Mitchell v. Donovan and Gunn v. University Committee are to the effect that Section 1253 does not authorize an appeal to this court from the grant or denial of declaratory relief alone. We conclude, nevertheless, that those decisions do not foreclose our review of both the injunctive and the declaratory aspects of a case of this kind when it is properly here, as this one is, on appeal under 1253 from specific denial of injunctive relief, and the arguments as to both aspects are necessarily identical. It would be destructive of time and energy for all concerned were we to rule otherwise. 4. We are next confronted with issues of justiciability, standing, and abstention. Have Roe and the Does established that, quote, personal stake in the outcome of the controversy, end of quote, that ensures that, quote, the dispute sought to be adjudicated will be presented in an adversary context and in a form historically viewed as capable of judicial resolution, end of quote. And what effect did the pendency of criminal abortion charges against Dr. Halford in state court have upon the propriety of the federal courts granting relief to him as a plaintiff intervener? A. Jane Roe. Despite the use of the pseudonym, no suggestion is made that Roe is a fictitious person. For purposes of her case, we accept as true and as established her existence, her pregnant state as of the inception of her suit in March 1970, and as late as May 21st of that year, when she filed an alias affidavit with the district court, and her inability to obtain a legal abortion in Texas. Viewing Roe's case as of the time of its filing and thereafter until as late as May, there can be little dispute that it then presented a case or controversy, and that wholly apart from the class aspects, she, as a pregnant single woman, thwarted by the Texas criminal abortion laws, had standing to challenge those statutes. Indeed, we do not read the appellee's brief as really asserting anything to the contrary. The, quote, logical nexus between the status asserted and the claims sought to be adjudicated, end of quote, and the necessary degree of contentiousness are both present. The appellee notes, however, that the record does not disclose that Roe was pregnant at the time of the district court hearing on May 22, 1970, or on the following June 17th when the court's opinion and judgment were filed. And he suggests that Roe's case must now be moot because she and all other members of her class are no longer subject to any 1970 pregnancy. The usual rule in federal cases is that an actual controversy must exist at stages of appellate or certiorari review, and not simply at the date the action is initiated. But when, as here, pregnancy is a significant fact in the litigation, the normal 266-day human gestation period is so short that the pregnancy will come to term before the usual appellate process is complete. If that termination makes a case moot, pregnancy litigation seldom will survive much beyond the trial stage, and appellate review will be effectively denied. Our law should not be that rigid. Pregnancy often comes more than once to the same woman, and in the general population, if man is to survive, it will always be with us. Pregnancy provides a classic justification for a conclusion of non-mootness. It truly could be, quote, capable of repetition, yet evading review, end of quote. We therefore agree with the district court that Jane Roe had standing to undertake this litigation, that she presented a justiciable controversy, and that the termination of her 1970 pregnancy has not rendered her case moot. B. Dr. Halford. The doctor's position is different. He entered Roe's litigation as a plaintiff intervener, alleging in his complaint that he, quote, in the past has been arrested for violating the Texas abortion laws, and at the present time stands charged by indictment with violating said laws in the Criminal District Court of Dallas County, Texas, to wit, 1. The State of Texas versus James H. Halford, number C6953071H, and 2. The State of Texas versus James H. Halford, number C692524H. In both cases, the defendant is charged with abortion. End of quote. In his application for leave to intervene, the doctor made like representations as to the abortion charges pending in the state court. These representations were also repeated in the affidavit he executed and filed in support of his motion for summary judgment. Dr. Halford is, therefore, in the position of seeking in a federal court declaratory and injunctive relief with respect to the same statutes under which he stands charged in criminal prosecutions simultaneously pending in state court. Although he stated that he has been arrested in the past for violating the state's abortion laws, he makes no allegation of any substantial and immediate threat to any federally protected right that cannot be asserted in his defense against the state prosecutions. Neither is there any allegation of harassment or bad faith prosecution. In order to escape the rule articulated in the cases cited in the next paragraph of this opinion, that absent harassment and bad faith, a defendant in a pending state criminal case cannot affirmatively challenge in federal court the statutes under which the state is prosecuting him, Dr. Halford seeks to distinguish his status as a present state defendant from his status as a, quote, potential future defendant, end of quote, and to assert only the latter for standing purposes here. We see no merit in that distinction. Our decision in Samuels v. Mackle compels the conclusion that the district court erred when it granted declaratory relief to Dr. Halford instead of refraining from so doing. The court, of course, was correct in refusing to grant injunctive relief to the doctor. The reasons supportive of that action, however, are those expressed in Samuels v. Mackle, supra, and in Younger v. Harris, Boyle v. Landry, Perez v. Ledesma, and Byrne v. Carleas. See also Dombrowski v. Pfister. We note in passing that Younger and its companion cases were decided after the three-judge district court decision in this case. Dr. Halford's complaint and intervention, therefore, is to be dismissed. Footnote: we need not consider what different result, if any, would follow if Dr. Halford's intervention were on behalf of a class. His complaint and intervention does not purport to assert a class suit and makes no reference to any class apart from an allegation that he, quote, and others similarly situated, end of quote, must necessarily guess at the meaning of Article 1196. His application for leave to intervene goes somewhat further, for it asserts that Plaintiff Rowe does not adequately protect the interest of the doctor, quote, and the class of people who are physicians, and the class of people who are patients, end of quote. The leave application, however, is not the complaint. Despite the district court's statement to the contrary, we fail to perceive the essentials of a class suit in the Halford complaint. End of footnote. He is remitted to his defenses in the state criminal proceedings against him. We reverse the judgment of the district court insofar as it granted Dr. Halford relief and failed to dismiss his complaint and intervention. C. The Does. In view of our ruling as to Rowe's standing in her case, the issue of the Does' standing in their case has little significance. The claims they assert are essentially the same as those of Rowe, and they attack the same statutes. Nevertheless, we briefly note the Does' posture. Their pleadings present them as a childless married couple, the woman not being pregnant, who have no desire to have children at this time because of their having received medical advice that Mrs. Doe should avoid pregnancy, and for, quote, other highly personal reasons, end of quote. But they, quote, fear they may face the prospect of becoming parents, end of quote. And if pregnancy ensues, they, quote, would want to terminate, end of quote, it by an abortion. They assert an inability to obtain an abortion legally in Texas, and consequently the prospect of obtaining an illegal abortion there, or of going outside Texas to some place where the procedure could be obtained legally and competently. We thus have as plaintiffs a married couple who have, as their asserted immediate and present injury, only an alleged, quote, detrimental effect upon their marital happiness, end of quote, because they are forced to, quote, the choice of refraining from normal sexual relations or of endangering Mary Doe's health through a possible pregnancy, end of quote. Their claim is that sometime in the future, Mrs. Doe might become pregnant because of possible failure of contraceptive measures, and at that time in the future, she might want an abortion that might then be illegal under the Texas statutes. The very phrasing of the Doe's position reveals its speculative character. Their alleged injury rests on possible future contraceptive failure, possible future pregnancy, possible future unpreparedness for parenthood, and possible future impairment of health. Any one or more of these several possibilities may not take place, and all may not combine. In the Doe's estimation, these possibilities might have some real or imagined impact upon their marital happiness, but we are not prepared to say that the bare allegation of so indirect an injury is sufficient to present an actual case or controversy. The Doe's claim falls far short of those resolved otherwise in the cases that the Doe's urge upon us, namely Investment Company Institute v. Camp, Data Processing Service v. Camp, and Epperson v. Arkansas. See also Truax v. Raich. The Doe's, therefore, are not appropriate plaintiffs in this litigation. Their complaint was properly dismissed by the district court, and we affirm that dismissal. 5. The principal thrust of the appellant's attack on the Texas statutes is that they improperly invade a right said to be possessed by the pregnant woman to choose to terminate her pregnancy. Appellant would discover this right in the concept of personal liberty embodied in the 14th Amendment's Due Process Clause, or in personal, marital, familial, and sexual privacy said to be protected by the Bill of Rights or its penumbras, or among those rights reserved to the people by the Ninth Amendment. Before addressing this claim, we feel it desirable briefly to survey, in several aspects, the history of abortion, for such insight as that history may afford us, and then to examine the state purposes and interests behind the criminal abortion laws. 6. It perhaps is not generally appreciated that the restrictive criminal abortion laws in effect in a majority of states today are of relatively recent vintage. Those laws generally prescribing abortion or its attempt at any time during pregnancy except when necessary to preserve the pregnant woman's life are not of ancient or even of common law origin. Instead, they derive from statutory changes effected for the most part in the latter half of the 19th century. 1. Ancient attitudes. These are not capable of precise determination. We are told that at the time of the Persian Empire, abortifacients were known, and that criminal abortions were severely punished. We are also told, however, that abortion was practiced in Greek times as well as in the Roman era, and that, quote, it was resorted to without scruple, end of quote. The Ephesian, Cyranous, often described as the greatest of the ancient gynecologists, appears to have been generally opposed to Rome's prevailing free abortion practices. He found it necessary to think first of the life of the mother, and he resorted to abortion when upon this standard he felt the procedure advisable. Greek and Roman law afforded little protection to the unborn. If abortion was prosecuted in some places, it seems to have been based on a concept of a violation of the father's right to his offspring. Ancient religion did not bar abortion. 2. The Hippocratic Oath. What then of the famous oath that has stood so long as the ethical guide of the medical profession, and that bears the name of the great Greek, 460 to 377 BC, who has been described as the father of medicine, the, quote, wisest and the greatest practitioner of his art, end of quote, and the, quote, most important and most complete medical personality of antiquity, end of quote, who dominated the medical schools of his time, and who typified the sum of the medical knowledge of the past. The oath varies somewhat according to the particular translation, but in any translation the content is clear. Quote, I will give no deadly medicine to anyone if asked, nor suggest any such counsel, and in like manner I will not give to a woman a pessary to produce abortion, end of quote, or, quote, I will neither give a deadly drug to anybody if asked for it, nor will I make a suggestion to this effect. Similarly, I will not give to a woman an abortive remedy, end of quote. Although the oath is not mentioned in any of the principal briefs in this case or in Doe v. Bolton, it represents the apex of the development of strict ethical concepts in medicine, and its influence endures to this day. Why did not the authority of Hippocrates dissuade abortion practice in his time and that of Rome? The late Dr. Edelstein provides us with a theory. The oath was not uncontested even in Hippocrates' day. Only the Pythagorean school of philosophers frowned upon the related act of suicide. Most Greek thinkers, on the other hand, commended abortion, at least prior to viability. For the Pythagoreans, however, it was a matter of dogma. For them, the embryo was animate from the moment of conception, and abortion meant destruction of a living being. The abortion clause of the oath, therefore, quote, echoes Pythagorean doctrines, end of quote, and, quote, in no other stratum of Greek opinion were such views held or proposed in the same spirit of uncompromising austerity, end of quote. Dr. Edelstein then concludes that the oath originated in a group representing only a small segment of Greek opinion, and that it certainly was not accepted by all ancient physicians. He points out that medical writings down to Galen, AD 130 to 200, quote, give evidence of the violation of almost every one of its injunctions, end of quote. But with the end of antiquity, a decided change took place. Resistance against suicide and against abortion became common. The oath came to be popular. The emerging teachings of Christianity were in agreement with the Pythagorean ethic. The oath, quote, became the nucleus of all medical ethics, end of quote, and, quote, was applauded as the embodiment of truth, end of quote. Thus, suggests Dr. Edelstein, it is, quote, a Pythagorean manifesto, and not the expression of an absolute standard of medical conduct, end of quote. This, it seems to us, is a satisfactory and acceptable explanation of the Hippocratic Oath's apparent rigidity. It enables us to understand, in historical context, a long accepted and revered statement of medical ethics. 3. The common law. It is undisputed that at common law, abortion performed before, quote, quickening, end of quote, the first recognizable movement of the fetus in utero appearing usually from the 16th to the 18th week of pregnancy, was not an indictable offense. The absence of a common law crime for pre-quickening abortion appears to have developed from a confluence of earlier philosophical, theological, and civil and canon law concepts of when life begins. These disciplines variously approached the question in terms of the point at which the embryo or fetus became formed or recognizably human, or in terms of when a person came into being, that is, infused with a soul or animated. A loose consensus evolved in early English law that these events occurred at some point between conception and live birth. Footnote: early philosophers believed that the embryo or fetus did not become formed and begin to live until at least 40 days after conception for a male and 80 to 90 days for a female. Aristotle's thinking derived from his three-stage theory of life: vegetable, animal, rational. The vegetable stage was reached at conception, the animal at, quote, animation, end of quote, and the rational soon after live birth. This theory, together with the 40 to 80 day view, came to be accepted by early Christian thinkers. The theological debate was reflected in the writings of St. Augustine, who made a distinction between embryo inanimatus, not yet endowed with a soul, and embryo animatus. He may have drawn upon Exodus chapter 21, verse 22. At one point, however, he expressed the view that human powers cannot determine the point during fetal development at which the critical change occurs. Galen, in 3 treatises related to embryology, accepted the thinking of Aristotle and his followers. Later, Augustine on abortion was incorporated by Gratian into the Decretum published about 1140. This decretal and the decretals that followed were recognized as the definitive body of canon law until the new code of 1917. End of footnote. This was, quote, mediate animation, end of quote. Although Christian theology and the canon law came to fix the point of animation at 40 days for a male and 80 days for a female, a view that persisted until the 19th century, there was otherwise little agreement about the precise time of formation or animation. There was agreement, however, that prior to this point the fetus was to be regarded as part of the mother, and its destruction therefore was not homicide. Due to continued uncertainty about the precise time when animation occurred, to the lack of any empirical basis for the 40 to 80 day view, and perhaps to Aquinas' definition of movement as one of the 2 first principles of life, Bracton focused upon quickening as the critical point. The significance of quickening was echoed by later common law scholars and found its way into the received common law in this country. Whether abortion of a quick fetus was a felony at common law or even a lesser crime is still disputed. Bracton, writing early in the 13th century, thought it homicide. Footnote: Bracton took the position that abortion by blow or poison was homicide, quote, if the fetus be already formed and animated, and particularly if it be animated, end of quote, or as a later translation puts it, quote, if the fetus is already formed or quickened, especially if it is quickened, end of quote, end of footnote. But the later and predominant view, following the great common law scholars, has been that it was, at most, a lesser offense. In a frequently cited passage, Koch took the position that abortion of a woman, quote, quick with child, end of quote, is, quote, a great misprision and no murder, end of quote. Blackstone followed, saying that while abortion after quickening had once been considered manslaughter, though not murder, quote, modern law, end of quote, took a less severe view. A recent review of the common law precedents argues, however, that those precedents contradict Koch and that even post-quickening abortion was never established as a common law crime. Footnote: means the phoenix of abortional freedom is a penumbral or Ninth Amendment right about to arise from the 19th century legislative ashes of a 14th century common law liberty The author examines the two principal precedents cited marginally by Koch, both contrary to his dictum, and traces the treatment of these and other cases by earlier commentators. He concludes that Koch, who himself participated as an advocate in an abortion case in 1601, may have intentionally misstated the law. The author even suggests a reason: Koch's strong feelings against abortion, coupled with his determination to assert common law, secular jurisdiction to assess penalties for an offense that traditionally had been an exclusively ecclesiastical or canon law crime. See also later, who notes that some scholars doubt that the common law ever was applied to abortion, that the English ecclesiastical courts seem to have lost interest in the problem after 1527, and that the preamble to the English legislation of 1803, referred to in the text, states that, quote, no adequate means have been hitherto provided for the prevention and punishment of such offenses, end of quote. End of footnote. This is of some importance because, while most American courts ruled, in holding or dictum, that abortion of an unquickened fetus was not criminal under their received common law, others followed Koch in stating that abortion of a quick fetus was a, quote, misprision, end of quote, a term they translated to mean misdemeanor, that their reliance on Koch in this aspect of the law was uncritical, and, apparently in all the reported cases, dictum, due probably to the paucity of common law prosecutions for post-quickening abortion, makes it now appear doubtful that abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. 4. The English statutory law. England's first criminal abortion statute, Lord Ellenborough's Act, came in 1803. It made abortion of a quick fetus, Section 1, a capital crime, but in Section 2, it provided lesser penalties for the felony of abortion before quickening, and thus preserved the quickening distinction. This contrast was continued in the General Revision of 1828. It disappeared, however, together with the death penalty in 1837, and did not reappear in the Offences Against the Person Act of 1861 that formed the core of English anti-abortion law until the liberalizing reforms of 1967. In 1929, the Infant Life Preservation Act came into being. Its emphasis upon the destruction of, quote, the life of a child capable of being born alive, end of quote. It made a willful act performed with the necessary intent a felony. It contained a proviso that one was not to be found guilty of the offense, quote, unless it is proved that the act which caused the death of the child was not done in good faith for the purpose only of preserving the life of the mother, end of quote. A seemingly notable development in the English law was the case of Rex v. Bourne. This case apparently answered in the affirmative the question whether an abortion necessary to preserve the life of the pregnant woman was accepted from the criminal penalties of the 1861 Act. In his instructions to the jury, Judge McNaughton referred to the 1929 Act and observed that that act related to, quote, the case where a child is killed by a willful act at the time when it is being delivered in the ordinary course of nature, end of quote. He concluded that the 1861 Act's use of the word, quote, unlawfully, end of quote, imported the same meaning expressed by the specific proviso in the 1929 Act, even though there was no mention of preserving the mother's life in the 1861 Act. He then construed the phrase, quote, preserving the life of the mother, end of quote, broadly. That is, quote, in a reasonable sense, end of quote, to include a serious and permanent threat to the mother's health, and instructed the jury to acquit Dr. Bourne if it found he had acted in a good faith belief that the abortion was necessary for this purpose. The jury did acquit. Recently, Parliament enacted a new abortion law. This is the Abortion Act of 1967. The Act permits a licensed physician to perform an abortion where two other licensed physicians agree, a, quote, that the continuance of the pregnancy would involve risk to the life of the pregnant woman or of injury to the physical or mental health of the pregnant woman or any existing children of her family, greater than if the pregnancy were terminated, end of quote. Or b, quote, that there is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped, end of quote. The Act also provides that in making this determination, quote, account may be taken of the pregnant woman's actual or reasonably foreseeable environment, end of quote. It also permits a physician, without the concurrence of others, to terminate a pregnancy where he is of the good faith opinion that the abortion, quote, is immediately necessary to save the life or to prevent grave permanent injury to the physical or mental health of the pregnant woman, end of quote. 5. The American law. In this country, the law in effect in all but a few states until the mid-19th century was the pre-existing English common law. Connecticut, the first state to enact abortion legislation, adopted in 1821 that part of Lord Ellenborough's Act that related to a woman, quote, quick with child, end of quote. The death penalty was not imposed. Abortion before quickening was made a crime in that state only in 1860. In 1828, New York enacted legislation that in two respects was to serve as a model for early anti-abortion statutes. First, while barring destruction of an unquickened fetus as well as a quick fetus, it made the former only a misdemeanor, but the latter second-degree manslaughter. Second, it incorporated a concept of therapeutic abortion by providing that an abortion was excused if it, quote, shall have been necessary to preserve the life of such mother or shall have been advised by two physicians to be necessary for such purpose, end of quote. By 1840, when Texas had received the common law, only 8 American states had statutes dealing with abortion. It was not until after the war between the states that legislation began generally to replace the common law. Most of these initial statutes dealt severely with abortion after quickening, but were lenient with it before quickening. Most punished attempts equally with completed abortions. While many statutes included the exception for an abortion thought by one or more physicians to be necessary to save the mother's life, that provision soon disappeared, and the typical law required that the procedure actually be necessary for that purpose. Gradually, in the middle and late 19th century, the quickening distinction disappeared from the statutory law of most states, and the degree of the offense and the penalties were increased. By the end of the 1950s, a large majority of the jurisdictions banned abortion, however and whenever performed, unless done to save or preserve the life of the mother. The exceptions, Alabama and the District of Columbia, permitted abortion to preserve the mother's health. 3 states permitted abortions that were not, quote, unlawfully, end of quote, performed, or that were not, quote, without lawful justification, end of quote, leaving interpretation of those standards to the courts. In the past several years, however, a trend toward liberalization of abortion statutes has resulted in adoption by about 1/3 of the states of less stringent laws, most of them patterned against the ALI Model Penal Code, Section 230.3, set forth as Appendix B to the opinion in Doe v. Bolton. Footnote: 14 states have adopted some form of the ALI statute. Mr. Justice Clark described some of these states as having, quote, led the way, end of quote. By the end of 1970, 4 other states had repealed criminal penalties for abortions performed in early pregnancy by a licensed physician, subject to stated procedural and health requirements. The precise status of criminal abortion laws in some states is made unclear by recent decisions in state and federal courts striking down existing state laws in whole or in part. End of footnote. It is thus apparent that at common law, at the time of the adoption of our Constitution, and throughout the major portion of the 19th century, abortion was viewed with less disfavor than under most American statutes currently in effect. Phrasing it another way, a woman enjoyed a substantially broader right to terminate a pregnancy than she does in most states today, at least with respect to the early stage of pregnancy, and very possibly without such a limitation. The opportunity to make this choice was present in this country well into the 19th century. Even later, the law continued for some time to treat less punitively an abortion procured in early pregnancy. 6. The position of the American Medical Association. The anti-abortion mood prevalent in this country in the late 19th century was shared by the medical profession. Indeed, the attitude of the profession may have played a significant role in the enactment of stringent criminal abortion legislation during that period. An AMA committee on criminal abortion was appointed in May 1857. It presented its report to the 12th annual meeting. That report observed that the committee had been appointed to investigate criminal abortion, quote, with a view to its general suppression, end of quote. It deplored abortion and its frequency, and it listed 3 causes of, quote, this general demoralization. The first of these causes is a widespread popular ignorance of the true character of the crime, a belief, even among mothers themselves, that the fetus is not alive till after the period of quickening. The second of the agents alluded to is the fact that the profession themselves are frequently supposed careless of fetal life. The third reason of the frightful extent of this crime is found in the grave defects of our laws, both common and statute, as regards the independent and actual existence of the child before birth as a living being. These errors, which are sufficient in most instances to prevent conviction, are based, and only based, upon mistaken and exploded medical dogmas. With strange inconsistency, the law fully acknowledges the fetus in utero and its inherent rights for civil purposes, while personally and as criminally affected, it fails to recognize it, and to its life as yet denies all protection. End of quote. The committee then offered, and the association adopted, resolutions protesting, quote, against such unwarrantable destruction of human life, end of quote, calling upon state legislatures to revise their abortion laws, and requesting the cooperation of state medical societies, quote, in pressing the subject, end of quote. In 1871, a long and vivid report was submitted by the Committee on Criminal Abortion. It ended with the observation, quote, we had to deal with human life. In a matter of less importance, we could entertain no compromise. An honest judge on the bench would call things by their proper names. We could do no less. End of quote. It proffered resolutions, adopted by the association, recommending, among other things, that it, quote, be unlawful and unprofessional for any physician to induce abortion or premature labor without the concurrent opinion of at least one respectable consulting physician, and then always with a view to the safety of the child, if that be possible, end of quote, and calling, quote, the attention of the clergy of all denominations to the perverted views of morality entertained by a large class of females, aye, and men also, on this important question, end of quote. End of section 25. Recording by Colleen McMahon. Section 26 of A Collection of Supreme Court Opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Colleen McMahon. Roe v. Wade, 410 U.S. 113, decided January 22, 1973, Part 2. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. End of quote. Except for periodic condemnation of the criminal abortionist, no further formal AMA action took place until 1967. In that year, the Committee on Human Reproduction urged the adoption of a stated policy of opposition to induced abortion, except when there is, quote, documented medical evidence, end of quote, of a threat to the health or life of the mother, or that the child, quote, may be born with incapacitating physical deformity or mental deficiency, end of quote, or that a pregnancy, quote, resulting from legally established statutory or forcible rape or incest may constitute a threat to the mental or physical health of the patient, end of quote. 2 other physicians, quote, chosen because of their recognized professional competence have examined the patient and have concurred in writing, end of quote. And the procedure, quote, is performed in a hospital accredited by the Joint Commission on Accreditation of Hospitals, end of quote. The providing of medical information by physicians to state legislatures in their consideration of legislation regarding therapeutic abortion was, quote, to be considered consistent with the principles of ethics of the American Medical Association, end of quote. This recommendation was adopted by the House of Delegates. In 1970, after the introduction of a variety of proposed resolutions and of a report from its Board of Trustees, A reference committee noted, quote, polarization of the medical profession on this controversial issue, end of quote, division among those who had testified, a difference of opinion among AMA councils and committees, quote, the remarkable shift in testimony, end of quote, in 6 months, felt to be influenced, quote, by the rapid changes in state laws and by the judicial decisions which tend to make abortion more freely available, end of quote, and a feeling, quote, that this trend will continue, end of quote. On June 25, 1970, the House of Delegates adopted preambles and most of the resolutions proposed by the reference committee. The preambles emphasized, quote, the best interests of the patient, sound clinical judgment, and informed patient consent, end of quote, in contrast to, quote, mere acquiescence to the patient's demand, end of quote. The resolutions asserted that abortion is a medical procedure that should be performed by a licensed physician in an accredited hospital only after consultation with 2 other physicians and in conformity with state law, and that no party to the procedure should be required to violate personally held moral principles. Footnote, quote, whereas abortion, like any other medical procedure, should not be performed when contrary to the best interests of the patient, since good medical practice requires due consideration for the patient's welfare and not mere acquiescence to the patient's demand, and whereas the standards of sound clinical judgment, which together with informed patient consent, should be determinative according to the merits of each individual case, therefore be it resolved that abortion is a medical procedure and should be performed only by a duly licensed physician and surgeon in an accredited hospital, acting only after consultation with 2 other physicians chosen because of their professional competency and in conformance with standards of good medical practice and the Medical Practice Act of his state, and be it further resolved that no physician or other professional personnel shall be compelled to perform any act which violates his good medical judgment. Neither physician, hospital, nor hospital personnel shall be required to perform any act violative of personally held moral principles. In these circumstances, good medical practice requires only that the physician or other professional personnel withdraw from the case so long as the withdrawal is consistent with good medical practice. End of quote. Proceedings of the AMA House of Delegates 220, June 1970. End of footnote. The AMA Judicial Council rendered a complimentary opinion. Footnote. The principles of medical ethics of the AMA do not prohibit a physician from performing an abortion that is performed in accordance with good medical practice and under circumstances that do not violate the laws of the community in which he practices. In the matter of abortions, as of any other medical procedure, the Judicial Council becomes involved whenever there is alleged violation of the principles of medical ethics as established by the House of Delegates. End of footnote. 7. The position of the American Public Health Association. In October 1970, the Executive Board of the APHA adopted standards for abortion services. These were 5 in number. A. Rapid and simple abortion referral must be readily available through state and local public health departments, medical societies, or other nonprofit organizations. B. An important function of counseling should be to simplify and expedite the provision of abortion services. It should not delay the obtaining of these services. C. Psychiatric consultation should not be mandatory. As in the case of other specialized medical services, psychiatric consultation should be sought for definite indications and not on a routine basis. D. A wide range of individuals, from appropriately trained, sympathetic volunteers to highly skilled physicians, may qualify as abortion counselors. E. Contraception and/or sterilization should be discussed with each abortion patient. Among factors pertinent to life and health risks associated with abortion were 3 that, quote, are recognized as important, end of quote. A. The skill of the physician. B. The environment in which the abortion is performed. And above all, C. The duration of pregnancy as determined by uterine size and confirmed by menstrual history. It was said that, quote, a well-equipped hospital, end of quote, offers more protection, quote, to cope with unforeseen difficulties than an office or clinic without such resources. The factor of gestational age is of overriding importance, end of quote. Thus, it was recommended that abortions in the second trimester and early abortions in the presence of existing medical complications be performed in hospitals as inpatient procedures. For pregnancies in the first trimester, abortion in the hospital with or without overnight stay, quote, is probably the safest practice, end of quote. An abortion in an extramural facility, however, is an acceptable alternative, quote, provided arrangements exist in advance to admit patients promptly if unforeseen complications develop, end of quote. Standards for an abortion facility were listed. It was said that at present abortions should be performed by physicians or osteopaths who are licensed to practice and who have, quote, adequate training, end of quote. 8. The position of the American Bar Association. At its meeting in February 1972, the ABA House of Delegates approved, with 17 opposing votes, the Uniform Abortion Act that had been drafted and approved the preceding August by the Conference of Commissioners on Uniform State Laws. We set forth the act in full in the margin. Footnote: Uniform Abortion Act. Section 1. Abortion defined when authorized. A. Abortion means the termination of human pregnancy with an intention other than to produce a live birth or to remove a dead fetus. B. An abortion may be performed in this state only if it is performed 1. By a physician licensed to practice medicine or osteopathy in this state, or by a physician practicing medicine or osteopathy in the employ of the government of the United States or of this state, and the abortion is performed in the physician's office or in a medical clinic or in a hospital approved by the Department of Health or operated by the United States, this state, or any department, agency, or political subdivision of either, or by a female upon herself with the advice of the physician. And 2. Within 20 weeks after the commencement of the pregnancy, or after 20 weeks only if the physician has reasonable cause to believe 1. That there is a substantial risk the continuance of the pregnancy would endanger the life of the mother, or would gravely impair the physical or mental health of the mother. 2. That the child would be born with grave physical or mental defect. Or 3. That the pregnancy resulted from rape or incest or illicit intercourse with a girl under the age of 16 years. Section 2. Penalty. Any person who performs or procures an abortion other than authorized by this act is guilty of a felony and upon conviction thereof may be sentenced to pay a fine not exceeding $1,000 or to imprisonment in the state penitentiary not exceeding 5 years, or both. Section 3. Uniformity of interpretation. This act shall be construed to effectuate its general purpose to make uniform the law with respect to the subject of this act among those states which enact it. Section 4. Short title. This act may be cited as the Uniform Abortion Act. Section 5. Severability. If any provision of this act or the application thereof to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of this act which can be given effect without the invalid provision or application, and to this end the provisions of this act are severable. Section 6. Repeal. The following acts and parts of acts are repealed. 1, 2, 3. Section 7. Time of taking effect. This act shall take effect blank. End of footnote. The opinion of the Court Conference has appended an enlightening prefatory note. Footnote. This act is based largely upon the New York Abortion Act following a review of the more recent laws on abortion in several states and upon recognition of a more liberal trend in laws on this subject. Recognition was given also to the several decisions in state and federal courts which show a further trend toward liberalization of abortion laws, especially during the first trimester of pregnancy. Recognizing that a number of problems appeared in New York, a shorter time period for, quote, unlimited, end of quote, abortions was advisable. The time period was bracketed to permit the various states to insert a figure more in keeping with the different conditions that might exist among the states. Likewise, the language limiting the place or places in which abortions may be performed was also bracketed to account for different conditions among the states. In addition, limitations on abortions after the initial, quote, unlimited, end of quote, period were placed in brackets, so that individual states may adopt all or any of these reasons, or place further restrictions upon abortions after the initial period. This act does not contain any provision relating to medical review committees or prohibitions against sanctions imposed upon medical personnel refusing to participate in abortions because of religious or other similar reasons, or the like. Such provisions, while related, do not directly pertain to when, where, or by whom abortions may be performed. However, the Act is not drafted to exclude such a provision by a state wishing to enact the same. End of footnote. 7. 3 reasons have been advanced to explain historically the enactment of criminal abortion laws in the 19th century and to justify their continued existence. It has been argued occasionally that these laws were the product of a Victorian social concern to discourage illicit sexual conduct. Texas, however, does not advance this justification in the present case, and it appears that no court or commentator has taken the argument seriously. The appellants and amici contend, moreover, that this is not a proper state purpose at all, and suggest that if it were, the Texas statutes are overbroad in protecting it, since the law fails to distinguish between married and unwed mothers. A second reason is concerned with abortion as a medical procedure. When most criminal abortion laws were first enacted, the procedure was a hazardous one for the woman. This was particularly true prior to the development of antisepsis. Antiseptic techniques, of course, were based on discoveries by Lister, Pasteur, and others, first announced in 1867, but were not generally accepted and employed until about the turn of the century. Abortion mortality was high. Even after 1900, and perhaps until as late as the development of antibiotics in the 1940s, standard modern techniques such as dilation and curettage were not nearly so safe as they are today. Thus it has been argued that a state's real concern in enacting a criminal abortion law was to protect the pregnant woman, that is, to restrain her from submitting to a procedure that placed her life in serious jeopardy. Modern medical techniques have altered this situation. Appellants and various amici refer to medical data indicating that abortion in early pregnancy, that is, prior to the end of the first trimester, although not without its risk, is now relatively safe. Mortality rates for women undergoing early abortions, where the procedure is legal, appear to be as low as or lower than the rates for normal childbirth. Consequently, any interest of the state in protecting the woman from an inherently hazardous procedure, except when it would be equally dangerous for her to forego it, has largely disappeared. Of course, important state interests in the areas of health and medical standards do remain. The state has a legitimate interest in seeing to it that abortion, like any other medical procedure, is performed under circumstances that ensure maximum safety for the patient. This interest obviously extends at least to the performing physician and his staff, to the facilities involved, to the availability of aftercare, and to adequate provision for any complication or emergency that might arise. The prevalence of high mortality rates at illegal, quote, abortion mills, end of quote, strengthens rather than weakens the state's interest in regulating the conditions under which abortions are performed. Moreover, the risk to the woman increases as her pregnancy continues. Thus, the state retains a definite interest in protecting the woman's own health and safety when an abortion is proposed at a late stage of pregnancy. The third reason is the state's interest, some phrase it in terms of duty, in protecting prenatal life. Some of the argument for this justification rests on the theory that a new human life is present from the moment of conception. The state's interest and general obligation to protect life then extends, it is argued, to prenatal life. Only when the life of the pregnant mother herself is at stake, balanced against the life she carries within her, should the interest of the embryo or fetus not prevail. Logically, of course, a legitimate state interest in this area need not stand or fall on acceptance of the belief that life begins at conception or at some other point prior to live birth. In assessing the state's interest, recognition may be given to the less rigid claim that as long as at least potential life is involved, the state may assert interests beyond the protection of the pregnant woman alone. Parties challenging state abortion laws have sharply disputed in some courts the contention that a purpose of these laws, when enacted, was to protect prenatal life. Pointing to the absence of legislative history to support the contention, they claim that most state laws were designed solely to protect the woman. Because medical advances have lessened this concern, at least with respect to abortion and early pregnancy, they argue that with respect to such abortions, the laws can no longer be justified by any state interest. There is some scholarly support for this view of original purpose. The few state courts called upon to interpret their laws in the late 19th and early 20th centuries did focus on the state's interest in protecting the woman's health rather than in preserving the embryo and fetus. Proponents of this view point out that in many states, including Texas, by statute or judicial interpretation, the pregnant woman herself could not be prosecuted for self-abortion or for cooperating in an abortion performed upon her by another. They claim that adoption of the quickening distinction through received common law and state statutes tacitly recognizes the greater health hazards inherent in late abortion and impliedly repudiates the theory that life begins at conception. It is with these interests and the 8 to be attached to them that this case is concerned. 8. The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, going back perhaps as far as Union Pacific Railroad Company v. Botsford, the court has recognized that a right of personal privacy, or a guarantee of certain areas or zones of privacy, does exist under the Constitution. In varying contexts, the court or individual justices have, indeed, found at least the roots of that right in the First Amendment, in the Fourth and Fifth Amendments, in the penumbras of the Bill of Rights, in the Ninth Amendment, or in the concept of liberty guaranteed by the first section of the 14th Amendment. These decisions make it clear that only personal rights that can be deemed, quote, fundamental, end of quote, or, quote, implicit in the concept of ordered liberty, end of quote, are included in this guarantee of personal privacy. They also make it clear that the right has some extension to activities relating to marriage, procreation, contraception, family relationships, and child rearing and education. This right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or, as the District Court determined, in the Ninth Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The detriment that the state would impose upon the pregnant woman by denying this choice altogether is apparent. Specific and direct harm medically diagnosable even in early pregnancy may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family already unable, psychologically and otherwise, to care for it. In other cases, as in this one, the additional difficulties and continuing stigma of unwed motherhood may be involved. All these are factors the woman and her responsible physician necessarily will consider in consultation. On the basis of elements such as these, appellant and some amici argue that the woman's right is absolute, and that she is entitled to terminate her pregnancy at whatever time, in whatever way, and for whatever reason she alone chooses. With this, we do not agree. Appellant's arguments that Texas either has no valid interest at all in regulating the abortion decision, or no interest strong enough to support any limitation upon the woman's sole determination, are unpersuasive. The court's decisions recognizing a right of privacy also acknowledge that some state regulation in areas protected by that right is appropriate. As noted above, a state may properly assert important interests in safeguarding health, in maintaining medical standards, and in protecting potential life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain regulation of the factors that govern the abortion decision. The privacy right involved, therefore, cannot be said to be absolute. In fact, it is not clear to us that the claim asserted by some amici that one has an unlimited right to do with one's body as one pleases bears a close relationship to the right of privacy previously articulated in the court's decisions. The court has refused to recognize an unlimited right of this kind in the past. We therefore conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests in regulation. We note that those federal and state courts that have recently considered abortion law challenges have reached the same conclusion. A majority, in addition to the district court in the present case, have held state laws unconstitutional, at least in part because of vagueness or because of overbreadth and abridgment of rights. Others have sustained state statutes. Although the results are divided, most of these courts have agreed that the right of privacy, however based, is broad enough to cover the abortion decision, that the right, nonetheless, is not absolute and is subject to some limitations, and that, at some point, the state interests as to protection of health, medical standards, and prenatal life become dominant. We agree with this approach. Where certain, quote, fundamental rights, end of quote, are involved, the court has held that regulation limiting these rights may be justified only by a, quote, compelling state interest, end of quote, and that legislative enactments must be narrowly drawn to express only the legitimate state interests at stake. In the recent abortion cases cited above, courts have recognized these principles. Those striking down state laws have generally scrutinized the state's interests in protecting health and potential life, and have concluded that neither interest justified broad limitations on the reasons for which a physician and his pregnant patient might decide that she should have an abortion in the early stages of pregnancy. Courts sustaining state laws have held that the state's determinations to protect health or prenatal life are dominant and constitutionally justifiable. 9. The district court held that the appellee failed to meet his burden of demonstrating that the Texas statute's infringement upon Roe's rights was necessary to support a compelling state interest, and that although the appellee presented, quote, several compelling justifications for state presence in the area of abortions, end of quote, the statutes outstripped these justifications and swept, quote, far beyond any areas of compelling state interest, end of quote. Appellant and appellee both contest that holding. Appellant, as has been indicated, claims an absolute right that bars any state imposition of criminal penalties in the area. Appellee argues that the state's determination to recognize and protect prenatal life from and after conception constitutes a compelling state interest. As noted above, we do not agree fully with either formulation. A. The appellee and certain amici argue that the fetus is a, quote, person, end of quote, within the language and meaning of the 14th Amendment. In support of this, they outline at length and in detail the well-known facts of fetal development. If this suggestion of personhood is established, the appellant's case, of course, collapses, for the fetus's right to life would then be guaranteed specifically by the amendment. The appellant conceded as much on re-argument. On the other hand, the appellee conceded on re-argument that no case could be cited that holds that a fetus is a person within the meaning of the 14th Amendment. The Constitution does not define person in so many words. Section 1 of the 14th Amendment contains 3 references to person. The first, in defining citizens, speaks of, quote, persons born or naturalized in the United States, end of quote. The word also appears both in the Due Process Clause and in the Equal Protection Clause. Person is used in other places in the Constitution, in the listing of qualifications for representatives and senators, in the Apportionment Clause. Footnote, we are not aware that in the taking of any census under this clause a fetus has ever been counted. End of footnote. In the Migration and Importation Provision, in the Emolument Clause, in the Electors Provisions, in the provision outlining qualifications for the office of President, in the extradition provisions and the superseded Fugitive Slave Clause, and in the 5th, 12th, and 22nd Amendments, as well as in Sections 2 and 3 of the 14th Amendment. But in nearly all these instances, the use of the word is such that it has application only postnatally. None indicates with any assurance that it has any possible prenatal application. Footnote, when Texas urges that a fetus is entitled to 14th Amendment protection as a person, it faces a dilemma. Neither in Texas nor in any other state are all abortions prohibited. Despite broad proscription, an exception always exists. The exception contained in Article 1196 for an abortion procured or attempted by medical advice for the purpose of saving the life of the mother is typical. But if the fetus is a person who is not to be deprived of life without due process of law, And if the mother's condition is the sole determinant, does not the Texas exception appear to be out of line with the amendment's command? There are other inconsistencies between 14th Amendment status and the typical abortion statute. It has already been pointed out that in Texas, the woman is not a principal or an accomplice with respect to an abortion upon her. If the fetus is a person, why is the woman not a principal or an accomplice? Further, the penalty for criminal abortion specified by Article 1195 is significantly less than the maximum penalty for murder prescribed by Article 1257 of the Texas Penal Code. If the fetus is a person, may the penalties be different? End of footnote. All this, together with our observation supra, that throughout the major portion of the 19th century, prevailing legal abortion practices were far freer than they are today, persuades us that the word person as used in the 14th Amendment does not include the unborn. Footnote. Cf. the Wisconsin abortion statute defining, quote, unborn child, end of quote, to mean, quote, a human being from the time of conception until it is born alive, end of quote, and the New Connecticut statute declaring it to be the public policy of the state and the legislative intent, quote, to protect and preserve human life from the moment of conception, end of quote. End of footnote. This is in accord with the results reached in those few cases where the issue has been squarely presented. Indeed, our decision in United States v. Vuitch inferentially is to the same effect, for we there would not have indulged in statutory interpretation favorable to abortion in specified circumstances if the necessary consequence was the termination of life entitled to 14th Amendment protection. This conclusion, however, does not of itself fully answer the contentions raised by Texas, and we pass on to other considerations. B. The pregnant woman cannot be isolated in her privacy. She carries an embryo and later a fetus, if one accepts the medical definitions of the developing young in the human uterus. The situation, therefore, is inherently different from marital intimacy, or bedroom possession of obscene material, or marriage, or procreation, or education, with which Eisenstadt and Griswold, Stanley, Loving, Skinner, and Pierce and Meyer were respectively concerned. As we have intimated above, it is reasonable and appropriate for a state to decide that at some point in time another interest, that of health of the mother or that of potential human life, becomes significantly involved. The woman's privacy is no longer sole, and any right of privacy she possesses must be measured accordingly. Texas urges that apart from the 14th Amendment, life begins at conception and is present throughout pregnancy, and that therefore the state has a compelling interest in protecting that life from and after conception. We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer. It should be sufficient to note briefly the wide divergence of thinking on this most sensitive and difficult question. There has always been strong support for the view that life does not begin until live birth. This was the belief of the Stoics. It appears to be the predominant, though not the unanimous, attitude of the Jewish faith. It may be taken to represent also the position of a large segment of the Protestant community, insofar as that can be ascertained. Organized groups that have taken a formal position on the abortion issue have generally regarded abortion as a matter for the conscience of the individual and her family. As we have noted, the common law found greater significance in quickening. Physicians and their scientific colleagues have regarded that event with less interest and have tended to focus either upon conception, upon live birth, or upon the interim point at which the fetus becomes, quote, viable, end of quote, that is, potentially able to live outside the mother's womb, albeit with artificial aid. Viability is usually placed at about 7 months, 28 weeks, but may occur earlier, even at 24 weeks. The Aristotelian theory of, quote, mediate animation, end of quote, that held sway throughout the Middle Ages and the Renaissance in Europe continued to be official Roman Catholic dogma until the 19th century, despite opposition to this, quote, ensoulment, end of quote, theory from those in the Church who would recognize the existence of life from the moment of conception. The latter is now, of course, the official belief of the Catholic Church. As one brief amicus discloses, this is a view strongly held by many non-Catholics as well, and by many physicians. Substantial problems for precise definition of this view are posed, however, by new embryological data that purport to indicate that conception is a process over time rather than an event, and by new medical techniques such as menstrual extraction, the morning after pill, implantation of embryos, artificial insemination, and even artificial wombs. In areas other than criminal abortion, the law has been reluctant to endorse any theory that life, as we recognize it, begins before live birth, or to accord legal rights to the unborn, except in narrowly defined situations, and except when the rights are contingent upon live birth. For example, the traditional rule of tort law denied recovery for prenatal injuries even though the child was born alive. That rule has been changed in almost every jurisdiction. In most states, recovery is said to be permitted only if the fetus was viable, or at least quick, when the injuries were sustained, though few courts have squarely so held. In a recent development, generally opposed by the commentators, some states permit the parents of a stillborn child to maintain an action for wrongful death because of prenatal injuries. Such an action, however, would appear to be one to vindicate the parent's interest, and is thus consistent with the view that the fetus, at most, represents only the potentiality of life. Similarly, unborn children have been recognized as acquiring rights or interests by way of inheritance or other devolution of property, and have been represented by guardians ad litem. Perfection of the interests involved, again, has generally been contingent upon live birth. In short, the unborn have never been recognized in the law as persons in the whole sense. 10. In view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant woman that are at stake. We repeat, however, that the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical consultation and treatment there, and that it has still another important and legitimate interest in protecting the potentiality of human life. These interests are separate and distinct. Each grows in substantiality as the woman approaches term, and at a point during pregnancy, each becomes, quote, compelling, end of quote. With respect to the state's important and legitimate interest in the health of the mother, the, quote, compelling, end of quote, point, in light of present medical knowledge, is at approximately the end of the first trimester. This is so because of the now established medical fact, referred to above, that until the end of the first trimester, mortality in abortion may be less than mortality in normal childbirth. It follows that, from and after this point, a state may regulate the abortion procedure to the extent that the regulation reasonably relates to the preservation and protection of maternal health. Examples of permissible state regulation in this area are requirements as to the qualifications of the person who is to perform the abortion, as to the licensure of that person, as to the facility in which the procedure is to be performed, that is, whether it must be a hospital or may be a clinic or some other place of less than hospital status, as to the licensing of the facility, and the like. This means, on the other hand, that for the period of pregnancy prior to this compelling point, the attending physician, in consultation with his patient, is free to determine, without regulation by the state, that in his medical judgment the patient's pregnancy should be terminated. If that decision is reached, the judgment may be effectuated by an abortion free of interference by the state. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to proscribe abortion during that period, except when it is necessary to preserve the life or health of the mother. Measured against these standards, Article 1196 of the Texas Penal Code, in restricting legal abortions to those, quote, procured or attempted by medical advice for the purpose of saving the life of the mother, end of quote, sweeps too broadly. The statute makes no distinction between abortions performed early in pregnancy and those performed later, and it limits to a single reason, saving the mother's life, the legal justification for the procedure. The statute, therefore, cannot survive the constitutional attack made upon it here. This conclusion makes it unnecessary for us to consider the additional challenge to the Texas statute asserted on grounds of vagueness. 11. To summarize and to repeat, 1. A state criminal abortion statute of the current Texas type that accepts from criminality only a life-saving procedure on behalf of the mother, without regard to pregnancy stage and without recognition of the other interests involved, is violative of the Due Process Clause of the 14th Amendment. A. For the stage prior to approximately the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician. B. For the stage subsequent to approximately the end of the first trimester, the state, in promoting its interest in the health of the mother, may, if it chooses, regulate the abortion procedure in ways that are reasonably related to maternal health. C. For the stage subsequent to viability, the state, in promoting its interest in the potentiality of human life, may, if it chooses, regulate and even proscribe abortion except where it is necessary, in appropriate medical judgment, for the preservation of the life or health of the mother. 2. The state may define the term physician as it has been employed in the preceding paragraphs of this Part 11 of this opinion to mean only a physician currently licensed by the state, and may proscribe any abortion by a person who is not a physician as so defined. In Doe v. Bolton, procedural requirements contained in one of the modern abortion statutes are considered. That opinion and this one, of course, are to be read together. Footnote. Neither in this opinion nor in Doe v. Bolton do we discuss the father's rights, if any exist in the constitutional context, in the abortion decision. No paternal right has been asserted in either of the cases, and the Texas and Georgia statutes on their face take no cognizance of the father. We are aware that some statutes recognize the father under certain circumstances. North Carolina, for example, requires written permission for the abortion from the husband when the woman is a married minor, that is, when she is less than 18 years of age. If the woman is an unmarried minor, written permission from the parents is required. We need not now decide whether provisions of this kind are constitutional. End of footnote. This holding, we feel, is consistent with the relative weights of the respective interests involved, with the lessons and examples of medical and legal history, with the lenity of the common law, and with the demands of the profound problems of the present day. The decision leaves the state free to place increasing restrictions on abortion as the period of pregnancy lengthens, so long as those restrictions are tailored to the recognized state interests. The decision vindicates the right of the physician to administer medical treatment according to his professional judgment, up to the points where important state interests provide compelling justifications for intervention. Up to those points, the abortion decision in all its aspects is inherently and primarily a medical decision, and basic responsibility for it must rest with the physician. If an individual practitioner abuses the privilege of exercising proper medical judgment, the usual remedies, judicial and intraprofessional, are available. 12. Our conclusion that Article 1196 is unconstitutional means, of course, that the Texas abortion statutes as a unit must fall. The exception of Article 1196 cannot be struck down separately, for then the state will be left with a statute prescribing all abortion procedures, no matter how medically urgent the case. Although the district court granted Appellant Roe declaratory relief, it stopped short of issuing an injunction against enforcement of the Texas statutes. The court has recognized that different considerations enter into a federal court's decision as to declaratory relief on the one hand and injunctive relief on the other. We are not dealing with a statute that on its face appears to abridge free expression, an area of particular concern under Dombrowski and refined in Younger v. Harris. We find it unnecessary to decide whether the district court erred in withholding injunctive relief, for we assume the Texas prosecutorial authorities will give full credence to this decision that the present criminal abortion statutes of that state are unconstitutional. The judgment of the district court as to intervenor Halford is reversed, and Dr. Halford's complaint in intervention is dismissed. In all other respects, the judgment of the district court is affirmed. Costs are allowed to the appellee. It is so ordered. End of section 26. Recording by Colleen McMahon.
Section 27 of A Collection of Supreme Court Opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Florence Short. McDaniel versus Paty, 435, U.S. 618. Decided April 19, 1978. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Chief Justice Berger announced the judgment of the court and delivered an opinion in which Mr. Justice Powell, Mr. Justice Rehnquist, and Mr. Justice Stevens joined. The question presented by this appeal is whether a Tennessee statute barring, quote, ministers of the gospel or priests of any denomination whatever, end of quote, from serving as delegates to the state's limited constitutional convention deprived appellant McDaniel, an ordained minister, of the right to free exercise of religion, guaranteed by the First Amendment and made applicable to the states by the 14th Amendment. The First Amendment forbids all laws, quote, prohibiting the free exercise, end of quote, of religion. In its first constitution in 1796, Tennessee disqualified ministers from serving as legislators. That disqualifying provision has continued unchanged since its adoption. It is now Article 9, Section 1 of the state constitution. The state legislature applied this provision to candidates for delegate to the state's 1977 Limited Constitutional Convention when it enacted Chapter 848, Section 4 of 1976 Tennessee Public Acts. Any citizen of the state who can qualify for membership in the House of Representatives of the General Assembly may become a candidate for delegate to the convention. McDaniel, an ordained minister of a Baptist church in Chattanooga, Tennessee, filed as a candidate for delegate to the Constitutional Convention. An opposing candidate, appellee Selma Cash Paty, sued in the Chancery Court for a declaratory judgment that McDaniel was disqualified from serving as a delegate and for a judgment striking his name from the ballot. Chancellor Franks of the Chancery Court held that Section 4 of Chapter 848 violated the First and 14th Amendments to the federal Constitution and declared McDaniel eligible for the office of delegate. Accordingly, McDaniel's name remained on the ballot and, in the ensuing election, he was elected by a vote almost equal to that of the three opposing candidates. After the election, the Tennessee Supreme Court reversed the Chancery Court, holding that the disqualification of clergy imposed no burden upon, quote, religious belief, end of quote, and restricted, quote, religious action only in the lawmaking process of government, where religious action is absolutely prohibited by the Establishment Clause, end of quote. 547 S.W. 2nd, 897, 903, 1977. The state interests in preventing the establishment of religion and in avoiding the divisiveness and tendency to channel political activity along religious lines, resulting from clergy participation in political affairs, were deemed by that court sufficiently weighty to justify the disqualification, notwithstanding the guarantee of the Free Exercise Clause. We noted probable jurisdiction, 432 U.S. 905, 1977. The disqualification of ministers from legislative office was a practice carried from England by the 7 of the original states. Later, 6 new states similarly excluded clergymen from some political offices. A. Stokes, Church and State in the United States, 622, 1950. Hereafter Stokes. In England, the practice of excluding clergy from the House of Commons was justified on a variety of grounds: to prevent dual office holding, that is, membership by a minister in both Parliament and Convocation; to ensure that the priest or deacon devoted himself to his, quote, sacred calling, end of quote, rather than to, quote, such mundane activities as were appropriate to a member of the House of Commons, end of quote, and to prevent ministers who, after 1533, were subject to the Crown's powers over the benefices of the clergy, from using membership in the Commons to diminish its independence by increasing the influence of the king and the nobility. The purpose of the several states in providing for disqualification was primarily to assure the success of a new political experiment, the separation of church and state. Stokes, 622. Prior to 1776, most of the 13 colonies had some form of an established or government-sponsored church, even after ratification of the First Amendment, which prohibited the federal government from following such a course. Some states continued pro-establishment provisions. Massachusetts, the last state to accept disestablishment, did so in 1833. In light of this history and a widespread awareness during that period of undue and often dominant clerical influence in public and political affairs here, in England, and on the continent, it is not surprising that strong views were held by some that one way to assure disestablishment was to keep clergymen out of public office. Indeed, some of the foremost political philosophers and statesmen of that period held such views regarding the clergy. Earlier, John Locke argued for confining the authority of the English clergy, quote, within the bounds of the Church, nor can it in any manner be extended to civil affairs, because the Church itself is a thing absolutely separate and distinct from the Commonwealth. End of quote. Thomas Jefferson initially advocated such a position in his 1783 draft of a Constitution for Virginia. James Madison, however, disagreed and vigorously urged the position which, in our view, accurately reflects the spirit and purpose of the religion clauses of the First Amendment. Madison's response to Jefferson's position was, quote, does not the exclusion of ministers of the gospel, as such, violate a fundamental principle of liberty by punishing a religious profession with the privation of a civil right? Does it not violate another article of the plan itself, which exempts religion from the cognizance of civil power? Does it not violate justice by at once taking away a right and prohibiting a compensation for it? Does it not, in fine, violate impartiality by shutting the door against the ministers of one religion and leaving it open for those of every other? End of quote. Madison was not the only articulate opponent of the clergy disqualification. When proposals were made earlier to prevent clergymen from holding public office, John Witherspoon, a Presbyterian minister, president of Princeton University, and the only clergyman to sign the Declaration of Independence, made a cogent protest and, with tongue in cheek, offered an amendment to a provision much like that challenged here. Quote, no clergyman of any denomination shall be capable of being elected a member of the Senate or House of Representatives, because here insert the grounds of offensive disqualification, which I have not been able to discover, provided always, and it is the true intent and meaning of this part of the Constitution, that if at any time he shall be completely deprived of the clerical character by those by whom he was invested with it, as by deposition for cursing and swearing, drunkenness, or uncleanliness, he he shall then be fully restored to all the privileges of a free citizen. His offense of being a clergyman shall no more be remembered against him, but he may be chosen either to the Senate or House of Representatives, and shall be treated with all the respect due to his brethren, the other members of the Assembly. End of quote. Stokes 624 through 625. As the value of the disestablishment experiment was perceived, 11 of the 13 states disqualifying the clergy from some types of public office gradually abandoned that limitation. New York, for example, took that step in 1846, after delegates to the state's constitutional convention argued that the exclusion of clergymen from the legislature was an, quote, odious distinction, end of quote. Only Maryland and Tennessee continued their clergy disqualification provisions into this century, and in 1974, a district court held Maryland's provision violative of the First and 14th Amendments' guarantees of the free exercise of religion. Kirkley v. Maryland, 381, F. Supplement, 327. Today, Tennessee remains the only state excluding ministers from certain public offices. The essence of this aspect of our national history is that, in all but a few states, the selection or rejection of clergymen for public office soon came to be viewed as something safely left to the good sense and desires of the people. This brief review of the history of clergy disqualification provisions also amply demonstrates, however, that, at least during the early segment of our national life, those provisions enjoyed the support of responsible American statesmen and were accepted as having a rational basis. Against this background, we do not lightly invalidate a statute enacted pursuant to a provision of a state constitution which has been sustained by its highest court. The challenged provision came to the Tennessee Supreme Court clothed with a presumption of validity to which that court was bound to give deference. However, the right to the free exercise of religion unquestionably encompasses the right to preach, proselytize, and perform other similar religious functions, or, in other words, to be a minister of the type McDaniel was found to be. Murdoch v. Pennsylvania, 319 U.S. 105, 1943. Cantwell v. Connecticut, 310 U.S. 296, 1940. Tennessee also acknowledges the right of its adult citizens generally to seek and hold office as legislators or delegates to the state constitutional convention. Yet, under the clergy disqualification provision, McDaniel cannot exercise both rights simultaneously because the state has conditioned the exercise of one on the surrender of the other. Or, in James Madison's words, the state is, quote, punishing a religious profession with the privation of a civil right, end of quote. In doing so, Tennessee has encroached upon McDaniel's right to the free exercise of religion, quote, to condition the availability of benefits, including access to the ballot, upon this appellant's willingness to violate a cardinal principle of his religious faith by surrendering his religiously impelled ministry, effectively penalizes the free exercise of his constitutional liberties. End of quote. Sherbert v. Werner, 374, U.S. 398, 406, 1963. If the Tennessee disqualification provision were viewed as depriving the clergy of a civil right solely because of their religious beliefs, our inquiry would be at an end. The Free Exercise Clause categorically prohibits government from regulating, prohibiting, or rewarding religious beliefs as such. In Torcaso v. Watkins, 367, U.S. 488, 1961, the court reviewed the Maryland constitutional requirement that all holders of, quote, any office of profit or trust in this state, end of quote, declare their belief in the existence of God. In striking down the Maryland requirement, The court did not evaluate the interests assertedly justifying it, but rather held that it violated freedom of religious belief. In our view, however, Torcaso does not govern. By its terms, the Tennessee disqualification operates against McDaniel because of his status as a, quote, minister or priest, end of quote. The meaning of those words is, of course, a question of state law. And although the question has not been examined extensively in state law sources, such authority as is available indicates that ministerial status is defined in terms of conduct and activity, rather than in terms of belief. Because the Tennessee disqualification is directed primarily at status, acts, and conduct, it is unlike the requirement in Torcaso, which focused on belief. Hence, the Free Exercise Clause's absolute prohibition of infringements on the, quote, freedom to believe, end of quote, is inapposite here. This does not mean, of course, that the disqualification escapes judicial scrutiny, or that McDaniel's activity does not enjoy significant First Amendment protection. The court recently declared in Wisconsin v. Yoder, 406 U.S. 205, 215, 1972, quote, "The essence of all that has been said and written on the subject is that only those interests of the highest order and those not otherwise served can overbalance legitimate claims to the free exercise of religion." End of quote. Tennessee asserts that its interest in preventing the establishment of a state religion is consistent with the Establishment Clause, and thus of the highest order. The constitutional history of the several states reveals that, generally, the interest in preventing establishment prompted the adoption of clergy disqualification provisions. See Stokes 622. Tennessee does not appear to be an exception to this pattern. There is no occasion to inquire whether promoting such an interest is a permissible legislative goal, however, for Tennessee has failed to demonstrate that its views of the dangers of clergy participation in the political process have not lost whatever validity they may once have enjoyed. The essence of the rationale underlying the Tennessee restriction on ministers is that, if elected to public office, they will necessarily exercise their powers and influence to promote the interests of one sect or thwart the interests of another, thus pitting one against the others, contrary to the anti-establishment principle with its command of neutrality. See Walz v. Tax Commission 397 U.S. 664, 1970. However widely that view may have been held in the 18th century by many, including enlightened statesmen of that day, the American experience provides no persuasive support for the fear that clergymen in public office will be less careful of anti-establishment interests, or less faithful to their oaths of civil office than their unordained counterparts. We hold that Section 4 of Chapter 848 violates McDaniel's First Amendment right to the free exercise of his religion made applicable to the states by the 14th Amendment. Accordingly, the judgment of the Tennessee Supreme Court is reversed, and the case is remanded to that court for further proceedings, not inconsistent with this opinion. Reversed and remanded. Mr. Justice Blackmun took no part in the consideration or decision of this case. End of Section 27.
Section 28 of a collection of Supreme Court opinions by the United States Supreme Court. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Gretchen LaBuhn, Columbus. Rosales-Mireles v. United States. Decided June 18, 2018. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinions. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Justice Sotomayor delivered the opinion of the court. Federal Rule of Criminal Procedure 52B provides that a court of appeals may consider errors that are plain and affect substantial rights, even though they are raised for the first time on appeal. This case concerns the bounds of that discretion and whether a miscalculation of the United States sentencing guidelines range that has been determined to be plain and to affect a defendant's substantial rights calls for a court of appeals to exercise its discretion under Rule 52B to vacate the defendant's sentence. The court holds that such an error will, in the ordinary case, as here, seriously affect the fairness, integrity, or public reputation of judicial proceedings, and thus will warrant relief. 1A. Each year, thousands of individuals are sentenced to terms of imprisonment for violations of federal law. District courts must determine in each case what constitutes a sentence that is, quote, sufficient but not greater than necessary, end quote, Title 18 of the U.S. Code, to achieve the overarching sentencing purposes of, quote, retribution, deterrence, incapacitation, and rehabilitation, end quote, Tapia v. United States. Those decisions call for the district court to exercise discretion, yet to ensure, quote, certainty and fairness, end quote, in sentencing, district courts must operate within the framework established by Congress. United States v. Booker, quoting Title 28 of the U.S. Code. The sentencing guidelines serve an important role in that framework. Quote, district courts must begin their analysis with the guidelines and remain cognizant of them throughout the sentencing process, end quote, Pugh v. United States. Courts are not bound by the guidelines, but even in an advisory capacity, the guidelines serve as a, quote, meaningful benchmark, end quote, in the initial determination of a sentence and, quote, through the process of appellate review, end quote. Title 569 of the U.S. Code. Of course, to consult the applicable guidelines range, a district court must first determine what that range is. This can be a, quote, complex, end quote, undertaking. Molina-Martinez v. United States. The United States Probation Office, operating as an arm of the district court, first creates a pre-sentence investigation report, quote, which includes a calculation of the advisory guidelines range it considers to be applicable, end quote. Molina-Martinez v. United States. That calculation derives from an assessment of the, quote, offense characteristics, offender characteristics, and other matters that might be relevant to the sentence, end quote. Rita v. United States. Specifically, an offense level is calculated by identifying a base level for the offense of conviction and adjusting that level to account for circumstances specific to the defendant's case, such as how the crime was committed and whether the defendant accepted responsibility. A numerical value is then attributed to any prior offenses committed by the defendant, which are added together to generate a criminal history score that places the defendant within a particular criminal history category. Together, the offense level and the criminal history category identify the applicable guidelines range. B. The district court has the ultimate responsibility to ensure that the guidelines range it considers is correct, and that the, quote, failure to calculate the correct guidelines range constitutes procedural error, end quote. Pugh. Given the complexity of the calculation, however, district courts sometimes make mistakes. It is unsurprising, then, that, quote, there will be instances when a district court's sentencing of a defendant within the framework of an incorrect guidelines range goes unnoticed, end quote, by the parties as well, which may result in a defendant raising the error for the first time on appeal. Molina-Martinez. Those defendants are not entirely without recourse. Federal Rule of Criminal Procedure 52B provides that, quote, a plain error that affects substantial rights may be considered even though it was not brought to the district court's attention, end quote. In United States v. Olano, the court established 3 conditions that must be met before a court may consider exercising its discretion to correct the error. Quote, first, there must be an error that has not been intentionally relinquished or abandoned. Second, the error must be plain, that is to say, clear or obvious. Third, the error must have affected the defendant's substantial rights, end quote, Molina-Martinez. To satisfy this third condition, the defendant ordinarily must, quote, show a reasonable probability that, but for the error, the outcome of the proceeding would have been different, end quote, Molina-Martinez. Once those 3 conditions have been met, quote, the Court of Appeals should exercise its discretion to correct the forfeited error if the error seriously affects the fairness, integrity, or public reputation of judicial proceedings, end quote. Molina-Martinez. It is this last consideration, often called Olano's fourth prong, that we are asked to clarify and apply in this case. C. Petitioner Florencio Rosales-Mireles pleaded guilty to illegal reentry in violation of Title VIII of the U.S. Code. The Probation Office, in its pre-sentence investigation report, mistakenly counted a 2009 state conviction of misdemeanor assault twice. This double counting resulted in a criminal history score of 13, which placed Rosales-Mireles in criminal history category 6. Combined with his offense level of 21, that yielded a guidelines range of 77 to 96 months. Had the criminal history score been calculated correctly, Rosales-Mireles would have been in criminal history category 5, and the resulting guidelines range would have been 70 to 87 months. Rosales-Mireles did not object to the double counting error before the district court. Relying on the erroneous pre-sentence investigation report, and after denying Rosales-Mireles' request for a downward departure, the court district sentenced Rosales-Mireles to 78 months of imprisonment, 1 month above the lower end of the guidelines range that everyone thought applied. On appeal, Rosales-Mireles argued for the first time that his criminal history score and the resulting guidelines range were incorrect because of the double counting of his 2009 conviction. Because he had not objected in the district court, the Court of Appeals for the Fifth Circuit reviewed for plain error. Applying the Olano framework, the Fifth Circuit concluded that Rosales-Mireles had established that the guidelines miscalculation constituted an error that was plain, satisfying Olano's first two conditions. It also held that the error affected Rosales-Mireles' substantial rights, thus satisfying the third condition, because there was, quote, a reasonable probability that he would have been subject to a different sentence but for the error, end quote. In reaching that conclusion, the Fifth Circuit rejected the government's argument that Rosales-Mireles would have received the same sentence regardless of the guidelines error, because the district court had denied a downward departure, quote, based in part on Rosales-Mireles' criminal history, end quote, which, quote, erroneously included an extra conviction, end quote. The Fifth Circuit nevertheless declined to exercise its discretion to vacate and remand the case for resentencing, because it concluded that Rosales-Mireles failed to establish that the error would seriously affect the fairness, integrity, or public reputation of judicial proceedings. In its view, quote, the types of errors that warrant reversal are ones that would shock the conscience of the common man, serve as a powerful indictment against our system of justice, or seriously call into question the competence or integrity of the district judge, end quote. Because Rosales-Mireles' sentence of 78 months fell within the correct range of 70 to 87 months, the Fifth Circuit held that neither the error nor the resulting sentence, quote, would shock the conscience, end quote. The Fifth Circuit's articulation of Olano's fourth prong is out of step with the practice of other circuits. We granted certiorari to resolve that conflict. And now, reverse. 2a. Although, quote, Rule 52b is permissive, not mandatory, end quote, Olano, it is well established that courts should correct a forfeited plain error that affects substantial rights, quote, if the error seriously affects the fairness, integrity, or public reputation of judicial proceedings, end quote, Olano. The court in Olano rejected a narrower rule that would have called for relief only, quote, in those circumstances in which a miscarriage of justice would otherwise result, end quote. That is to say, where a defendant is actually innocent. By focusing instead on principles of fairness, integrity, and public reputation, the court recognized a broader category of errors that warrant correction on plain error review. Like the miscarriage of justice rule that the court rejected in Olano, the Fifth Circuit's standard is unduly restrictive. To be sure, a conclusion that an error, quote, shocks the conscience of the common man, serves as a powerful indictment against our system of justice, or seriously calls into question the competence or integrity of the district judge, end quote, would demand an exercise of discretion to correct the error. Limiting relief only to those circumstances, however, too narrowly confines the extent of a court of appeals discretion. The, quote, shock the conscience, end quote, standard typically is employed when determining whether governmental action violates due process rights under the Fifth and 14th Amendments. This court has said that the shock the conscience standard is satisfied where the conduct was, quote, intended to injure in some way unjustifiable by any government interest, end quote, or in some circumstances if it resulted from deliberate indifference. That standard is not reflected in Rule 52b itself, nor in how this court has applied the plain error doctrine. The court repeatedly has reversed judgments for plain error on the basis of inadvertent or unintentional errors of the court or the parties below. The court also routinely remands cases involving inadvertent or unintentional errors, including sentencing errors, for consideration of Olano's fourth prong with the understanding that such errors may qualify for relief. The Fifth Circuit's additional focus on errors that, quote, serve as a powerful indictment against our system of justice, or seriously call into question the competence or integrity of the district judge, end quote, similarly alters the Rule 52b standard. The court has never said that errors must amount to a, quote, powerful indictment, end quote, of the system, a phrase which implies by its terms that the only errors worthy of correction are those that rise to the level of grossly serious misconduct. Similarly, the Fifth Circuit's emphasis on the, quote, competence or integrity of the district judge, end quote, narrows Olano's instruction that an error should be corrected if it seriously affects, quote, judicial proceedings, end quote. In articulating such a high standard, the Fifth Circuit substantially changed Olano's fourth prong. B. The effect of the Fifth Circuit's heightened standard is especially pronounced in a case like this one. A plain guidelines error that affects a defendant's substantial rights is precisely the type of error that ordinarily warrants relief under Rule 52b. In Molino-Martinez, the court recognized that, quote, when a defendant is sentenced under an incorrect guidelines range, whether or not the defendant's ultimate sentence falls within the correct range, the error itself can and most often will be sufficient to show a reasonable probability of a different outcome absent the error, end quote. In other words, an error resulting in a higher range than the guidelines provide usually establishes a reasonable probability that a defendant will serve a prison sentence that is more than necessary to fulfill the purposes of incarceration. Quote, to a prisoner, end quote, this prospect of additional, quote, time behind bars is not some theoretical or mathematical concept, end quote, Barber v. Thomas. Quote, any amount of actual jail time, end quote, is significant, Glover v. United States, and, quote, has exceptionally severe consequences for the incarcerated individual and for society which bears the direct and indirect cost of incarceration, end quote, United States v. Jenkins. The possibility of additional jail time thus warrants serious consideration in a determination whether to exercise discretion under Rule 52b. It is crucial in maintaining public perception of fairness and integrity in the justice system that courts exhibit regard for fundamental rights and respect for prisoners as people. The risk of unnecessary deprivation of liberty particularly undermines the fairness, integrity, or public reputation of judicial proceedings in the context of a plain guidelines error, because of the role the district court plays in calculating the range and the relative ease of correcting the error. Unlike, quote, cases where trial strategies in retrospect might be criticized for leading to harsher sentence, end quote, guidelines miscalculations ultimately result from judicial error. Glover, see also Pugh. That was especially so here where the district court's error in imposing Rosales-Mireles' sentence was based on a mistake made in the pre-sentence investigation report by the probation office, which works on behalf of the district court. Moreover, quote, a remand for resentencing, while not costless, does not invoke the same difficulties as a remand for retrial does, end quote, Molina-Martinez. Quote, a resentencing is a brief event, normally taking less than a day and requiring the attendance of only the defendant, counsel, and court personnel, end quote, United States v. Williams. Ensuring the accuracy of guidelines determinations also serves the purpose of, quote, providing certainty and fairness in sentencing, end quote, on a greater scale. The guidelines assist federal courts across the country in achieving uniformity and proportionality in sentencing. To realize those goals, it is important that sentencing proceedings actually reflect the nature of the offense and criminal history of the defendant, because the United States Sentencing Commission relies on data developed during sentencing proceedings, including information in the pre-sentence investigation report, to determine whether revisions to the guidelines are necessary. When sentences based on incorrect guidelines ranges go uncorrected, the Commission's ability to make appropriate amendments is undermined. Footnote 2. In broad strokes, the public legitimacy of our justice system relies on procedures that are, quote, neutral, accurate, consistent, trustworthy, and fair, end quote, and that, quote, provide opportunities for error correction, end quote. Bowers and Robinson's Perceptions of Fairness and Justice. In considering claims like Rosales-Mireles', then, quote, what reasonable citizen wouldn't bear a rightly diminished view of the judicial process and its integrity if courts refused to correct obvious errors of their own devise that threaten to require individuals to linger longer in federal prisons than the law demands, end quote. United States v. Sabian Umana. In the context of a plain guidelines error that affects substantial rights, that diminished view of the proceedings ordinarily will satisfy Olano's fourth prong as it does in this case. Footnote. The dissent maintains that adhering to procedure does not have prime importance for purposes of the fourth prong, because the court has held in some instances where the error was not likely to have affected the substantive outcome, that the procedural error alone did not satisfy Olano's fourth prong. Post at 7, citing Johnson v. United States v. Cotton, United States v. Marcus. The cases on which the dissent relies do not stand for the view, however, that procedural errors are unimportant or could never satisfy Olano's fourth prong, especially where, as here, the defendant has shown a likelihood that the error affected the substantive outcome. As the Fifth Circuit itself concluded, there is a reasonable probability that, without correction of the guidelines error, Rosales-Mireles will spend more time in prison than the district court otherwise would have considered necessary. That error was based on a mistake by the probation office, a mistake that can be remedied through a relatively inexpensive resentencing proceeding. Of course, any exercise of discretion at the fourth prong of Olano inherently requires, quote, a case-specific and fact-intensive, end quote, inquiry, Puckett v. United States. There may be instances where countervailing factors satisfy the Court of Appeals that the fairness, integrity, and public reputation of the proceedings will be preserved absent correction. But on the facts of this case, there are no such factors. Footnote. As the dissent points out, a defendant bears the burden to persuade the court that the error seriously affected the fairness, integrity, or public reputation of judicial proceedings. United States v. Vaughn. In the ordinary case, proof of a plain guidelines error that affects the defendant's substantive rights is sufficient to meet that burden. 3. The United States and the dissent agree with Rosales-Mireles that the Fifth Circuit's formulation of the standard for the exercise of discretion under Rule 52b, quote, is an inaccurate description, end quote, of Olano's fourth prong. They nevertheless maintain that Rosales-Mireles is not entitled to relief. We are unpersuaded, though a few points merit brief discussion. First, the United States and the dissent caution that a grant of relief in Rosales-Mireles' case, and in others like his, would be inconsistent with the court's statements that discretion under Rule 52b should be exercised sparingly and reserved for exceptional circumstances. As an initial matter, Jones and the cases it relies on for the point that discretion should be exercised sparingly would have required additional jury proceedings on remand either at resentencing or retrial. As we have explained, a decision remanding a case to the district court for resentencing on the basis of a guidelines miscalculation is far less burdensome than a retrial or other jury proceedings, and thus does not demand such a high degree of caution. In any event, the circumstances surrounding Rosales-Mireles' case are exceptional within the meaning of the court's precedent on plain error review, as they are reasonably likely to have resulted in a longer prison sentence than necessary, and there are no countervailing factors that otherwise further the fairness, integrity, or public reputation of judicial proceedings. The fact that, as a result of the court's holding, most defendants in Rosales-Mireles' situation will be eligible for relief under Rule 52b does not justify a decision that ignores the harmful effects of allowing the error to persist. Second, the United States and the dissent assert that, because Rosales-Mireles' sentence falls within the corrected guidelines range, the sentence is presumptively reasonable and, quote, less likely to indicate a serious injury to the fairness, integrity, or public reputation of judicial proceedings, end quote. A substantive reasonableness determination, however, is an entirely separate inquiry from whether an error warrants correction under plain error review. Before a court of appeals can consider the substantive reasonableness of a sentence, quote, it must first ensure that the district court committed no significant procedural error, such as failing to calculate, or improperly calculating, the guidelines range, end quote. Gall. This makes eminent sense, for the district court is charged in the first instance with determining whether, taking all sentencing factors into consideration, including the correct guidelines range, a sentence is, quote, sufficient but not greater than necessary, end quote, Title 18 of the U.S. Code. If the district court is unable properly to undertake that inquiry because of an error in the guidelines range, the result sentence no longer bears the reliability that would support a, quote, presumption of reasonableness, end quote, on review. Likewise, regardless of its ultimate reasonableness, a sentence that lacks reliability because of unjust procedures may well undermine public perception of the proceedings. The mere fact that Rosales-Mireles' sentence falls within the corrected guidelines range does not preserve the fairness, integrity, or public reputation of the proceedings. Footnote: the dissent's discussion of Rosales-Mireles' criminal history misses the point. That history is relevant to the district court's determination of an appropriate sentence under Title 18 of the U.S. Code. It does not help explain whether the plain procedural error in Rosales-Mireles' sentencing proceedings, which may have resulted in a longer sentence than is justified in light of that history, seriously affects the fairness, integrity, or public reputation of judicial proceedings. Third, the United States and the dissent contend that our decision, quote, creates the very opportunity for sandbagging that Rule 52B is supposed to prevent, end quote. Post. But that concern fails to account for the realities at play in sentencing proceedings. As this court repeatedly has explained, quote, the guidelines are the starting point for every sentencing calculation in the federal system, end quote. Hughes v. United States. It is hard to imagine that defense counsel would, quote, deliberately forego objection now, end quote, to a plain guidelines error that would subject her client to a higher guidelines range, quote, because counsel perceives some slightly expanded chance to argue for plain error later, end quote, Henderson v. United States. Even setting aside the conflict such a strategy would create with defense counsel's ethical obligations to represent her client vigorously and her duty of candor toward the court, any benefit from such a strategy is highly speculative. There is no guarantee that a court of appeals would agree to a remand, and no basis to believe that a district court would impose a lower sentence upon resentencing than the court would have imposed at the original sentencing proceedings had it been aware of the plain guidelines error. 4. For the foregoing reasons, we conclude that the Fifth Circuit abused its discretion in applying an unduly burdensome articulation of Olano's fourth prong, and declining to remand Rosales-Mireles' case for resentencing. In the ordinary case, as here, the failure to correct a plain guidelines error that affects a defendant's substantial rights will seriously affect the fairness, integrity, and public reputation of judicial proceedings. The judgment of the Court of Appeals is therefore reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Footnote 2. Similarly, the work of the Federal Bureau of Prisons is hindered by uncorrected guidelines errors, because the Bureau relies, in part, on aspects of the guidelines calculation in designating and classifying prisoners based on security and program needs. See Federal Bureau of Prisons Program Statement Number P5100.08. Subject, Inmate Security Designation and Custody Classification, Chapter 2, page 1, Chapter 4, page 8, Chapter 6, page 5. End of Section 28. Recording by Gretchen LaBuhn, Columbus. End of a collection of Supreme Court opinions by the United States Supreme Court.